matter actually, the last occasion my learned friend had said that this matter is, it will come under res judica. I have confirmed, yes, earlier, same matter was, case was filed before this honorable. I was not informed or I didn't know about it. Therefore, your lordship, I have seen the order, so it's correct. So I would like to withdraw this. There is no other option.
Acha, okay. Acha, heard Mr. Y.S. Mannan, learned counsel for the petitioner, and Miss
MD Bora.
M.D. Bora, learned
Standing Council Transport Department.
standing counsel for the transport department. Mr. Mannan submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as withdrawn.
Obliged.
Deeply obliged.
Hmm.
May I please look?
Hmm.
Get to mention for listing of a contempt matter, my lord. On
For listing,
listing, my lord, on the 3rd June, my lord.
My lord, item number 32 and 33, my lord. In 32, my lord,
yes.
I am appearing on behalf of person number 6, my lord.
Mr. Saikia is there for petitioner.
Yes, he's.
My lord, in fact, my lord, it was brought on by at my instance, my lord.
Hmm.
So, my lord, the connected matters is fixed on, my lord, 4th of June.
Hmm. Where Mr. P.K. Rai Chaudhary appears.
My lord,
Hmm.
as my friend has some difficulty today, my lord, let the matter be taken up on, my lord, 4th, my lord.
Yes, my lord, 4th June.
No, my lord, 8th June, my lord, 8th June, I'm sorry, my lord, 8th June.
8 June.
My lord.
Okay, Mr.
A. Hussain.
A. Hussain, appearing for respondent number 6, praised that the matter may be taken up on a later date, which is not objected to by Mr. Ayed Saikia, learned counsel appearing for petitioner. Prayer is allowed. List this matter when? After 8.
On 8th, my lord.
On 8.
On 8.
On
8th of June 2026. The other matter also goes likewise, sir.
No,
Fix this
But I
matter
have
on
an
8
additional
June.
prayer, my lord, for listing a petition, my lord, on Tuesday next. My lord.
Tuesday next. Hmm?
Similar. No.
Please speak to the court master. Yes.
May I please, your ladyship, with the consent of the other side, I beg to mention item number 36 of the daily list.
Hmm.
In this matter, your ladyship, the SSA authority was instructed to obtain instructions. However, we are awaiting the instructions, so further time may be granted.
Okay. Miss what
A.
Bhattakur?
A. Bhattakur.
A. Bhattakur, learned counsel for the learned standing counsel for.
No, appearing on behalf of P. Nayak, SSA.
Acha, learned counsel appearing on behalf of Mr. P. Nayak, learned standing counsel for SSC, submits that in the instance case, more instructions are required, and as such has prayed for some time. Prayer is allowed. List this matter when?
After 3 weeks, your
2
ladyship.
weeks, man. That 2 weeks, any day.
Acha, you are there, no?
1 day.
List this matter on 9th of June or 10th of June.
10th.
10th of June.
Highly
Yes.
obliged.
Yes, Mr.
Bring for listing of a matter on Tuesday.
Okay, speak to. Yes.
Lord, item number 35. If
35?
Yeah, man, that may be upgraded, my lord, regarding
Upgraded.
or at any time, my lord, because declaration of HSL class 12 result, my lord, my result has been withheld.
At 2?
Or at any time.
College matter, huh? That time not even 2000 matlo ho. Yes. Hmm. এটা লোর হেৰিটো বেয়াকে এইটো ভাঙি আছে দিয়ক ভাঙি আছে Yes, item 1, Mr. Das.
Yeah, his worship, madam. Worship, in this case,
Mm.
on 11/2/26,
Order
yes, I was filed, mother, and I was,
11/2/26.
yes, I was filed for impleading respondent number 8, mission director of the Service Shiksha Abhijan Assam. And
Ah.
it
Implement was
it
done.
was impleaded,
Mm.
but on that day, my lord, notice was issued against respondent number 8.
Mm.
Other respondents are remain left over.
Oh, left out.
Yes, so
Acha.
notice should go at all other 7 respondents.
Otherwise, Mr. A. Fukon appears for respondent number 1 to 5. So
Yes.
who else are required? 6, 7, 8. 6, 7.
It is,
6, 7 is the district program manager, midday. and 7 is headmaster. Somebody will appear or notices will go? Yes,
For
Mr.
six
Bora?
and eight, my lord, SSA, my lord.
6 is
Six, my lord, district program manager, my lord, SSA, my lord.
SSA.
SSA.
So Mr. Nayak can appear
Yes.
and 7 headmaster,
Notice to go. It is notice.
only 7 is left.
Well, yes, my lord.
1 to 5, Mr. Fukon appears. And he can appear, Mr.
Well,
Bora
I
will
can-
appear.
well,
Okay. Heard Mr.
Yes,
S.C.
it does.
Das, learned counsel for the petitioner, and Mr. Bora,
Bora, my lord.
MP,
PK Bora, my lord.
P.K. Bora,
For respondent number 1 to 5, my lord.
for respondent number 1 to 5.
My lord.
Um, and for respondent number 6, the standing counsel for SSA can appear.
My lord.
As such, Mr. Nayak is requested to appear in the instant case. As far as, no, as far as, for respondent number 8, the notices have already gone. Sir, 8 also appears. Somebody has filed. Notices have gone and the same is complete as per the office note. However, to respondent number 7, issue notice, returnable by 3 weeks. Petitioner to take steps for service of notice upon respondent number 7 by speed post with AD or by any usual process. Lest this matter on,
My lord, in respect of 1 to 5, extra copies have to be,
oh yes, extra copies were already
no,
ordered,
not ordered, my lord.
not ordered.
Yes.
Acha, acha. There's an order on 9/1/2026
Yes.
where he appears. Okay, extra copies to be furnished to the respondents by the learned counsel for the petitioner. List this matter on 17th of June.
My lord, in respondent number 6, my lord, in response to respondent 6, my notice may go to. Here, my lord, only thing is that district program manager, midday meal, PM person, Nalbari Assam, my lord.
So SSA will not appear.
May not, my lord.
আচ্ছা তেতিয়া সেইটো কাটি দিয়া মিষ্টাৰ নায়াক এণ্ড অল ডেট 7ৰ কথাখিনি কাটি দিয়া 7 নহয় 8ৰ নহয় 6ৰ তাত যে দিলোঁ 8ৰ লগত লগাই দিয়ে 7ৰ লগত 6 লগাই দিয়ে they take steps for service of notice, okay? 6 and 7 together. Yes, Mr. Hajrika?
Yes, Doctor. The petitioner is the associate professor of the Department of
They are
Finish
required to
your-
file affidavits?
Notice not issued yet, my lord.
Notice
Notice
not
been
issued?
issued, Your Honor. And also the order impunity at page 24, Your Lordship. My 2 increments was being withheld, Your Lordship.
One
Because I was,
second. Ha.
Page 24. The speaking order passed by the Director of Higher Education, Your Lordship, the last para, Your Lordship.
Which page?
Page 24.
Page
Page
24.
24.
Yes.
Two
Hmm?
increments,
This is the impugn order?
that is the order.
Hmm?
That is the order impugned, Your Lordship.
Yes.
2 increments in his salary are to be withheld with cumulative effect under set proviso so and so, so and so. Because I was cleared,
Hmm.
some complaint was made that with the influence of alcohol, I
The disciplinary proceeding was initiated against you.
initiated,
Then?
the criminal case was there, I was cleared. I was not being charged, charge was being framed, I was discharged
Discharged.
from all charges. And he filed one representation that is from page 25
Hmm.
to 27. And Lordship may kindly come to page 26, Your Lordship.
Hmm.
He relied on one judgment of the apex court,
Hmm.
which is Union of India versus KV.
KV Janki Raman.
Yes. Only the 2 lines, the court held that an employee cannot be made to suffer on account of a criminal proceedings in which he is ultimately acquitted. He was acquitted. He
Hmm.
is not being
He is
charged.
discharged.
Discharged. There is a question, he raised some questions that once evidence has been discarded by one criminal court, that can be used in a different proceedings or not. That
Hmm.
question will be
Whether that can be used in different proceeding or not.
lost.
But
if
here-
Lordship allows,
Yes.
if Lordship
Now
allows,
that you are discharged in the
I
criminal,
am discharged.
and now you,
I'm continuing.
and your disciplinary proceeding is on.
No.
No, it's concluded. It's concluded.
It ended. With what punishment?
Punishment is a two,
Increments.
increments being
Were withheld.
withheld. Page 24.
So you have challenged this on the ground that since criminal case you are discharged, you are not entitled, you are not liable to be punished. Right? This is the ground.
That is his contention.
Let notice be issued.
Madam.
Block.
Okay. Heard Mr. R.P. Hazarika, learned counsel appearing for the petitioner, and also heard Mr.
As that's madam.
S. Das, learned standing counsel for
I-
higher education department.
I'll be appearing for 1, 2, and 3, madam.
In the instant case, the petitioner has challenged the impugn order dated
Page 24.
Page 24.
Page 24.
page 24, you said, right?
Is
Order dated 4th of 4/7/2025,
Yes, sir.
by which, in pursuant to the disciplinary proceeding initiated against him, 2 increments of his salary were ordered to be withheld with cumulative effect under the provisions of Rule 7(1), Roman 1 within bracket, of the Assam Service Discipline and Appeal Rules 1964. Issue notice. Returnable by 3 weeks. Mr. S. Das appears for
1, 2, and 3, madam.
respond number 1, 2, and 3. Governing body and principal, you have to take steps.
Madam.
As far as respond number 4 and 5 are concerned, petitioner to take steps for service of notice by speed post with AD or by usual process. Extra copies be furnished by the petitioner to the respondent authorities. List this matter on 19th of June. Will it be too late, Mr. Hazarika? 19th of June. Acha, here to
19th,
the first line to
Lordship,
on the facts of the case there. Tata likhe
Lordship,
do
it is
the
for
petition
20. I'll be out of session on 19. On 20. 20.
on 20
20,
Saturday.
28.
20
20 of June.
28th of June is a Saturday.
21.
Well, it will be on working day, but let it be on 22nd.
Madam.
22nd.
Obliged law.
Tata likhe diya, the ground of challenge by the petitioner is that he having discharged in the criminal proceeding issued instituted against him for want of evidence, he is not liable to be punished in the disciplinary proceeding. Okay, fix this matter on 22nd of June.
Obliged law.
Yes, Mr. Ahmed.
Yes.
Yes.
Instruction was sought for in this case, madam.
Mhm.
Instruction was sought for.
Yes, Mr. Pavitra Saikya.
Notice was not issued, madam.
Instruction received by him on the earlier occasion. You are there, Saikya?
Madam.
Why not complete an account regard to the manner in which proposal for allotment settlement of land was processed. So land was settled in favor of petitioner school
Not settled, madam.
Not
Process was,
settled,
madam, initiated.
initiated.
Madam.
So what is the stage of that?
Earlier, my lord, circle office settlement officer, he sent the proposal to the district authority. District authority, my lord, against, my lord, directed them to furnish it with the proper format, my lord.
To the circle officer, it was returned back.
My lord,
Then?
for his submission,
Ah,
my lord, that letter initiated on 8/5/2026, my lord.
acha. After that, nothing has
After that,
happened.
my lord, nothing has happened. My lord.
Madam, the lordship
My lord, may, in the meantime, my lord, may issue notice, my lord. In the meantime, we can proceed because there is an allegation by the other person
Mm.
that school is not located in that particular area where they are claiming settlement.
What is not located?
The school, my lord.
Acha.
On that identified, my lord, plot of land, school is not located. They have raised.
Where is the school now?
School is in a nearby area, my lord, but not in particular place, my lord, where they are seeking the settlement, my lord.
They want the area to be somewhere else.
my lord.
The
They
area
are
that is,
claiming that this particular proposal sent by this settlement officer, the school is located in this particular Dag or particular Dagman. But some person made a complaint that this is not a Dag where school is situated, my lord.
acha, it is not on the same Dag.
Not on the same Dag, my lord.
Even lordship, some other similar petition, they have filed. There is some complaint against them on the school lordship. Some NGO has been, my lord, that made a complaint.
That is
Only
six
because of that. my
Complaint against the school.
Lord,
against the school, my lord.
What kind of a complaint?
my lord, this is the one that there is a school lordship, some other school, government school also there. But they are, my lord, trying to, my lord, they establish a new school, my lord, that private school. Only because of that, my lord, government cannot be allowed to, my lord, allotted the land to the private school. Lord.
Within a specific radius, my lord. There may be 3 kilometers.
Acha, government cannot allot land to a private school, but they are a
They are
government
the
school.
private school.
No, no, private.
Private, not a my lord, government school.
You are a government school,
Answer is.
venture
They
school.
are-
Not the-
Okay, you bring the necessary full instructions.
Can we issue notice on, then we can, my lord,
Notice was not issued earlier.
It is not.
we can file our response.
Heard Mr.
Yes, sir.
H.R. Ahmed, learned counsel for the petitioner, and also heard Mr. P. Saikia, learned government advocate, as well as Mr.
They handy for lot to.
J. Handik
Four
for
and five lot to.
respond number 4 and 5, and you are also there? Ms. P. Das appears for respond number 1, 2, and 3.
I am appearing for my lord 6, 7, 8, my lord.
Acha, P. Saikia is for, it was a Dilo, government advocate representing 6, 7, 8.
6, 7.
By this application, the petitioner has prayed for a direction to the respondent authorities to allot / settle the land measuring 7 bighas, wide Dag number 8, under sheet number 150, Moza Eraligul, ERALIGWL, Wasteland Grant, Nilam Bazar Revenue Circle, District Shribhumi, Assam. In terms of the proposal made by the Assistant Settlement Officer Nilam Bazar in favor of the petitioner school. However, the learned counsel appearing for the respondent submits that there are complaints against the petitioner school and that it is also stated that the land allotted to, the land which is proposed to be allotted to the petitioner school is not within the said Dag number, where this school is already functioning. Issue notice to the respondents. All respondents are represented, right?
Represent.
All are.
1, 2, 3, P. Das appears. 4, Additional Chief Secretary Revenue.
Five, I appeal.
Acha. So Mr. Hendik for 4 and 5, 6, 7, 8.
I am appearing.
You are there. So, okay. Extra copies to be served upon the learned counsels for the respondents within 2 days from today. Issue notice returnable by Kikola, 3 weeks. 3 weeks. List this matter on
My lord, there is another writ petition, may be taken up along with that writ petition, my lord.
with similar cause of action.
My lord,
They are also seeking on that.
Acha.
Allotment.
so WPC 663/2026.
Acha, Mr. Saikia submits that there is an analogous writ petition which can be heard along with the present writ petition. And the number of the said analogous petition is
663/2026.
663 of 2021.
26.
26. Prayer is allowed. List both the matters together on 19th of June.
Madam.
19th of June.
Obliged.
Must.
Obliged.
Yes.
Special laws.
Ah.
Matter pertains to payment of area salary.
Petitioner may file an additional affidavit. You have filed an additional affidavit.
Because I had inadvertently, I missed out this one. joining letter. So
That you have annexed now.
Yes, yes, Your Lordship.
So what about affidavits by the other party?
Not yet, notice has not been issued.
Ms. Chutia?
Notice me.
Oh, notice not issued
Not yet, Your Lordship.
because adjournments were taken earlier. Okay, heard Mr.
My name is A. Narzari, Your Lordship.
A. Narjari, learned counsel for the petitioner, and Ms. S. Chutia for
Elementary division.
standing counsel for elementary education. What is this matter about?
Non-payment of area salary.
The learned counsel for the petitioner submits that the instant petition has been filed with the prayer for releasing the salary to the petitioner, area salary,
Yes,
for releasing the area salary to the petitioner in the light of an order dated 22/1/2019 passed by this honorable court in writ petition number 1728 of 2015, as well as the order passed by this court in writ appeal number 255 of 22. Issue notice, returnable by 3 weeks. Ms. Chutia, S. Chutia, appears for respondent number 1. No, 1 you are appearing or only 2? Education
My
Department?
lord, 1, 2, 3, 4. 4, my lord. 1, 2, 3.
1, 2, 3, and 4. For Accountant General? Who appears for Accountant General? Somebody used to appear.
R. Talukdar, my lord. R.K. Talukdar.
Mr. R.K. Talukdar appears for respondent number 5 and 6.
5 and 6.
5 and 6. Extra copies to be served upon the respondents within a period of 2 days from today. List this matter on 17th of June. Yes, Ms. Chaudhary?
Your Lordship,
Hmm.
the matter relates to non-payment of salaries for the period of maternity leave, my lord.
For the
My lord,
period of maternal leave.
Maternity leave, my lord. In fact, the leave was also not sanctioned, my lord.
Acha.
Leave was, she sought leave.
Acha, counter affidavit last time, H. Borua, oh, no, B. Gogoi took time.
My lord, now also I am praying for 2 weeks more time, my lord, to file our affidavit.
For
My lord,
further.
it's a mandatory right, my lord.
Notice the
right,
issue.
My lord, to get, my lord, full salary for.
What I have seen is that the government advocate do not file their affidavit on the first occasion. They will wait. They will wait for the second order and then they will file. What is this?
My lord, we will file.
You have been given so many, you have been given 2 weeks time.
Notice is not issued in this matter, Your Lordship.
But then parawise comments were received and only affidavit was supposed to be filed on the last occasion.
But the notice may go at this
He
stage.
has received a detailed parawise comments.
My lord,
B. Gogoi, Buddha Gogoi, right?
my lord,
He appears for SSA
SSA, my lord, SSA RMS.
and H. Borua appearing on behalf of B. Gogoi.
My lord.
Okay. So,
My lord,
who is
noted
appearing
the-
for whom?
Notice issued for my lord.
Heard Mr. S.B. Chaudhary, learned counsel for the petitioner,
Issue.
and Mr.
H. Borua, my lord.
H. Borua. You only made the prayer last time. H. Borua, learned counsel, appearing on behalf of B. Gogoi. B. Gogoi is learned standing counsel for SSA, and Miss P. Das for
1 to 5 and 6. secondary
learned
education.
counsel, learned standing counsel for secondary
Yes, sir.
education.
And for seven.
Acha, P. Saikya, you are there for
And for seven.
7, and Mr. P. Saikya for respondent number 7. Who else are left to be served? Chief Accounts Officer, R.K. Talukdar can appear,
Can it-
and Accountant General also R.K. Talukdar. Only principal.
it can be appeared.
SSA.
My lord,
Uh-huh.
3, 4, and 8, my lord, I am appearing.
Acha. So Mr. H. Borua, কি বুলি কলো? Heard Mr. Iman and Iman কলো ন? তাৰপিছত কোৱা, this instant petition is filed by the petitioner praying for releasing the area salary during the period of her maternity leave. Area salary during the period of her maternity leave.
ইয়াত লিখা আছে।
Acha. Leave was also not granted.
Yes, ma'am. Proper notice may go.
The petitioner has also prayed for considering her leave application dated 5/8/2024. Issue notice returnable by 3 weeks. Learned counsels appear for the official respondents as mentioned above. The petitioner, kono na? Huh? Sobore naam?
After 3 weeks, sir.
7 and 8. Mr. Borua for, you are for 3, 4 and 8, right?
My lord,
Huh?
3, 4 and 8.
3, 4 and 8, huh? Aru P does for
1, 2 and 5.
1, 2 and 5. And Mr. P Saikia for 7, 6 and 7. So 8 and 9? 8 you are appearing. 9 R.K. Talukdar. Mr. R.K. Talukdar for respondent number 9. Petitioner to take steps for service of notice upon respondent number 10
আর ISO by instruction অনুযায়ী
by speed post with AD or by usual process or taragot didiba extra copies to be served upon the learned counsels for the respondents. List this matter on 19th of June.
19. 19?
Similar, my lord, 5, 6 and 7.
5, 6 and
Better, your lordship.
same. Order will be same. Parties arrayed are also same.
Same, my lord.
Yes.
Arising issue is same.
Accountant General.
Yes, in 6 and 7, item 6 and 7.
5 also you can appear. R.K. Talukdar's name is already reflected in 5.
5 to লিখে
Okay. 6 and 7 of Tatu Eke Didba, huh?
5 to লিখে
Same order, right? Parties are same. I don't have to change.
Petitioners are different and respondents are same.
Petitioners also same cause of action.
Same
Area
cause
salary for
of
maternity
action.
period.
Same, my lord, maternity.
Same order, 6 and 7.
Alia.
Yes.
deeply obliged.
8, 9 and 10 are similar or what?
Similar.
Mm.
Instead of soft force, why my provincialization has not been done?
Provincialization not done.
Not done. My lord, district scrutiny committee recommended my name. Thereafter, the matter was placed before
State security, state
SLC.
scrutiny.
Then state scrutiny committee, then by the recommendation of SLC, it was sent to joint committee. Joint committee thought that there should be an independent authority who should examine our case. That was examined. Then independent committee also recommended my name. So as per procedure, everything is done,
Actually, it was not required
not
from
required.
state scrutiny committee. It will go to the government
Yes,
and the government will publish.
yes. But even then, they have done some other
Joint
works
committee,
also.
then individual committee.
Everything is done now, the government has to take a call.
It has not been done.
Not been done.
That was your recommendation for what period? Which time? What time?
But a very recent man,
So they will do, I think.
yes.
So, my lord, in this matter, my lord, notice has not been issued yet, my lord.
So
So
instruction
notice
was
may
sought
be
for.
issued. Yes, notice may be issued in the.
Notice
meantime,
not
may be
required
start-
perhaps because you see, last time, PDAS was supposed to get the instruction.
Yes, but instruction.
Miss
is not
Pidas?
yet received.
Instruction awaited, your lordship. Already communication has made, your lordship. Kindly grant us 2 weeks.
Earlier, D. Mushahari took time and she was granted
More to this suit.
for to get her instructions. Same department, D. Mushahari and you.
Same.
So see, 4 weeks time, 1 month time we had taken,
Date may be given, your lordship, will obtain instruction.
but no notice. Let the instruction come. Because everything is done, only that the government has
Provincialization
to.
matter, your lordship, notice may go at least, your lordship. Only 2 dates, your lordship, we are asking for your lordship instruction. So at this stage, your lordship. if
Notice not
formal-
required.
Formal notice may go, your lordship, then we are able to.
Notice
If
not
it-
required, right?
Not
Not
required,
not
only that
required.
instruction is required.
Only that instruction. This matter should not be kept for pending for
Yes,
long. So, okay, you bring the instructions. Okay, heard
this
Mr.
copy, yeah.
A. Bhattacharya, learned counsel for the petitioner, and Ms. P. Das, learned standing counsel for the Secondary Education Department. Miss P does. Miss P does. It is seen that the learned counsels for secondary education department had taken time twice to get the necessary instructions. But when the matter is called up today, the learned counsel submits that she is still awaiting the instructions and has prayed for 2 days time.
Your Lordship, next Monday.
Monday,
Your Lordship,
Monday.
next month.
Monday means today is Friday. Tomorrow is what? Tomorrow is a working day or what? Not a working day. So I'll fix it on Wednesday.
Yes, Your
Hmm?
Lordship.
Prays for a few days time to get the necessary instructions. As such, the prayer is allowed. List this matter on Wednesday is, it may be a working day. It will be rescheduled. But list this matter on 26th, Tuesday. 26th, huh? Only you have to bring the instruction. Everything is done. Why not the government
Earlier,
is issuing?
Shari is appearing, Your Lordship. On the last occasion, I just take this, Your Lordship.
Okay,
matter.
tell her to get the
So,
instruction.
Soft copy may be given, Your Lordship. In the meantime, I will obtain.
Okay, provide a soft copy to her.
Deeply obliged.
9 and 10 also.
9, 10, or 8, 9, 10, okay, huh? Yes.
Right.
12. Mr. R. Sharma. Yes, Miss Mushahare. In the earlier matter, yes, that provincialization, everything is done, I'm told.
I'll get the instruction.
You get the instructions.
yes.
And we are fixing it on Tuesday.
On Tuesday.
You get telephonic
Lordship,
instructions.
Lordship, I will.
Yes.
May I present?
Huh.
My lord, this impugn order dated 9/1/26 lordship,
Hmm.
page 32 lordship.
Page 32.
This petitioner is under suspension
Hmm.
and his suspension is extended for another 3 months.
3 months.
Lordship, at this
Because
stage,
disciplinary proceeding is not initiated.
not initiated.
That is why 3 months extension.
Lordship. Lordship, at this stage, let instruction be
Notice.
obtained, lordship.
Okay. This is the first suspension order or the second? Page 31?
9/1/26, page 32 lordships.
32.
Lordships. 32
9/1/26.
lordships.
Earlier was 22/9/25.
Lordships. Accordingly, the suspension order dated 22/9/25 issued against Sri Utpal Goswami, Junior
You have
Chief
challenged this extension order,
Lordships,
not the original suspension order.
not original. Second,
Because this will go in view of the fact that proceeding has not started.
not started,
That is why.
Lordship.
Okay. Heard Mr. R. Sharma, learned counsel for the petitioner. By this application, the petitioner has challenged the extension of the suspension order for another 3 months period by order dated 9/1/2026, issued by the Director Elementary Education Assam. On the ground that the said extension cannot be ordered in pursuant to the first suspension order, which was dated 22/9/2025. Issue notice, returnable by 3 weeks. Yes, elementary education, nobody is there for that. Miss Kaur, you are not for elementary, right? You are government advocate. So, Chutia? Yes, Miss S. Chutia appears for respondent number 1, 2, 3, 4, 5, 5. 1 to 5, I think.
Madam, our name is not shown, that is a man.
Yes. Block elementary education
My
officer,
lord,
you
my-
can appear. 1, 2, 3, 4, and 5, huh? Treasury officer, finance, Miss R.M. Borua, learned standing counsel, appears for respondent number 6. Extra copies may be furnished to the learned counsels for the respondents by the petitioner's counsel, by the petitioner within a period of 2 days from today. List this matter on 18th of June. The registry is directed to reflect the names reflect
Our
the
name is Sohan, madam.
nomenclature.
No, no, our name is Sohan, madam. This is my
Sohan?
mistake. Sohan, madam.
Elementary shown, nalage, registry nalage. Raise this matter on, what did I say? 18th of June.
Obliged.
Oh, government deputy assistant. Yes?
May I please, your lordship?
Hmm.
Lordship, petitioner before.
This is for motion.
Motion, madam.
Ah.
My lord, petitioner before your lordship, he has retired from his service in the month of May 2025
Hmm.
as a headmaster of, my lord, Railway High School, Romia, my lord.
Mm.
Thereafter, after 2 months, my lord, in the month of August, my lord, an order has been issued for releasing his provisional pension till the finalization of the his pensionary benefits, my lord. Thereafter, he till November, he has got his provisional pension, my lord. Thereafter, his provisional pension has been stopped. And
From
till-
November, it was stopped.
Stop, madam. And till now, he has not received his DCRG and other pensionary benefits. Only GPF amount and 6 months provisional pension has been received by him. That is my case.
Okay, we will examine.
My,
Okay, heard Mr.
as a result.
S. Hajorika, learned counsel for the petitioner. By this application, the petitioner has prayed for releasing his pensionary benefits since the day of his retirement, right?
Yes, ma'am.
Which was on during May 2025.
My,
Issue notice, returnable by 3 weeks. Miss D. Mushahare, learned counsel, learned standing counsel, appears for respondent number
1, 2, and 3. Your Lordship.
1, 2, and 3. Assistant Director of Audit, I think the Accountant General can.
Lordship.
Director of Pension,
In the government. Your Lordship.
ask for pension. And for Assistant Director of Audit, R.K. Talukdar.
Architect.
Mr. R.K. Talukdar appears for respondent number 4. And Miss S. Kumar, learned government advocate, appears for respondent number 5. Extra copies be served upon the respondents within a period of 2 days from today. This matter on 18th of June.
well,
18.
I'll serve the extra copy.
Extra copies.
My,
Same
no, my lord, this is regarding, my lord, promotion to the post of headmaster, my lord. What happened?
appointment to the post of headmaster.
Post of headmaster, my lord.
Selection.
Selection, my lord. Through, my lord, Rule 14 of 2018 rule, my lord, defines regarding the process of, my lord, the promotion of the, my lord, headmaster. My name has been, my lord, sent for the, my lord, promotion, but at the, my lord, document verification, my lord, it was, my lord, some objection was raised by the respondent authority, and my promotion has been withheld, my lord. At page 38, my lord, is the withheld order.
This is the district-wise
District-wise.
selection which
Yes,
is
my lord.
made.
Yes, my lord.
I am to inform you that a hearing date is fixed in, actually, that has to be preceded by an interview.
Yes, my lord. The process is that, my lord, district-wise seniority list, my lord, has been sent to the, my lord.
Seniority list together with 3 years
Yes,
ACS.
yes, my lord.
So that has been done.
Everything is done, my lord. My lord,
Interview board also set and it
yes, but at
interviewed
the
you.
time of document verification, my lord, it was, my lord, withheld because of, my lord, at page.
Acha, let me see 38 first, that a
30.
hearing date is fixed as mentioned below. In
Page
the
30.
Iman in connection with withheld candidates.
Yes, page,
Selection for regular master.
I am at serial number 13, my lord. Josna Das. Sankar
So
Thai.
these are withheld candidates. Okay, you are from which district?
I am from Kamrup. Rural.
Kamrup. So what do you want to show after this?
Thereafter, my lord,
No. I had seen only page 38.
yes, my lord, page 28, my lord. That is my
28.
regularization order, my lord. Page 28. My regularization.
Okay,
order.
as an assistant teacher, she was regularized.
Regularized, my lord.
But during document verification, your results were withheld.
Withheld, my lord. My appointment was done in 17/11/1993. This is my regular.
Okay, let notice be issued now. Let
my
notice
lord, the point is there in my regularization in the below, my lord.
You are praying for some interim.
Yes, my lord.
Hmm.
In pursuance, page 28, my lord. In pursuance of the order dated so is hereby regularized in her post with immediate effect.
Hmm.
although, my lord, the similarly incumbent, my lord, the in the page 30, my lord,
She was regularized to her post in
For-
2005.
2005 with immediate effect.
Mm.
But although the other incumbents are similarly, they are regularized from the date of their joining,
Acha.
from their date of joining,
That
and,
is 93.
93, my lord.
Mm.
But in my lord, regulation order, it was seems mentioned as a with immediate effect.
Mm.
So my seniority has come, my lord, below
Down.
the other incumbents.
Mm.
In my lord, our honorable, my lord, division bench has decided is this issue, my lord.
Mm.
I'm providing the judgment where it clearly says, my lord, the seniority must be count from the date of initial appointment, my lord. Providing the judgment, my lord. Because my
Even
appointment
if somebody
is
is
the year
huh.
1993, my lord. My appointment is the 1993, but my regularization is in the year 2005. So department has counted my seniority from the regularization of my order. Although the other incumbents regularization order it clearly mentioned as from the date of initial joining. Only because of this, my lord, error, my this promotion has been withheld, my lord, regarding this seniority issue.
My lord, in this process, my lord, verification is going on, my lord. And moreover, my lord, in page 38, annexus 7, my lord, here it is clearly stated that you are also requested to instruct the candidates concerned to bring all the necessary documents in original, along with one set of self-attested copy without fail.
Mm.
My lord, that
So,
is
my lord,
that is-
verification process is
As well
going-
as
that
what
is
he is
not
saying
already
is,
Same.
But that is already done, my lord. That is order is on 6/5/2026. My lord, verification already done. At the time of verification, this issue has been raised, my lord. That's why, my
he
lord.
said that all others were regularized from the date of joining, but in his case, it was with the immediate effect.
And,
That is
yes,
from-
mention is.
and that is why
mention
his
is-
seniority is affected.
Let
Yes,
me
my lord.
obtain the instruction, my lord.
In the records, right?
Mm.
Let me obtain the instruction, my lord, regarding that, my lord.
May I please place this judgment?
Whether it was an inadvertent mistake, immediate effect, it should have been from the date of joining.
Well, I have enclosed
my lord-
6 appointment orders, my regulation orders. All regulation
I've
orders is
seen.
clearly mentioned as the date of my lord joining.
What is the division bench judgment show me?
Well,
Even if somebody is regularized later, if he is appointed earlier, that will be the date. So doesn't Hare Krishna da? बहुत खांसी हो रही है. Which
yes,
paragraph?
para 17 is clearly, my lord, stated. Paragraph 17, my lord.
Hmm.
Issue has been taken under this paragraph on counting the period of ad hoc service of the.
Wait, paragraph 17.
17, my lord.
Huh. In the case of Narayan Rao
Yes, my lord.
and so and so.
And so, the Supreme Court of India, by following decision of Constitution bench, in case of direct recruitment class 2 engineering officer, Assam and State of Maharashtra reported and so, has held that where ad hoc appointment is made by the following procedure laid down by rules and the appointees continues in the post till his regularization, seniority must be counted from the date of initial joining.
Mm.
Here also, in my case, my lord, I have my service has been extended time to time. My lord, extension order also I have annexed, my
Mm.
lord. Since my service was not regularized at the initial time, my lord, it was extended time to time, my lord. My similar case, my lord, here.
Acha, what interim you want?
My lord, the post of my lord, one headmaster kept.
Should be kept vacant.
Yes, that is
Okay, heard, Mr.
S. Hazarika.
S. Hajurika, learned counsel for the petitioner. By this application, the petitioner has prayed for appointment. Where is the prayer? Appointment to the post of principal. Prayed
My lord,
for
headmaster, my lord.
oh,
Oh, headmaster.
appointment to the post of
Regular
to the
headmaster.
post of headmaster in pursuant to the selection made by the office of the elementary education department
My lord,
Secondary.
secondary.
or secondary education department. The learned counsel for the petitioner submits that the petitioner was appointed in the year 1993 and was continuing in the post of assistant teacher since then.
Well.
And her services was regularized by the order dated 28th of February 2005 and the said regularization was given effect immediately. That is from February 2005. However, the counsel for the petitioner submits that in case of other similarly situated assistant teachers, the regularization was made from the date of joining. After, during the selection process. Oh, no, no, regulation, okay. Due to the fact that the petitioner services was regularized with immediate effect, that is from the date of the order, her seniority was affected. And as such, during the selection process, the said impediment was noticed and selection to the an appointment of the petitioner to the post of the headmaster was could not be proceeded,
Yes.
and her results were withheld. And her result of her case was withheld.
Yes, was with them.
And her case was withheld. And by order dated 6/5/2026, the candidates the withheld candidates were there. The withheld candidates were called for a hearing in the office of the Director of Secondary Education, Assam, for selection to the Assam, full stop. Issue notice, returnable by 3 weeks. Mr.
U.
U. Sharma, learned counsel for the, learned standing counsel
For secondary education.
for secondary education appears for respondent number 2, 3 and 4. No,
2, 3.
1, 2, 3.
Yes, district elementary.
Miss Esquire is for elementary. No, Miss
Elementary.
you can. Miss Esquire, learned government advocate, appears for respondent number 4. Extra copies to be furnished.
Council Lordship.
Huh?
As a standing council, I can appear for respondent number 4.
Miss Esquire appears for respondent number 4. Extra copies to be served within a period of 2 days from today. Heard on the interim prayer.
My lord,
In the
before
above
considering
facts and
the interim, my lord, let me obtain the instruction regarding that, my
My
lord.
lord, we already hearing
Till
was-
next date, we will keep one seat vacant. If nothing is found against him, then okay. Heard on the interim prayer. In the facts and circumstances mentioned above, more so due to the fact that similarly situated assistant teachers, that services of similarly situated assistant teachers were regularized from the date of joining. This court thinks it fit to direct the authorities concerned to keep one post of regular headmaster in any school of the district, in any,
High school.
Some district, any district, because my lord, after promotion, she may be transferred to any of the, that's why.
to keep one vacant, to keep one post, to keep one post of regular headmaster vacant till the next date.
In Kamrup district, my lord.
In Kamrup district, vacant in the schools in Kamrup district.
I'm highly
In Nalaga school libo, in the Kamrup district.
I'm highly aware.
List this matter on, etu didia, etu ere didia. Etu diba libo. Ago diba, where his submissions are recorded. The learned counsel for the petitioner has placed the judgment of the Honorable Supreme, had placed the judgment of this court, passed in writ appeal number 101 of 2024, by order and by judgment and order dated 22/10/2024, by which the decision of the Supreme Court was, the decision of the Honorable Supreme Court was cited for the reason that the appointees, cited to bring home the point that, that when the appointees continues in the post till his regularization, seniority must be counted from the date of initial joining. Headline it level mother. Place this matter kolu. No, place this matter on 23rd of June.
23rd of.
You bring the instruction. 23rd of June is otherwise a long date. You just, Mr. Out of detail, Mr. U. Sharma
Yes.
is directed to place the instructions on the next date. List this matter on 16th of June. Yes, implement of parties, Mr. Bhuya.
My lord, what has happened, my lord? Regarding the issue disputes of a dice code of a school, my lord. Allegation is that, my lord, the dice code which we are claiming is not belong to the petitioner's institution. But, my lord, the online system which is maintained by the National University NUPA, Delhi, and as well as the Sarva Shiksha Abhijan Mission in the Directorate of Education also, at present also I have just checked. My lord, the online system, this dice code belongs to the petitioner's institution, my lord. Now, there is an order.
Why are they disputing?
My lord, it has been disputed by basing on a complaint, laws before the, my lord, additional, before the district commissioner, my lord, at page 49, my lord.
In the IA?
No, my lord, in the writ petition, my lord.
No, this is for impleading of the party.
My lord, the SSA is a necessary party. And so that's why, my lord, we could not implement in the main writ petition. We are now praying for the implement of the mission director and the, my lord, Sarva Shiksha Abhijan Mission as respondent number 8 and 9, my lord.
Okay.
My lord.
They're supposed to be the proper parties. Necessary.
My lord, because the DIAS data is maintained by the Sarva Shiksha Abhijan in our state, my lord. So they record.
And why have they disputed, you said?
Not the event disputed and the school is under lock and key, my lord. Forcefully they have sealed also. So that's why, my lord.
The school is not functioning.
School is not functioning. Around 240 numbers of students are now, my lord, debarring from imparting education. That's why there is an urgency, my lord. So when we prayed for an interim order, my lord, then, my lord, as these private respondents were
Learned counsel assisted by Mr. H. A. Talukdar, learned counsel for the petitioner, and Miss P. Das
I'm appearing for respondent 1 and 2
for respond number 1 and 2.
for secondary.
By this application, in IA likhiba, huh? By this application, the petitioner has prayed for impleadment of two respondents, impleadment of two parties as respondents,
number 8 and 9, my lord.
number 8 and 9. Learned counsel for the petitioner submits that during the hearing of the connected petition, wherein wherein the school was stated, wherein the school was stated to be not in the DIAS data.
It is their allegation, my lord.
It is stated that the school was not there in the DIAS data. And as such, what was the prayer in your writ?
My lord, to set aside, my lord, may be pleased to find at page 15, my lord. Page
Implement,
16,
right?
my lord, for passing and setting aside the impugn order of 28/4/2026.
No, this is okay. During the hearing of the, during the, during the connected, hearing of the connected writ petition, which was filed for quashing of the order dated 28/4/2026, by which it was held the Dias code used by the school is fake.
Mile.
And that the school is running illegally. During the hearing of the connected petition person, it was, it was felt that the Sarva Shiksha,
My lord, the party should be, my lord, the Samagra Shiksha
Uh,
Ashram.
where have, Samagra Shiksha Aham,
My lord, may I find it at page 7 of my IA, my lord, page 7.
yes, Samagra Shiksha Aham,
To be represented.
being the nodal implementing agency of the government of Assam for elementary education, who handles Dias code allotment, as well as, what is the other party?
My lord, the mission director should be the, my lord, respondent number 8 and Samagra Shiksha.
And
Ashram
the
is
mission
respondent
director
number 9.
and the district mission coordinator,
My lord, is the respondent number 9.
Nagaon within bracket SSA, are necessary parties
My lord.
and should be impleaded for the adjudication of the writ petition. In the facts of the case, it is considered that the said two parties may be impleaded as respondents. Accordingly, the instant I is allowed the petitioner to amend the cause title in the connected writ petition by filing the necessary application
Amended cost title, we will file it before the.
by filing the necessary application. I is disposed of.
My lord, may I pray for an, my lord, consideration of the interim prayer? My lord?
After impleadment, let the SSA come.
My lord. My lord,
List this matter.
then, my lord, there is an urgency. Can it be on Monday, my lord, coming Monday?
By Monday, whether this exercise can be done, you have to file an amended cost title.
Then Wednesday, my lord, coming.
Wednesday, perhaps it will be a working day.
No, my lord, I would not have pressed, my lord, because 240 numbers of student has been forcefully devoured, my lord.
Okay, Tuesday.
My lord, my lord.
By Tuesday, you have filed your amended
I
title.
have the need,
Because Wednesday might be a working day,
working day.
but we never know whether it will be declared as a working day or not. The notifications are not out.
That is it.
So Tuesday.
I'm appearing 4 and 5.
Koi diba, huh? So Gogoi, right? Born appearing for 4 and 5.
Oblige me.
List this matter on 26th.
14 and 15.
Yes, Mr. Gupta, 14 and 15 together.
I am appearing in item number 14, madam.
15,
15 I am not appearing, madam.
Al Mohan. He is appointed as a public prosecutor.
Yes, ma'am.
J.I. Bormia will be there. Okay, whether pleadings are complete here?
In the second case, my lord, we have filed our affidavit in opposition.
You will.
We have filed already.
Oh, we have
It is
filed.
filed, my lord. For the second case, we are ready, man.
In the first case also, someone has filed, but the respondent number is not shown.
Filed, madam.
Respondent number 1.
One, madam.
One is who?
One is my lord director,
Director of Elementary.
secretary, madam.
Secretary.
Commission secretary, madam.
So in item number 1, you will file your affidavit, Mr. or that affidavit will do.
My lord, I think I'll get my instructions on that, my lord. Because it's an old matter, my lord. 50.
Hmm.
So that's why I have to get.
It's an old matter. This is of 2015.
Yes, my lord. It's an analogous.
Stop for hearing today.
My lord, the first case, my lord, I would like to get my instruction obtained because regarding that, if I need I might need instructions.
No further adjournment shall be granted in the matter. It's in the order.
He had taken time, man.
Whatever it is, no further adjournment.
Fine, my lord. My lord will. The
See,
second,
this is such an old matter. Let me look into it and whether your response is
second
required.
case, I think second case too is we can
Ready.
prepared. I'm ready, man.
Second case is, look, second case
But they
counsel
are,
is not there.
but they're connected, my lord. They're connected.
Counsel is not there.
That is the problem. Because they're analogous matters, they're supposed to be taken up together.
Inform Mr. Borvia. Okay,
Your
or
lordship
what?
can fix a
You
date.
have some other prayer?
No, my lord, if lordship may visit, then I am ready, my lord.
Otherwise, such an old matter, more than 10 years have elapsed. I don't know what is the stage of your
Lord,
prayer now.
my lord,
Any interim order?
No interim, madam. My lord, matter relates to non-payment of salary, my lord. What happened, my lord? They were appointed in the year 1989. 92, their services were terminated. They have approached this honorable court. The termination orders were set aside, my lord. Thereafter, they continue till September 2003. Salaries were paid, my lord. And out of, my lord, here 9 petitioners, 4 services were regularized. 5 to 9 services were, although not regularized, they are continuing, my lord. From October 2003, their services were not paid, my lord. They have approached this on the
Their salaries were not paid
not paid, my
from
lord.
2003.
My lord.
But they were appointed by the High Court's order.
Not by the High Court order, my lord. Initially, there was some interview in the year 1986. So after that, my lord, 89 they were appointed, man, by the government, man. So since 2003, they are continuing. They have approached this honorable court earlier also. This honorable court directed the authorities to look into the matter and, my lord, passed the order. In the meantime, my lord, in the year 2015, one so-called notice was issued by saying that since they were terminated in the year 1992 and they were continuing in service, so therefore their appointments are illegal and void ab initio, my lord. And they are directed to submit their reply. This petitioner has submitted their reply. At this stage, this petitioner has approached this honorable court. And in the year, my lord, 2020, in the last part of 2020, my lord, out of here, 9 petitioners, 8 were offered, my lord, as a tutor. So out of that, my lord, 7 have joined, 2 have not joined, and arrest petitioner number 9 is, my lord, not
But
offered.
there are so many facts here.
So many facts are
Lordship,
there.
one more thing, there are a lot of facts here, my lord, and lordship will take up the second case. There, the affidavit will speak for itself, my lord. Page 69, there was a, my lord, order passed by, my lord, WPC number 104 of 2004. There, my lord, in compliance, my lord, order dated 23/2010. There, my lord, a screening committee was made, and my lord, all districts, my lord, and then, my lord, they were when the divisional screening committees were made, then verifying the applications, my lord. So when the applications were verified, 4 categories were made, my lord. The first category was recommended and working till date. There were 136 candidates. Because that time many irregular people were appointed because of that, my lord. Second category was recommended but discontinued. And those were 250. Out of then, my lord, there were third category which was not recommended but working till date. That was 8,470. And then fourth category was not recommended and discontinued. That is 2,900. Now, my lord, in the second case, here also I will say, in the second case, my lord, there were 11
Okay,
petitions.
then we will hear it some other day.
Exactly,
Mr.
ma'am.
Barvia should be
Full
should be informed because second case is ready. Counsel is not there.
Yes, ma'am.
First case they held to
This
file.
also same argument, my lord. This also same
So
argument.
that affidavit will cover this also.
Exactly.
They did not file.
And here, my lord, here also, my lord, I would just obtain instructions because here also, my lord, as per the some of the petitioners in his case have also been accommodated as tutors. In that particular case, my lord, there has been a this thing that if they take the tutorship, then they cannot claim the area salary. So they have participated in the screening committee and then they have accepted the tutorship. And after that, my lord, after taking the job, my lord, they are now again filing cases, my lord. So they cannot have the cake and the icing also. So that is the case, my lord. And my lord, there are coordinate bench judgments over here, which I will produce in the next date, my lord. Today, I don't want to show my cards, my lord. I will show on the next date, wherein the honorable court has said that, my lord, the people who have been appointed, they cannot ask for area salary because they have come under contract, they have
Yes,
signed
yes.
and everything.
Of course,
So
they
a
can.
lot of facts are there. ma'am.
Let's see what
Yes,
we
ma'am.
can.
Yes, ma'am.
Okay, in item number 14, you write, heard Mr. A.K. Gupta, learned counsel for petitioner, and Mr. A. Fukan, learned standing counsel for elementary education. Mr. Fukan submits that he will receive certain instructions in the matter and has prayed for some time. Prayer is allowed. Since the matter pertains to the year 2015, the case is fixed on 9th of June.
Yeah.
Okay? 9th of June for final disposal.
Yes, ma'am.
In the next matter, you write, none appears for the petitioner on call. Mr. A. Fukan, learned standing counsel for elementary education, however, submits that affidavit has been filed in the instant case. Place this matter on 9th of June.
Deeply obliged.
Both the matters will come up on 9th.
My lord.
Item 16. Yes, 16, Mr. Mia.
My lord, this is a matter filed.
Mediation report,
20
mediation failed.
My lord,
Mediation failed.
mediation failed, my lord, because my lord, this is not a case for mediation. We have prayed for, my lord, regularization of my suspension period, my lord.
Hmm.
Then, my lord, my salary has
Hmm.
not been fixed as per the revision of pay rules updated, my lord.
Hmm.
That has not been done.
So affidavits filed.
No, my lord, 2020 meter, perhaps, my lord, they are not going to file, my lord.
So Mr. PP Datta, ready?
Lordship, the school is placed at the disposal of Director of Elementary Education.
Hmm.
So the Director of Elementary Education will take care of it, Lordship. Now.
In this matter, the director of, the elementary education is not made a party in this case.
Not made.
Your lordship sees the cause list, it's
Hmm.
secondary education. So I think, my lord, they have to file an implement petition, the petitioner.
16.
The new notification. by the-
Secondary education is shown, but what
Yes,
about
but-
the respondents here?
My lord, when this petition was filed, my lord, one
Ah.
of the facts is like that, when this petition was filed, this entire madrasa education system was under the, my lord, Directorate of Secondary Education.
Hmm.
Now subsequently, my lord, they have bifurcated the elementary level to the elementary and the secondary is with the secondary. My lord.
Hmm.
Now here is a case, my lord, they have said that this is an elementary level education, but my instruction is that, my lord, this school has already been amalgamated with the secondary level institution. So ultimately, my lord, it will be governed by the Directorate of Secondary Education, my lord.
Hmm.
So it is their policy, my lord, by which the amalgamation exercise is
Mr.
going on.
Datta, you are for
Lordship,
secondary.
I have yes, I am for secondary. That is instruction, Lordship, I am sharing.
Hmm.
That I have no objection.
Jason, Eri, Mr. Argisunda, which instruction line? What is this instruction? Let me know.
It will be given.
Yeah, but what is the prayer, Mr. Bhuya
My lord,
here?
my prayer is very limited, my lord. My suspension period
Oh, acha, that has to be regularized.
is regularized. Then my salary, my lord, even the current salary has now been stopped. Today morning, my lord, the
Hmm.
petitioner, I have been instructed, my lord, he is not getting his regular current salary also, my lord. Very pathetic condition, my lord.
Acha, he was a regular
He
employee.
was, my lord, pursuant to the division bench, honorable division bench order, my lord, his service had been provincialized.
Hmm.
Thereafter, my lord, I am getting the salary. Then subsequently, I had been placed under suspension. Then again reinstated, my lord. And then I am getting the salary. But the problem is that, my lord, my counting of the salary as per the revision of pay rules was required to be done. That has not been done till date. So that's why, my lord, I am getting the salary much lesser to my, my lord, entitlement as per the rules.
Hmm. I have the honor to forward herewith another copy of so and so. It is said that it is presently serving in Fingua Iman. By government notification dated. Why has shifted the administrative power of the authorized police in the Madrasa. Now Acha, acha. Now it is being sent to the Directorate of Elementary Education.
Any relief if is getting from the Director of Elementary.
So you have to again file an impleading application.
My lord, that
I don't know what is the reason. It is they have referred to some High Court decision. Israfil,
roughly, my lord.
you are serving in Fingua Anchalik ME School.
My lord, what has
Erstwhile
happened?
it was madrasa.
My lord, what has happened originally, my lord, this 439/2020 reference is given, this is the case, my lord,
Hmm.
which we are, my lord, proceeding with.
Hmm.
My lord, this institution was originally a, my lord, pre-senior madrasa.
Pre-senior madrasa.
Pre-senior madrasa. Later on, my lord, this has been transformed into an ME madrasa, my lord, equivalent. Now, thereafter, my lord, it had been again amalgamated with some high schools nearby, my lord. Now, with the which high school it had been amalgamated, that I am not sure, my lord. So, therefore, my lord, if it is amalgamated with high school, then it can be taken care of by the director
Secondary.
secondary. Or if not amalgamated, then, my lord, definitely I have to implement the director elementary.
So you
my lord,
take the instruction whether it was amalgamated.
after a week, my lord, in the meantime, I will do the needful, my lord.
Okay. Because this will not be will not clinch the issue.
Not, my lord.
You bring the instruction.
My lord.
Heard Mr. A.R. Bhuya, learned senior counsel assisted by Miss N. Hussain. And I always forget her name, S. Loskor, learned counsel for the petitioner, and Mr. P.P. Datta, learned standing counsel for secondary education. Mr. P.P. Datta has placed one instruction which states that the school where the petitioner is presently serving is transformed to a general school by the name of Fingua Ancholik ME School, and that the said school has been shifted under the jurisdiction of Directorate of Elementary Education, Assam. However, Mr. Bhuya submits that he has information that the instant school has been amalgamated with her secondary school, right? With her secondary school. It was amalgamated with a secondary school.
Secondary school, my lord, but the correct name I don't have today, my
but
lord. I
how-
will take the
but-
updated.
He has no proper instruction as to the name of the said school and the status.
Fine.
Accordingly, he prays for some time to get the required instruction. Since he submits that if it is amalgamated with a secondary school, then the Directorate of Secondary Education
Fine.
will have the jurisdiction. Prayer is allowed. List this matter on when?
16th of June, my lord.
16th of June,
My lord.
2026.
My lord. Oblige, my lord. Deep praise.
Mr. Sakya, yes. Affidavits are exchanged.
My lord. Affidavit has been filed, my lord. I have also filed reply, my lord.
You will file reply.
My lord.
Okay. Mr. Ayat Sakya, learned counsel for the petitioner, prays for some time to file reply today.
I have filed.
Oh, you have filed.
I'm ready for.
I heard that you will file. Acha, Mr. Sakya, you have filed your affidavit and he has filed his reply. Any more affidavits required?
No, my lord, department has filed, my lord.
Huh?
Education department filed affidavit against that he made reply.
So any more affidavit required by other parties?
No, my lord.
No. So it can be heard finally?
My lord.
Okay. Mr. Sakya?
My
My
lord.
lord.
Okay. In between, you don't come up with the idea we will file something more. Right?
My lord.
My lord.
Okay. You say no. He is also confused. Yes, Mr. Sakya? I can hear?
My lord.
Oh, both of you are Sakyas.
Both of-
Okay. Then, yes, what is the matter about?
My lord, the petitioner who lordship is the my lord widow whose husband was selected, my lord, as ME school teacher.
Hmm.
By selectly.
Petitioner's husband. Yes, okay. Only. Oh, take it. Okay.
Right.
These are your citations.
My lord,
Okay.
by selectly stated 13/11/1999.
Petitioner's husband.
My lord,
He died.
he died.
Hmm.
He was selected on 13/11/1999
Huh.
and he was appointed on 3/12/1999.
Um,
Teacher in ME.
Appointment as assistant teacher.
My lord.
Huh. Where is his appointment order?
Appointment order lodged will find at page 12 first.
Hmm. Yes. Thiren Deka.
My lord,
So it was in 99.
99.
Hmm.
He joined on my lord 6/12/99. That will lodged will find at page 14.
Hmm.
joining
Yes.
report.
Hmm. He joined on
6/12/99, my lord.
6/12, yes.
My lord.
Vernacular. Hmm. So after 3 days.
After 3 days.
Hmm.
My lord, during this period, though he was working, my lord, his salary was not paid,
Not paid from 99.
99. So, my lord, the undersecretary to the government of Assam in Education Department on 21/12/2000 directed the DEO Borpeta to release the salary. That is at page 16, my lord.
Hmm. 58 numbers of teachers. Petitioner was one of them.
Petitioner was one of them.
Hmm.
So, my lord, there's a direction to pay the salaries, but the headmaster of the school,
Hmm.
he also certified on 6/8/2003
Hmm.
that the petitioner was, the husband of the petitioner was working on regular basis. That is at page 18, my lord.
Hmm.
There's a certificate issued by the headmaster of the school. I'm sorry, well, page 19.
Hmm. After appointment, why the salaries are not paid?
My
Then?
lord, what happened, my lord, at that point of time, the post were, my lord, on two categories, my lord. Some posts were, my lord, non-planned post. Non-planned post, my lord, does not require any retention. And the planned post, my lord, those were, my lord, require annual retention.
Hmm.
What happened, my lord, at the time of his appointment, though the post was there, because, my lord, it was against transferred vacancy, he was appointed. So though the post was there, subsequently, my lord, it was not retained.
Hmm.
It was
Non-planned.
Not retained. It was.
Hmm. It was a planned post.
It was not retained, for which, my lord, his salary could not be paid.
Hmm.
That is the, my lord, contention of the.
But then there are so many whose salaries were not paid. According to the directors, according to the secretary's letter, 58 numbers of ME school teachers. Same case with others also.
Fine.
Then?
Then, my lord, petitioner, my lord, he approached this honorable court
Hmm.
by filing a writ petition, that is 6246/2003.
Hmm. Where is that?
My lord, the interim order has not been annexed in this writ petition, my lord.
Hmm.
It has a reference at page 22, my lord.
Hmm. Yes.
This is a letter, my lord, to the
DEO.
Director of Elementary Education from the DEO at page 22.
Hmm.
My lord, for,
Yes.
as a result, the petitioners filed the case before the Honorable High Court for getting salaries, and the Honorable High Court, by WPC number so and so, directed to release the current salaries to the petitioners on 12/8/2003.
Hmm.
Further, on personal appearance of the undersigned on 16/9/2005 against Miss case number so and so,
Personal appearance of the undersigned, that is
Under the
this
D-
DEO. Hmm.
personally appeared, my lord. Court directed to adjust the petitioners against regular vacancies lying in the district,
Hmm. This
Before-
personal appearance was before the court.
my lord.
Hmm.
He was called on,
So adjust the petitioners against regular vacancies lying in the district before so and so, and accordingly an order was passed.
my lord. Thereafter, my lord, the husband of the petitioner was appointed,
No, this order was adjust the petitioners against regular vacancies, but they were working against regular vacancies only.
my lord, the post was not retained.
Retained.
Post was not retained, for which, my lord, it became, my lord, irregular.
So they were directed to be retained rather in
Fine.
regular vacancies and to release the salary.
My lord.
Hmm. Then?
Thereafter, my lord, by order at page 28,
Hmm.
he was appointed again against a different school.
Hmm.
He's at serial number 4, my lord, Thirendaka, Mahasara MP School.
Hmm.
due to
Where?
Page 28, my lord.
28 is the first page of the judgment.
Annexure H, my lord.
This is I.
Page 27, my lord, page 27.
27.
My lord.
Wait, ouch.
Annexure H, my lord.
Page 27, yes, order.
Or
9th of June
9th
2006.
of June 2006.
Hmm.
The petitioner is, husband of the petitioner is at serial number 4.
Thirendeka.
My lord. He was appointed at Mahasara MB School
Hmm.
due to transfer of on Hitesh Talukdar.
Hmm. On the first day itself, this was done. On a transferred vacant post, he was appointed.
Initially also, my lord, he was appointed against transfer vacant post.
Hmm.
That post was not retained, for which, my lord, he was again appointed
Hmm.
by this order, my lord.
Oh,
at page
acha.
27.
This is
And-
for the second time.
My lord.
Hmm.
At that point of time, my lord, the husband of the petitioner, who was a diabetic patient, he, my lord, he was suffering from kidney failure.
Hmm.
So, my lord, he could not join at Mahasara
Hmm.
as per this order, my lord.
Hmm.
So he was allowed to join in the office of the district elementary education officer. That lordship will find at page 57,
57.
my lord, in my reply.
This is an affidavit of position.
My lord, this is
Reply.
the rapid,
Reply.
rejoin the rapid.
57, yes. Huh?
With reference to subject cited above, I have the honor to inform you that I have joined as assistant teacher in your school office on 26/6/20.
In the
06
forenoon.
In the forenoon.
Acha, so in
Which
which
was
school?
accepted by the district elementary education officer, madam. He
2006?
joined in the office of the district elementary education officer.
He joined in the office of district. How can he join in the office?
Because, my lord, he was suffering from, my lord.
No, that
kidney
is
failure.
okay.
He was permitted to join by the district elementary education officer, my lord, on his paper slip.
As what?
As in the
As
office,
assistant teacher.
perhaps, my lord, he was doing some office duty,
Office duty cannot be a teacher.
my lord.
But it is written, I've joined as assistant teacher in your school office.
My lord, it is like that in the joining. And my lord.
Be that as it may, he had joined in the district elementary
which was
education office.
permitted by the district elementary.
This is the joining report. Huh.
My lord.
Whether it was permitted.
My lord. Well, he has accepted, my lord. The case 57, lawsuit.
No, this is a request. You kindly accept my joining report.
My lord accepted.
Oh, accepted.
My lord.
Acha.
They signed 29/6 to then.
Hmm. Hmm.
And thereafter, my lord. 1/8/11/2006. Husband of the petitioner, my lord, expired.
Died.
Died.
11/2006.
My lord, case 37.
8/11/2006.
2006.
Death certificate is there.
Case 37, my lord.
Yes. Then what happened? So he was not given salary. She did not get.
Giving his salary during his lifetime. So this writ petition he filed for this honorable court, that was disposed of on, my lord, 3/12/2008.
Where?
Page, my lord, 28.
She filed a writ after his death.
No, my lord, this writ petition was pending. He filed this writ petition, my lord, in the year 2023. 2003, my lord.
2003.
During his lifetime, it was filed. After his death, my lord, the petitioner implemented herself as in his place, my lord. And the petition was disposed of. This honorable court held that the petitioner was duly selected candidate. He worked in the from the date
Of his appointment?
initial joining in the earlier school, but his salary could not be paid. And there was a direction to the commissioner secretary, my lord, to take a decision by conducting an inquiry against, for which he was appointed against my lord,
Transferred.
against a post which was not retained. As he was a regularly selected candidate, my lord. It was also held that he was a regularly selected candidate, my lord. The admitted case of the said respondent is that, my lord, he was regularly selected candidate. So, my lord, for all on the part of the state, my lord, the petitioner's husband could not have been allowed to suffer. But
And he did not get salary from the first day, from day one.
till his death, he did not get any salary.
He was appointed first in which year?
1999, my lord.
1999, yes.
1299.
And from 1999 to 2006, he did not get anything
Not get any salary
for 7 years.
for 7 years. Honorable court directed to pay the current salary. Current salary was not paid. Preliminary education was called for personal appearance. He appeared before the court. He submitted before this court that the post was not retained. Paid. Subsequently, full court.
So what do you say, Mr. Saike? What are these judgments for? And what was the order by Justice Amitava Roy? In this 2003, disposed of on when? 20. This petition was disposed of in 2020.
2008.
2008.
Yes,
Oh, 2008, yes. After his death.
After his death. The petitioner before lawsuit was implemented.
The state respondent would release salary as well as other sum following their appointments on Iman. 2006 appointments.
My lord,
নালাগে থাক থাক এখন 2006 following their appointments in 2006
my lord, page, internal page 8 of the judgment, my lord,
Hmm.
paragraph 13,
Hmm. That's what I'm reading.
my lord.
And then Commissioner and Secretary to cause an inquiry to be made initial appointment and service rendered. Prior to what, why is this cutoff date 9/6/2006? He has been working since,
2006, my lord, he has been reappointed in another school.
oh, acha.
Adjustment order, my lord.
That one,
Adjustment order, my lord.
that, huh.
That is the adjustment order.
No, which was that, sir, Berry, annexure?
That is, my lord,
Yes, yes, page 27.
my lord.
Yes, 27, okay. Uh-huh. By duly
28.
associating the headmasters of the schools involved and thereafter take a decision on the post and their claim for pay and other allowances. The to ensure fairness and transparency, you have to participate in the, acha, okay. So an inquiry was directed to be held and he will participate and all.
My lord,
But he could not join here because of his disease
my lord,
and he joined the office
my lord,
after 4 months.
my lord. Now, my lord, the settled rule is that, my lord, in case of death, qualifying service for, my lord, payment of pension is 1 year.
Yes?
1 year.
1 year.
1 year. The husband of the petitioner, my lord, he joined on, my lord,
So 7 years.
6/12/1999, and till 2006, he was working till his death.
At least 5 years.
My lord, he has worked till his death. So, my lord, he has completed the qualifying service. So the petitioner, full lordship, being the wife of the, my lord, dead husband, my lord, she is entitled to payment of pension as well as the arrears salaries for the period her husband rendered her salary services. That point, my lord, I have also relied on some decisions.
Mm.
Recently, my lord, your lordship decision, my lord,
Mm.
wherein the lordship has held that, my lord, even if a person is appointed against a non-sanctioned post, if he renders service, salary should be paid.
Mm.
That is, my lord,
It's okay. These decisions are for this, right?
my lord, on the point of payment of pension.
Okay. So let me hear Sakya,
My lord.
other Sakya.
My lord, here, my lord, wife of the petitioners, she has claiming the pension, my lord.
Yes?
She is claiming the pension, my lord. As per the pension rule, my lord, that service have to be regular, my lord. And my lord, my senior friend already pointed out that why this person has not get this salary from 99 for 2006, my lord. And my lord, the education department has filed an affidavit by stating that they have verified the records of the joining date of joining of the school, particular school. Headmaster of the school said that from 2006, my lord, there is no any report of joining. Even
No, that 2006 he did not join. He joined elementary education.
my lord, he said that join in the elementary education department, my lord. And apart from that, my lord, service condition of the teachers as well as the other post in the inspector both are the separate condition, my lord.
Mm.
Once teacher, my lord, he cannot be appointed in the inspector school, my lord. That there his qualification as a teacher is a separate and other aspect also separate, my lord. That cannot be exhausted, my lord. Therefore, my lord, considering that, my lord, his husband has not get the salary. Even, my lord, he has pointed out the honorable court order where the honorable court order said that verify the document and entire aspect that if required, then the salary may be paid. But there is no indication in the writ petition what happened thereafter, my lord. Because there should be a specific order is violation of that order, my lord. Then there will be a separate cause of action, my lord.
After, matlab, whether any inquiry was held.
My lord. Because, my lord, for issuance of that salary, normally, my lord, salary have to be claimed within the 3 years. That is the Supreme Court mandate, my lord. Now, my lord,
After 2008, there are no information.
no
After
information.
whether it was done.
And for the pension also, my lord, continuous service of the required backup service, my lord, that cannot be without regulation, that cannot be pension cannot be granted, my lord. That is the pension rule says.
See, from 99 to 2000, forget about the next appointment, next, he worked till 2005-6.
Now, 5/6, my lord, what he has against that, my lord, he come before this honorable court, my lord. This honorable court has given the specific order, my lord, whether this order has complied or not, that is not in the part of the writ petition, my lord. That have to be chronologically come, my lord, that respect of particular DO.
Yes, what happened to that? No inquiry done.
My lord, that part, my lord, I have no instruction on that part, my lord. That can be present by the petitioner.
Yes, Mr. Ayat Sakia, what?
Nothing was done.
Nothing was done.
Nothing was done.
No, it must have been done. There are other petitioners.
No, my lord,
My lord, in the affidavit filed by the education department also, my lord, nothing has been brought on record, my lord, pursuant to the order what is the consequential order passed by that, my lord? Nothing has been brought on record. As per my instruction, my lord, nothing was done. Pursuant to that order for payment of salary for the period rendered prior to 2006.
My lord, in this particular writ
Oh,
petition,
there has to be something, otherwise Justice Amitabh Roy's judgment, right?
my lord,
Here, the state respondents would release salary as well as other for the period following their appointments on so and so.
Hmm.
It is not talking of the prior
my
appointments.
lord, that was the claim of the earlier writ petition, my lord. If that, whether any other violation of that writ petition or whether any impugn order issued against the petitioner, that will come the another plea, my lord. Now, my lord, in the present petition, he is claiming the pension, my lord, on the basis of that this available document, my lord. Whatever placed before this court, my lord, honorable court, my lord, this document does not prove that he is entitled for the pension, my lord. If it is in violation of the, my lord, he can proceed, my lord.
From 9/6/2006, actually the claim cannot be there because he did not join.
Fine.
He joined not as an assistant teacher, he joined as something else
Yes.
in the office. And this order also actually protects those who were appointed after 2006
My lord,
or following their appointments forthwith and would ensure that their dues in law are disbursed, or would cause an inquiry to be made into the aspect of initial appointment and service rendered for the period prior to 2006, but duly associating the headmasters and thereafter take into decision with regard to retention of post and their claim. To ensure fairness, they were allowed to participate in the service. Would be communicated to petitioners immediately on completion. So there was no communication also to the petitioners
no,
in view of
nothing,
the directions,
nothing was.
completion which should be done within 3 months. So nothing is done thereafter.
No, my lord, there any communication, any compliance of the order, that is a separate part, my lord. If that is a violation, my lord, petitioner raised the objection at that point of time.
Mm.
This petition, my lord, order passed, my lord, then this order passed in, my lord,
2008.
2008, my lord. Now we are in 2006, my lord. Whatever that order communicate or not communicated, my lord, even department may not be said by the petitioner may well known. If it is not communicated with the department as per order, it is the duty of the petitioner to raise before this honorable court. There is a process, my lord, contempt of
But
court.
nothing can be done, Mr. Ayat Saikia. What I feel is you make a representation. Now that what had happened in 2008-9 and the direction was directed to be completed within 3 months. So whether it was done, not done, you will not find any records. It's long ways.
That has not been done because, my lord, in the affidavit filed by the respondents, my lord, it is, my lord, they have made an inquiry after 2006, what happened?
No,
They
no.
are not making any inquiry prior to that, my lord. They have not indicated anything what was done prior to, my lord, for the service prior to 2006. They have not indicated anything.
Because in the court's order also it was directed.
Earlier on the litigation, it was a remand order. State authority.
Where is that earlier round of litigation not annexed?
Not any.
No, my lord, that order at pace, my lord, the passed by the Honorable Justice Amitabh Roy, my lord.
No, that is there.
My lord. In that order, my lord, for the period prior to 2006,
Mm.
there is a.
Was
my lord,
supposed to be
court was
considered.
Directed to take a decision
Mm.
by making a proper inquiry.
Mm.
But the same judgment, my lord, it was held that the petitioner's husband, my lord, he was regularly selected candidate. He was appointed regularly. But the post against which he was appointed.
Was not
That
retained.
was not retained. And for that, my lord, the petitioner's husband could not have been made to suffer because it was not his fault. If a post is not retained, he cannot retain the post. His duty is to participate in the selection process. He has participated, he was selected, and he was appointed, he joined. He rendered his service. It was duty of the state respondents to pay him salary. If they, my lord, appoint the.
No, it was your duty also to send, to hold the inquiry, to send the report to the petitioner. Petitioner has no role to play after that order.
No, my lord, there is a specific food process, my lord. If violation of the whatever is there, my lord, because, my lord, this petition, we are making the education department making the reply in regards to this petition only,
Mm.
not the earlier set of litigation, my lord. Even, my
No,
lord,
here also in this order also it is said that the service rendered prior to 9/6/2006 has also to be considered.
that have to be considered, my lord, that
friend
as
is not
per the.
representing the, my lord, education department, my lord.
No, no, I am for the pension department
So,
because
my lord,
entire
his
pension
duty
liability is the
is
pension
not to
department.
question my service, my lord. Pension department, he cannot say these things, my lord. The education department is the authority who can apprise this court, my lord, what was the consequential action taken by the education department, not the pension
No,
department.
because
Of pension.
my lord, because pension, we have to settle the pension, my lord, because
No,
my lord,
first,
it is-
let Ms. Kumar say.
my lord.
See the order of this court. Then there was a direction for holding an inquiry into the initial appointment and the service rendered prior to 9/6/2006. Whether that is done, whether that inquiry is done. And there was a direction to pay the salaries. Now, and this was in 2008.
Yes, Lordship.
What?
It was earlier litigation, Lordship, but here they are paying only for the pension, Lordship.
Hmm.
On that regard, Lordship, we had already filed our affidavit too.
Hmm. No, pension will depend upon the facts and circumstances of the
Yes.
case. Now, here in the affidavit, what have you written about the judgment of this court? Anything about that? Any inquiry? Nothing is written, right?
No, Lordship.
So there was no inquiry done. And the person died in the meantime, 2006.
Lordship,
He
then
died
Lordship-
before the judgment.
Yes, Lordship.
Wife impleted herself,
Then
substituted herself, and then the order was passed for an inquiry. 2008, you will not have the instructions also.
Oh, yes. Mhm. Okay.
Now, Mr. Ayat Sega, why this application has been filed so late? 2020.
Earlier, in another petitioner's file, my lord, due to some technical reasons, my lord, it was withdrawn
Acha.
with a liberty to file a fresh, my lord. That is, the order was still filed at page 40, my lord.
40.
40, my lord. The 19 also is filed with the petition.
40 is what?
That's a L, my lord. It
Ah.
comes from page 39, my lord.
Hmm. This was earlier it filed by the petitioner,
Petitioner, my lord.
Meena Deka. Why did she withdraw?
Some vital documents were not annexed in this petition, my lord. So, my lord,
This was filed in 19, a year before. But her husband died in 2006.
Yes.
So 6 to 19. Acha, acha, jano.
payment.
So, same is Kumar, what to do?
Lord, let him. They have to
But
file a-
he has, her husband has worked.
Yes, Lordship, but
For-
he was working in the a non-existing post, Lordship, earlier.
He was working in a regular post, but that same was not retained.
Yes, Lordship. That is another litigation, Lordship. But here in this petition, Lordship, their grievance is that their pension is not paid. So, Lordship, we have to discuss only about the pension, Lordship. That is another litigation, Lordship, whether it was inquired or not.
But it has to be seen whether she is entitled. He was entitled.
He is not entitled, Lordship.
Why he was not entitled? He will be entitled. He had worked in a regular post. The same was not retained. But in the judgment of this court, it is said that hold an inquiry. That was not done.
It is another litigation.
So that is not the fault of the petitioner that the inquiry was not done.
Then, Lordship, kindly allow me 1 week time, Lordship. I will bring.
And
on
this is
call-
what I asked in the beginning, that don't
No,
come with the...
Lordship, because I was,
Okay, what I'll do is, let she file an application, a
Yes.
representation before
Okay.
you. I'll write all these facts
Lordship,
and then it will have to be considered by the authorities.
Lordship.
Uh-huh.
That will be the benefit of the petitioner also.
Yes. And don't again pass a speaking order rejecting her,
Favor,
so and so.
all on that.
Because now whether inquiry was done and all, they will not have the information.
Earlier,
Inquiry was directed to be made for the purpose of payment of salary for the period, my lord, period of service rendered by her husband prior to 2006, from the date of his joining. But it is, my lord, the period for which, my lord, the husband of the petitioner, my lord, rendered service, there is pensionable service, my lord. He was regularly appointed, elected candidate, my lord, regularly appointed, that period is pensionable, my lord.
Okay, that is what we'll do.
That may be, my lord, Roshik may observe that.
I'll observe that it's a pensionable post. He was regularly working
yes.
and he had worked for more than 1 year. So he's entitled for pension.
Fine.
And then you will submit a representation. Okay? I'll
As
dictate
per-
this order after I come back in 2 minutes time. Mr. Saikia, you can go, your junior will be there if you have some other matters.
Alright.
Yes.
কিন্তু কথা হ'ল কোৱালিফাইং চাৰ্ভিচ টো কৰিব লাগিব কৰিলেহে পেঞ্চনটো মানুহটো পাব আৰু ছেকেণ্ড কথাটো হ'ল কোৱালিফাইং চাৰ্ভিচ কৰিবলৈ ক'ত 46 আৰু 143 প্ৰভিজন আছে এতিয়া খালি কোৰ্টে এটা ভাল বুদ্ধি দিছে তেখেতক যে এখন যদি নতুনকৈ ৰিপ্ৰেজেণ্টেশ্যন ফাইল কৰি যদি এই কথাখিনি প্লেচ কৰে তেতিয়া ডিপাৰ্টমেণ্টে এটা যিকোনো এটা অৰ্ডাৰ পাছ কৰিব যদি অৰ্ডাৰটো বেয়া হয় তেতিয়া গোটেই প্লিখিনি তেওঁ ল'ব কোৰ্টে খুব ভাল আইডিয়া এটা দিব কিন্তু এইটোত যদি কোৰ্টে অৰ্ডাৰো দিয়ে ডিপাৰ্টমেণ্টে কেতিয়াও পেঞ্চন নিদিয়ে কাৰণ আগৰ কথাখিনি থাকি যাব কিন্তু এই নতুন যেতিয়া পৰ্যবেক্ষণ আহিব কাৰণ 2006 অৰ্ডাৰটো আজি চেলেঞ্জ কৰিব নোৱাৰে তেতিয়া আকৌ সেই ভেলিডিটি অফ কথাটো ইয়াতো মানে সেইটো কোৰ্টে ধুনীয়া কৰি দিবে তাৰ সেইটো এটা ভালো হ'ব যেনেকৈ কালি দাদাটোৰ ক্ষেত্ৰত যে মই কৈছোঁ তেখেতে যে DLC যদি দিয়ে তেতিয়া তেওঁ ভাল পাব অৰ্ডাৰ কাৰণ সেইটো মানুহে পাব লাগে মানে খালি মানুহবিলাকে ভাবিছে যে আমি আপত্তি কৰিছোঁ মানে নাপাবলৈ এতিয়া কোৰ্টে যিটো বুলি দিছে ভাল কথা কালি এটাতো যদি ক'লে যে ডিষ্ট্ৰিক্ট কমিটিয়ে বস্তুটো চাব চাই লৈ যদি পাব লাগে দিব ডেফিনেটলি পাব কোনো মানুহ যদি মৰি গৈছে প্ৰভিঞ্চিয়েলে যোৱা নাই চাকৰি যদি পাবই কিন্তু সেইটো খালি আকৌ যদি DLC যোগেদি নাযায় তেতিয়াহ'লে আকৌ সেইটো ওলমি থাকিব মানুহজন ওলমি যাব নোৱাৰে এতিয়া এই কেছটোত এতিয়া এইটো কেছত একো নাপায় তুমি আৰু হিয়াৰিং কৰক কোৰ্টে অৰ্ডাৰ দিয়ক এইটো একো পাব নোৱাৰো কিন্তু কেতিয়া পাব গম পোৱা নে যেতিয়া মানে কোৰ্টে যিটো কথা কৈছে যে কি ৰিপ্ৰেজেণ্টেশ্যন দি গোটেই কথাখিনি ক'ব তেতিয়া ডিপাৰ্টমেণ্টে ক'ব যে এইটো অৰ্ডাৰ আমি পাছ কৰিলোঁ এইখিনি কথা ক'লোঁ এইখিনি নকৰোঁ তেতিয়া যদি চাপ'জ সেইটো তেওঁৰ পিছত ফেভাৰত মানে নগ'ল তেতিয়াহ'লে তেওঁ আকৌ এই গোটেই কথাখিনি ক'ব পাৰিব তাই আজি ডেটত এইখিনি ক'ব তেতিয়াতো ভাল কথা
Yes.
Lordship. My lord, sorry for disturbing Lordship. I beg to mention item number Lordship 28 Lordship.
28.
Lordship.
28.
Lordship, my learned friend is supposed to take time, Lordship.
Lordship, this matter,
It's a very urgent
this
matter.
matter, my lord, the affidavits have been filed, pleadings are complete. This matter is being led by Mr. Additional AG, my lord, Mr. B. Gowai. Today, my lord, since this matter will require a considerable hearing, and both sides have to be this thing, my lord, so therefore, my lord, a date may be given, man.
I think, Your Lordship, here is only.
Because a notification has been
small
challenged, my lord,
point, Lordship.
and my lord, a full bench or a judgment is there, my lord, which will be, no, we won't, which will produce later, my lord, which is a covered case, my lord. So,
Okay, we will take it up some
other day,
urgency to do it today.
Lordship, urgency, I have a urgency because I mentioned it, Lordship, because they are the two wives, Lordship. They have no objection.
No.
Lordship, they applied for next kin certificate. But the authority is not allowing by virtue of their one.
It's
My lord,
okay, but
because there are multiple wives, there are a lot of issues there, my lord, multiple wives, and my lord, there is a judgment also, my lord, which will produce, my
And,
lord.
as
it's
in a-
okay, we will hear it on
11th,
Monday,
can it be on
Lordship.
11th, my lord, 11th
11th of June.
June, my lord.
It's too late, Lordship, with all respect, Lordship, because
We will hear it on Friday then, next Friday.
Fine,
Lordship, please, yes.
Okay.
yeah,
Lordship.
Friday.
As prayed for by the learned counsels for both the parties,
His
this
name,
is matter on.
his request may be recorded.
Acha, okay,
Otherwise,
nalini
Lordship.
rekhi.
Then both
Uh,
parties, my lord, both parties. He has mentioned it now.
He has to reply to his client.
He's mentioned, my lord.
He wanted to be taken up today, actually.
Lordship. I
But-
mentioned it, by order it came, Lordship.
List this, and 29th. List this matter on, we will not write anybody's request.
Lordship.
List this matter on 29th of,
Whatever may be the order, Lordship, I.
29th of May,
29th.
2026.
Briefly, my lord.
Yes. Likha, huh? Heard Mr. Ayat Sekia, learned counsel for the petitioner. And Miss S. Kumar, learned standing counsel for secondary education, elementary education. You are for elementary, secondary, everyone. I mean, you can, a government advocate can appear for all. Or all departments. Or only elementary. Okay, for elementary education and Mr. P. Saikia, learned standing counsel for pension.
No.
Oh, learned government advocate for pension department. By this application, the petitioner being the wife of the petitioner, being the wife, the petitioner has prayed for a direction to the respondent authorities to release the pension benefits, to release the family pension and other service benefits relating to the service of her husband. Relating to the service of her husband. The case of the petitioner is that the petitioner was, the husband of the petitioner was appointed as an assistant teacher at Haripur Girls ME School, Haripur Girls ME School in the post held by one Abdul Kalam Azad, who was transferred. Full stop. The said appointment order was dated 3/12/1999. Thereafter, the husband of the petitioner joined to the said post in the said school. Mrs. Said school, by order dated, by joining report dated 6/12/99. And since the said date, the petitioner's husband was working as the assistant teacher. As a regular teacher, right? As a regular teacher to the sanction post. However, it is stated that although the petitioner was appointed to a sanction post, his post was not retained by the respondent authorities. You please correct me if I'm wrong, huh? Not retained by the respondent authorities. The petitioner was not, the petitioner's husband, petitioner was the husband, huh? Last line to your petitioner, petitioner's husband, huh? The husband of the petitioner, along with others, were not getting salaries. And for payment of the same, they made a representation before the Undersecretary to the Government of Assam Education Department. And the Undersecretary to the Government of Assam, by a communication to the DEEO, Borpeta, requested for release of salaries to 58 numbers of ME school teachers, as well as for payment of arrear salaries to the teachers, while letter dated 21st of December 2000. The petitioner also states that the headmaster of the school where her husband was serving had also, by a letter to the DEEO, had stated that the petitioner's husband was serving in the said school as assistant teacher from the date of his appointment as a selected candidate. However, the petitioner's husband did not get salary in spite of making the said representations, and without left with any other alternative, filed a case before the Honorable High Court. And the said case was registered as WPC number 6246 of 2003. 6246 of 2003. And this court had directed to release the current salaries of the petitioners, in that writ petition and on personal appearance of the DEEO, Borpeta, this court further directed to adjust the husband of the petitioner along with others against regular vacancies lying in the district. Full stop. This court, on a further date, directed the DEEO to appear personally, again to appear personally and apprise the court about adjustment of the husband of the petitioner along with others for getting salaries, and also to move the higher authority to get the necessary adjustments. And to complete the exercise, time frame was set. And in view of the said order, the District Elementary Education Officer, by an intimation to the Director of Elementary Education, requested for adjustment of the petitioners, which included the husband of the petitioner, against the vacancies shown by the undersigned, . so that he can personally appear before the Honorable High Court and show the compliance of the order. Thereafter, what happened?
Director sent a proposal, my lord, page 24.
Thereafter, the Director of Secondary Education Assam, by a communication to the Commissioner and Secretary to the Government of Assam, Education Department, had further requested for necessary order so that the concerned DEO may place the same before the High Court, before this High Court. And in pursuance to the said request, right, he was adjusted in this school, right? Read request by order dated 9th of June 2006. The petitioner's husband, along with others, were adjusted as assistant teacher on regular basis in Manchara MV School, Mahsara, Mahchara, Mahsara MV School on the transferred post. Regular post bili kuchu na ba ki kuchu? On regular basis on a transferred post. That will do. On regular basis on a transferred post. However, it is stated by the learned counsel appearing for the petitioner that the petitioner's husband could not join in the said school due to his ailment, and that he made a request for his induction in the office of the District Elementary Education Officer by giving a joining report on 26/6/2006, which was accepted by the Office of the District Elementary Education, which was accepted by the District Elementary Education Officer, which was accepted by the District Elementary Education Officer, Borpeta, on 29/6/2006. Even then, he was not getting salary, right? Even the learned counsel for the petitioner submits that even after the said exercises, the petitioner's husband, as well as other similarly situated teachers, did not get their salary. More so due to the fact that their initial appointment was not retained, right? Post were not. The post, no, because of the fact that the post in which the petitioner's husband and others had joined were not retained by the government. And as such, the petitioner's husband filed a writ petition before this court, which was registered and numbered as 6246 of 2003. 6246, right? Oh, same thing only, same petition. Oh, same petition. No. It will last line to he died, kolu no? Oh no, died I did not say, right? Oh, the learned counsel for the petitioner submits that after joining the office of the District Elementary Education Officer, the petitioner's husband expired on 8/11/2006. 8/11/2006. And the said writ petition, yes, and the said writ petition, that is writ petition number 6246 of 2003, was pending during the said time. And the wife of the petition, and the petitioner, being the wife, had substituted herself in the said petition. This court thereafter by order dated 3/12/2008, disposed of the said writ petition with the direction that state respondents should release the salary and other service entitlement of the petitioner's husband and others for the period following their appointments on 9/6/2006, forthwith. And that with the further direction that their salaries will be paid regularly after that. But as far as the service rendered by the petitioner's husband and others prior to the period of 9/6/2006, an inquiry was directed to be conducted by the Commissioner and Secretary, Government of Assam Education Department, by associating the headmasters of the schools involved, and to take a decision with regard to the retention of the post and their claim for salary and other benefits. And the said exercise was directed to be completed within 3 months from the date of receipt of the order. Full stop. It was also directed that once the said decision was taken, the same has to be communicated to the petitioners, which includes the husband of the petitioner. However, the learned counsel for the petitioner submits that he has no information as to whether an inquiry was conducted after the said order. In fact, he submitted that there was no inquiry held. The learned counsel submits that since day one of his appointment, the petitioner's husband was not paid any salary till the time of his death, that is on 8/11/2006. Although he was working continuously as assistant teacher from December 1999, no, November, wait, from 3/12/19, oh, no, 6/12, from 6/12/1999 to 26/6/2006, because after that he was inducted in the office. I don't know in what capacity. Till 26/6/2006, and thereafter till his death. No, no, ki kolo working as a assistant teacher koise ni last line person. Oh, okay, this sir. From so and so to so and so, and thereafter in the thereafter as an employee in the district elementary education officer Borpeta till his death, that is 8/11/2006, for a few months only. However, the learned counsel appearing for the elementary education, Miss S. Kaur, submitted that initially the petitioner was working, although in a regular post, but his post was not retained. And it was only in the year 2006. Ako petitioner kolo niki ma, petitioner's husband diba ha. Miss Kaur submitted, and it is only in 2006 that he was appointed and adjusted from 2006 to few months to you got your salary or what? No. It was only in the on 9th of June 2006 that his services was adjusted as an assistant teacher in Mahchara MV School in pursuant to the order of this honorable court. Full stop. She further submitted that the petitioner, after the said order, had not worked as an assistant teacher, and as such, he could not claim his salaries for the said period. Mr. P. Saikia, learned government advocate representing the Detention Department, also endorses to the said submission made by Ms. Esco and submits that pensionary benefits cannot be awarded to the petitioner's husband. Cannot be awarded to the petitioner for the service rendered by the petitioner's husband. I've heard the counsels and I've gone through the records. It is noticed that the petitioner was regularly appointed to the post of assistant teacher in the school of Haripur Girls ME School and posted to the post held by the erstwhile employee who was transferred. And he joined the said school on 6/12/1999. And since then, he was working in the said school. And since he was not getting his salary, he and other similarly situated teachers filed a writ petition, which was allowed to the extent that services rendered after his adjustment to another school to a regular post. কি বুলি আৰম্ভ কৰিলো? I'm not able. Writ petition, তাৰপিছত? Since then, he was working in the state school, and since there is not between service, he and other civil teachers filed a writ petition, which was allowed. Filed a writ petition, which was allowed to the extent that to the extent that the petitioners and other similarly situated petitioner's husband and other similarly situated employees would get their salary after their adjustment on 9/6/2006. And for the earlier period, an inquiry was directed to be conducted, as stated above. Full stop. In the said order, it was directed that the Commissioner and Secretary Government of Assam Education Department would conduct the inquiry by holding a discussion with the principal of respective schools and to maintain fairness and transparency. And in conducting the inquiry, the petitioners was also permitted to participate in the same. And it was further directed that the decision should be taken within a time frame, and the same must be communicated to the petitioners. It is full stop. It is seen that nothing was communicated to the petitioner, and it is also not known as to whether any inquiry was at all conducted in pursuant to the High Court's order. It is also seen that the petitioner, husband, had worked for at least 5 years, for 6 years, for at least 6 years. No, not even 6, 7. 2006 he died. 7 years. And he was not paid any salary for the said period, which is against the mandate of law and against the law laid down by the Honorable Apex Court. That if services are taken, if services are utilized by the government authorities, the payment should be made. As such, it is directed that the petitioner should make a representation before the Commissioner and Secretary, Government of Assam in Education Department,
regarding entitlement of the pension, the qualifying
oh yes, yes. Hetu agot dia, huh? It is further noticed that the petitioner had expired on 8/11/2006 during his service, and he is entitled not only to his arrear salary, but also his family is entitled for the pensionary benefits, for pension and other pensionary benefits.
Qualifying services mentioned in Rule 140 of the Full Services Pension Rules, 1969.
Show me that.
Rule 140.
It is in the service manual or where?
Pension bill.
Pension manual.
Page number 152.
Same book, page number?
Same, 152.
Yes.
Rule 140, Page 153, third line. In case of death while in service, the government servant should have completed a minimum period of 1 year service.
It's okay. It is provided under Rule 140 of the Assam Service within bracket Pension Rules 1969. What is 142 except as provided?
142 is,
Minimum of 7 years continuous service dies while in service. The family of such government servant may be granted a pension at the rate and conditions mentioned below. Here is a case where he has completed 7 years.
7 years. Even if he has not completed 7 years, he will get the proportional pension,
He'll get the provisional.
Proportional pension.
Proportional pension. Now, what is the difference? Except as provided in Rule 142, a family pension not exceeding the rate mentioned in Rule 141. I think this is amended 141. Right. This must have been amended now. Rate of family pension
That has been amended.
will be admissible in case of death of an officer. This is less than 1 year, less than 7 years.
Fine.
140 is less than 7 years. 142 is beyond 7 years. Will be admissible in case of death of an officer while in service or under retirement on service or after retirement on or after 1st January if at the time of death the retired officer was in receipt of a compensation in hand. So in the case of death while in service, the government servant should have completed
Around 25 days short, 7 years.
25 days short. He joined in January, no, December.
My lord, he joined on, my lord, 6 December 99.
Okay, the authority, I'll put this, both the sections and let's see. Provides, Kusuna. So and so that a family pension should be provided as mentioned in Rule 141 in case of death of an officer while in service. And also that for the said entitlement, the government servant should have completed a minimum period of 1 year of service. Should have completed a minimum period of 1 year service. And in 140, that 141 we are saying. Mentioned in Rule 141, hetu beleg. And further, in Rule 142, it is provided that government servant who has completed more than 7 years of service, 7 years of continuous service, dies in service, when koi start, and also that when a government servant renders more than 7 years of continuous service, dies while in service, the family pension has to be granted to the family under the provisions, under the conditions mentioned in the said rule. In the instant case, however, it is seen that the petitioner has completed his service for less than 7 years, right?
28 days. Have counted.
28 days less than 7 years.
That may be condoned by.
And let's see what they do. And under section 1 and under rule 142, a government servant is required to render service at least minimum of 7 years. Full stop. Be that as it may, the pension and the other pensionary benefits cannot be refused to the family of the husband of the petitioner by the authorities concerned. He having served as an assistant teacher or in other capacity continuously from 99 to 2006. As such, it is directed that the petitioner would submit a representation before the Commissioner and Secretary, Government of Assam Education Department.
Secretary, School Education Department. Now,
School Education,
now Secretary, School Education Department.
not Commissioner and Secretary.
It has been renamed, my lord.
Like it is done in the earlier case, no.
No, my lord, it has been renamed. That post has been renamed.
Achha. To before the Secretary of
School
School Education, Government of Assam, ventilating her grievances, that is payment of the salaries, which she is entitled under the Assam Services Pension Rules. And the authority concerned shall consider the said representation in the light of the observations made above, within a period of 1 month from the date of receipt of this order. You don't need again repetition.
Salary. Salary as well as.
Oh, yes, sir.
Area salary as well as the pension.
Ki boli korlo mo? They cannot refuse payment of the area salary as well as the pension and pensionary benefits. Area salary, tate mojo disu cannot refuse the area salary as well as pension and pensionary benefits to the petitioner. Having utilized the service to hole? Okay. Okay, no idea, correction for a sign. Receipt of this order. The petitioner is as such directed to place place this order before to submit her representation along with a certified copy of this order at the earliest.
2 months,
Before-
Lordship, 2 months.
Acha, 2 months, dear bro. 2 months, huh? Petition is disposed of. Yes, next. এখন আমার নাকি? 18 and 19, council not there. Huh?
Learned friend is there. Before my
18 and 19 who appears? Mr. A. Deca. Yes.
Order, Lordship,
Ah.
17th of February.
Hmm.
They are supposed to file a detailed affidavit as to why the secretary has not considered the grievance of the petitioner, although he is fulfilled with the criteria fixed by the advertisement of 2012. Lordship, may kindly see the order 17/2/2020.
What is the issue? What they
Yeah.
have not?
Although Lordship, her service has been recommended by the divisional screening committee to accommodate her service as tutor, but finally her name is left out from that list. Lordship.
She was appointed on temporary, what?
No, initially she was appointed in 1996, pursuant to selected Lordship.
Hmm.
Thereafter, she received salary up to 2006. Now, after 2007, her salary was stopped. Now, issue regarding the non-payment of salary, Lordship, this has been come up before division bench, and this honorable court, Lordship, directed to constitute a screening committee.
Hmm.
That order was passed in 2010. In brief, Lordship.
Mhm.
my lord, before my friend
No,
started.
it's okay. You have to file affidavit.
My lord, yes, my lord, 10 days time may be granted, my lord, I want to file a appeal.
Matter was being considered by the government and school department. Why the director had to, it is not understood as to why the director had to file an affidavit in the matter. The affidavit ought to have been filed by the competent authority of the Department of School Education.
Because
So what? The earlier prayer was that the director will file affidavit.
Yes,
Director has
earlier-
filed.
Last occasion, earlier occasion, my lord, director has filed an affidavit, my lord.
Ah.
Now, my
what
lord,
happened here, Lordship, the divisional screening committee has submitted a detailed report to the government, Lordship.
Hmm.
So entire record is within the commissioner, secretary, Lordship.
Hmm.
That is why this honorable court put a question, Lordship, as to why the directors file affidavit, because in their affidavit, they themselves stated that the entire records is within the department,
secretary.
of
Hmm.
department, Lordship.
So secretary has to file.
Yes, that was the director.
Before the next date, the secretary shall invariably file an affidavit before this court and therein disclose the reason why the name of the petitioner was not included in the illegal irregular teacher recommended as teacher. Huh? Disclose the reason as to why the name of the petitioner was not included in the list of illegal irregular teacher. I think this is little clerical mistake. Recommended for accommodation as teacher or tutor. I think not should not have been there.
Tutor, Lordship. As to
Hmm.
why her name is not included is in the list of accommodated tutor, Lordship. That was
Okay.
done under the 2007.
So see, invariably you have to file. You should have filed.
my lord.
Hmm. You will not be given more than 7 days time. Hmm?
10
You file it within,
Can it be 10 days, my lord?
no, 2nd of June. তাতো আহিলে নৰখ বাই আছো পানী গৰম পানী আৰু ঠিকছে গৰম দিব লাগে বিৰাট কাম হৈছে Heard Mr. A. Deca, Learned Counsel appearing for petitioner, and Mr.
PK
B.P. Bora,
PK.
P.K. Bora, Learned. I have also written your name as P.K., but I don't remember. D.P. Bora comes to my mind. P.K. Bora, Learned Counsel, Standing Counsel for Elementary,
My lord,
for elementary education. By the last order dated 17/2/2026, the secretary was directed to file an affidavit before this court, invariably, to disclose the reason why the name of the petitioner was not recommended for accommodation as teacher tutor. However, when the matter is called up today, the learned counsel submits that he requires further time to file the affidavit. As a last opportunity, full stop. At a last opportunity, as a last opportunity, the same is granted and the affidavit was directed to be filed. All of basic one did also. Filed by the next date fixed. List this matter on 2nd of June. 2nd of June?
My lord.
2nd of June is a hearing date. 3rd of June.
Obliged.
19 also similar.
Uh-huh.
Item 19 also
8 to
similar.
19, okay?
Oh.
Or 19 also similar.
Oh.
They have to file. Secretary
Yes,
has to
yes.
file.
Obliged.
Same order. 20.
Worship, in the earlier order, it is instruction is sought whether petitioner service can be adjusted in place of respondent number 7 or not, Lordship.
To obtain instruction, PK Bora. Yes. He is granted 2 weeks and the private respondent is suffering from a non-payment of salary. Therefore, it is appears that there is some urgency. Mr. PK Bora, so the matter relates to non-payment of salary, right?
Yes, Lordship.
So let's see what is the instruction. You are working in a regular post
Yes, Lordship.
continuously.
But Lordship, I am not fully acquainted with the fact of the case, Lordship.
Where is the senior who is appearing?
His Lordship suffering from some illness, Lordship.
Oh, acha. Let me see what the
Yes,
instruction
Lordship.
is.
Yes, Lordship.
Acha, that can be done only in respect to his post. He cannot take somebody else's provincialization. Cannot be provincialized in respect of someone who has resigned. Was resigned, was a personal post. These are all personal post or what?
Yes.
Even petitioner is continuing in personal post. So definitely personal post finishes, abolished when somebody resigns. Mr. Counsel, it's actually, they cannot accede to your request because the posts were held as personal. So let your senior come then.
Yes, as the merit is concerned, Lordship.
Okay, yeah. Go to the
Lordship.
instructions.
Yes, Lordship.
Lordship, I am for the respondent number 8 and 9, Lordship, and our salary has been stopped, Lordship. There is a interim
You
order.
are also personal post.
Yes, Lordship. I am for the respondent number 8 and 9, Lordship.
You are same with the petitioners.
No, no, no. I am. We have been selected, Lordship. Appointed as tutor, Lordship.
You also have not got salary.
Yes, Lordship.
Now, what is the reason behind?
Reason, Lordship, there is an interim order, Lordship, that was passed on wrong premises, Lordship. Lordship may pay the last.
But you have not filed any vacation of interim order.
Yes, that was not fine.
Now, how can we go against?
No, Lordship, earlier that may be given, Lordship.
Okay, let his senior come. His senior is not well. And you also go through the instructions. Will you file an affidavit incorporating this or no? You give an instruction copy. You give him. Okay. Mr.
P. Medhi, Lordship.
P. Medhi, heard Mr. P. Medhi, learned counsel for the petitioner, and Mr. P. K. Borman, learned standing counsel for elementary education, and Mr.
J.M. Gogoi, Lordship.
J.M. Gogoi, learned counsel for the private respondents number 8 and 9. Mr. P. K. Bora has, in compliance with the earlier order, dated 29/4/2026, Mr. P. K. Bora, learned standing counsel, has placed an instructions by which it is reflected that petitioner could not be adjusted to the post of adjusted to the post to the post which stood abolished as the other person has retired. কি বুলি ক'লো মই বুজিয়ে নাপালো কি? By which, yes. Or could not, no, এটা কাম কৰোঁ। By which the services of the petitioner could not be is stated, by which it is stated that services of the petitioner cannot be provincialized. In place of respondent number 7, who had resigned from the said post of language teacher due to the fact that the respondent number 7, who had resigned, was holding a personal, was holding the post in his personal capacity. The post which gets abolished once a person resigns. The learned counsel for the petitioner, however, submits that they may be allowed some time to go through the said instructions.
That,
The prayer is allowed. List this matter on
so order that may be given, Lordship.
Nine,
First of January, Lordship, 1st of June, Lordship,
1st of
2 or
June.
4, Lordship, if
okay,
possible.
1st of June. You go through the instruction, let me know.
2, probably that may be fixed, Lordship.
1st of June.
1st of June. Deeply obliged.
মাটি দিয়কচোন তাৰ পিছতো কি? 21. What has to be done here?
Lordship, I have that instruction. Dada, go ahead.
It's also non-payment of
What
arrears.
is the?
Lordship, the area seller as well as the interest as directed by this court has been proposed and they sent to the commissioner for their approval. And it was also made a budgetary provision for Lordship. That Lordship is clear of this.
So it is allowed.
It would be allowed, Lordship, after
there-
passing
there
of the budget by the assembly, Lordship.
Okay.
There are two issues, my lord.
Huh?
It's,
That clinches the issue. That answers your.
no, my lord, they have calculated interest from 1/7/2017, but my payment became due on 28/2/2015. It is not understandable why this period is not taken into account. One thing.
4,42,639
Lordship,
is
total-
required for release of area salary. That you are agreeable to?
No, my lord, this.
Area salary with effect from 18 to 2014
yes.
to 28 to 2015.
The
Yes.
principal amount is 2,73,417.
That was the area
According to
salary.
you.
Yes, they have
What?
also agreed in this letter, this principal amount, there is no dispute about
Only that interest part.
interest part.
Interest part will calculate it from 1/7/2017 to 4/5/2026.
My submission is that it should be calculated from the due date,
From
the date
18 to 2014.
Yes, 28 to 2015, when the payment became due. And another thing is that, my lord, by
At
the,
you are getting this payment because of an High Court's order, right?
yes,
And that order was issued, it was
there are two
issued.
orders, my lord.
There were two orders, right?
Yes.
5/8 and, acha.
And,
And arrear salary with an interest of 7% was allowed.
yes,
Interest. The interest due to the principal, due on the principal rate is, principal rate 2,73,000, you are not disputing. That
Yes,
is okay.
yes.
For the period so and so, 17 to 26. Per annum, 7% is 1,69,000.
yes. But this should be calculated from the date on which the payment became due. That is the. only-
28 to
Yes,
2015.
yes, yes,
So for 2 years, they have not paid.
yes.
The-
I mean, they are not calculating the interest.
Yes, Mr. PP Datta, whether
This
you
one
will
thing-
do it
another
afresh
thing
or.
That, my lord, this,
Because what I can feel is, the salary was not paid for 1 year
yes,
from 2014 to 15. Right.
18 to 2014 to 28 to 2015.
So 1 year,
Yes.
right?
Approximately.
And salary was not paid. So salary was due in 2015. So from that day, you have to calculate the interest. And what about 15 to 17? It was paid.
No, no.
From 15 to 26, it is paid.
Yes, from 15 to till date, I'm being paid.
Current salary, you have been
Current
paid.
salary is being paid. there
You
is
were
no
not
area.
paid salary only for the
Is
one year.
Yes, ma'am.
1 year area salary you will get
Yes.
along with 7% interest.
Interest rate.
So 7% interest per annum
Yes.
was calculated as 169,222. And period is effect from 17 to
Yes,
26. Why?
This, I have objection to this. The period, only the starting date from which they have calculated the salary. My submission is that it should be calculated from the date on which the payment became due, which is 28 to 2015.
To till
Till the date they pay.
you have been getting your salary from 2015 onwards,
Yes,
regular salary.
regular salary.
So no interest as far as that is concerned.
Yes, on the amount that has become arrear. Interest
Yes.
is only on the amount that has become arrear.
So interest, your arrear amount is 2,73,000.
Yes.
So you calculate 7% per annum, it comes to 169. Calculate it, Mr. P.P. Datta.
Yes.
Calculation should be from the date 28 to 2015.
So, okay, date you leave
Yes,
out.
yes.
But if you calculate 7% interest on 2,73,000, your amount will come.
Yes.
So calculate it, Mr. Datta.
Yes, I'm doing it.
It comes to what amount?
It would be little.
I'm not understanding this interest due on the principal of rupees 80 for 172. Do you have the instruction?
No, Lord.
They have calculated interest from 1/7/2017.
The letter written by the Director Education to the government that was shared with me by the Land Council. So on the basis of that, I'm saying that they have calculated it from 1/7/2017.
Why? Why is that?
I don't know. I don't know the reason. The letter doesn't disclose why they have chosen.
1/7/2017, why is that date? What is so sacrosanct about? And 2/4/5/2026, what is this?
It's also not clear.
Okay, I'll come back at 2. Mr. P.P. Datta.
Lordship.
You see what is to be done.
Fine.
Otherwise, see the chart 18/2, principal amount.
Yes.
1/7/2/4/5/2026. There the interest is not required. You are getting your pay
Yes. So interest would be on the only principal amount
of 2,76,000.
Yes.
So 7% of 2,70,000 is how much, Mr. Datta? This is into 7 divided by 100. You do it, it will come out.
Lordship,
What is the amount? You do 273,417
yes, 273.
into 7 by 100.
7% is equal to 19,119. 7%.
7%
per year.
Per year.
per year.
How many?
So 1 year only.
1 year.
No. It is
But
up
then
to
you
the date of
calculated-
payment.
Huh?
It is up to the date of payment. They have not yet paid. I'm not.
Up to 2026.
Yes.
That interest will be calculated.
Yes.
So from you
The
went
direction of
from
the
28 to 2015
yes.
till 4/5/2026.
No, till the day they make the payment. That is what it is. Maybe for the convenience, we can accept that date.
That May
Yes.
2026.
Yes.
So from 15
Lordship.
till 2026.
6, yes.
From 15 you are getting your salary.
Yes.
So that will come to how much? Calculate it and we'll see at 2.
Yeah. Oh, no, it's very good, sir. That's a good, sir. Hey, you come down there, very good. What are you? I didn't know. I didn't know. This way. This way. I studied here as a 27, 50 to 28. This.
Price, do I would consider the price. Position and that. So, price can be done. Oh, what's this? That's. 38 logo right there.
No, no, 21 logo.
That's right.
21 logo.
As price you go. You want to show you. That is 38 logo.
তারপর 32, তারপর 22, তারপর more আছে, তারপর বলবো।
All right.
এই একটু সব একটু।
Oh, between 45 to double zeros. Divide. This is procedure to be.
আপগ্রেড করা হবে।
এতিয়া কৰিব জানো?
আপগ্রেড কেইটা হৈ আছে?
Yes.
I'd like to mention with regard to item number 5758
57, 58.
for upgradation, my lord. Both the matter were left over on the previous 2 days, and there is
Acha.
urgency also, my lord.
57, 58.
My lord.
Okay, call up after, I'm in the midst of another matter, so after that. After that, I think another matter was mentioned in the morning.
Oh, sure.
Item number 35.
After this,
After 35, I'll take this.
Yes.
Okay.
Alright.
Yes, yes, Mr.
Please.
Datta.
Lordship, kindly come to page 39 of the.
39.
Yes.
Hmm. Yes.
The part of the order of the High Court, last
Huh.
paragraph. In that view of the matter, the writ petition is disposed of by issuing a writ of mandamus to the state respondent to release the area SLI order petitioner before 30/6/2017.
On or before, huh?
Oh, yes, on or before. Failing which the amount will carry interest of 7%.
Huh.
So we failed to pay that amount before 30/6/2017.
Hmm.
So from 1st of July 2017, that interest of 7% will be calculated on that amount. That's why, Lordship, it was from 1/7/2017.
And by issuing a writ of metro state respondents for release of on or before 36.
Yes.
So you have released the amount
After-
on 36.
No, Lordship, we could
Before.
fail.
Oh, you you
That's why-
failed. So you had released after 36.
After 36, Lordship, that proposal is mooted, Lordship, for releasing.
36, 2017.
Yes. Up to
Acha.
36, Lordship, if the department has paid the amount to before, on or before 36/2017, there was no necessity to pay 7%.
Hmm.
That
So
7%.
after 36,
After 36, that carry with 7% interest, Lordship. That's why in my instruction, Lordship.
This,
Ek minute, Dada, ek minute.
but whether
this,
That's
this
the-
that's the
interpretation
correct
is-
interpretation.
This interpretation is.
I
not-
may be wrong,
mean,
Lordship, I may be
clearly-
wrong.
Wait,
but-
let me go
Okay.
through.
I may be wrong.
This is in respect of the present petition.
Present-
This order.
Yes.
No, this order in respect of the another person who is similarly situated with the present petition,
Acha.
and I am relying on this order.
So it applies to you as well.
Yes.
It doesn't apply as such,
Hmm.
but on the basis of analogy, it applies,
Ah.
the precedent.
No, Sushilnath petition is page 45 order. That petitioner's order.
So in a way, of course, sir, subject to what you say,
Lordship.
but in a way, he's correct in saying that the area salary has to be paid on or before 36.
Yes.
And if they cannot pay, then 7% interest will be
Accrued.
This is,
accumulated.
yes, this is in respect of Ashraf Hussain, the
Ah.
petitioner in that petition.
Hmm.
So, I have relied on this order, my lord.
Page 45.
So, and then thereafter,
Hmm.
I have sent representation,
Hmm.
giving this order.
Hmm.
They have not paid, then I came before this honorable
Hmm.
court, and this honorable court issued order at page
45.
46.
Huh.
This is in my petition.
Yes.
This order, the last paragraph, my lord. In view of the above, the present petition is disposed of with the direction to the respondent authorities to verify the claim of the petitioner for payment of the area salary for the aforesaid period and release the same. If the petitioner is also similarly situated, as in WBC so-and-so, the petitioner shall also be given interest at the rate
7%.
of 7%.
So that will actually apply.
This window was given as an incentive to pay before this particular date.
Hmm.
But they failed, so this is not applicable anymore. Because this is a chance given to the respondents to pay without interest. But they didn't avail it. And therefore, I was forced to come before this honorable court twice.
हाँ
And
ठीक है, but
it-
7% interest from that Justice Goswami's order, that from 36 rather.
And another
You have got your entire amount.
Yes, well, another
Right.
thing, another thing, my lord, this honorable court in the present proceeding earlier passed order dated 24/26
Huh.
and 28/4/26,
Huh.
seeking to identify the officials who are responsible for delay
Hmm.
to recover the interest amount from them.
That is for them to do.
Yes.
That is, you have nothing to say, that is for them to do. As
But
long as they are paying you,
Yes.
you are satisfied. So they have paid you the principal amount?
No, they didn't pay this. This.
They will pay.
Yes.
They have admitted your claim.
Yes.
So to 2,73,000 you are getting as a principal amount,
Yes.
and the interest amount is calculated as 1,69,000. Of
Yes.
course, few, according to you,
It should be
28 to 2015 to 17 for 2 year period, it was not calculated.
not calculated.
But if we go strictly by these judgments of this court, you will be paid only after that date. And you
Yes,
are
yes,
claiming
but-
the same benefit.
But here.
Justice Koteshwar also had done the same because they similarly situated with 5105.
Yes, but it is clear from the Justice Goswami's, Honorable Justice Goswami's order that this was given a window of time to pay. I mean, quickly.
So they had
So
paid.
they failed to do so.
They had failed.
Yes.
Now they are
So
paying
therefore
you.
The interest should be, I mean, calculated from the due date. That is my submission, my lord. It is up to your lordship.
So what, for this remaining amount of interest, you can again just submit a representation. But again, whether he has to bring some fresh instruction or what. Let this matter be disposed of. You again try your best to get that interest for those 2 months. Right.
My lord, on the basis of this letter, if your lordship disposes this off, then I am not certain that they will make the payment because I came before this honorable court twice. for
Then
this.
you get the instruction why it is not paid for other 2 months. But whether that will be required or you think over. You have gone through this instruction.
Yes, I have gone through. I have gone through. But my submission is that let them process this and pay me, and then your lordship would close this court proceeding
After.
after payment. But otherwise, I would have to come back again because this has happened earlier.
Acha. Heard, Mr.
Oloskar.
Okay.
Oloskar.
O. Loskor, Learned Counsel for the petitioner, and Mr. P.P. Datta, Learned Standing Counsel for
Secondary education.
secondary education. By this application, the petitioner has prayed for releasing his arrear salary
Into 2020.
releasing his arrear salaries for the period 18 to 2014 to 28 to 2015, amounting to rupees 2,73,417 only, with interest at the rate of 10% per annum from the date of its becoming due till the date of actual payment. The petitioner states that for non-payment of the salary, he had filed a writ petition being WPC number 3815 of 2018 and this court, by order dated 5/8/2019, had disposed of same petitioner, right? Sujit Kumar Nag.
Yes, ma'am.
Yes. Had disposed of কি করলো? By order dated, and this court, by order dated 5/8/2019, had disposed of the said writ petition with the direction to the respondent authorities to verify the claim of the petitioner for payment of the arrear salary for the said period and release the same. Full stop. It was further directed that the petitioner is similarly situated with other petitioner who had filed another writ petition being 5085 of 2016 and at par with the direction given in the said judgment, the petitioner was also directed to be given 7% interest on the due amount. The petitioner was, however, not paid, right, after this order, and he filed the present writ petition. It is the case of the petitioner that from 1/7/2017, acha, you were regularly paid salary from 28 to 2015.
Yes, my lord.
That
1/3/2015.
1/3, huh? That the petitioner was paid his regular salary from 1/3/2015 and his salary only for the period from 18 to 20 to 2014 to 28/2/2015 was not paid. During hearing of this instant petition, Mr. P.P. Datta, learned standing counsel, has placed one instruction received from the Director of Secondary Education, Assam, by which it is stated that in inviting, I have the honor to state an amount of so and so is required for. No, কি করলো? Had placed an instruction. No, but so Secondary Education Assam dated 6/5/2026. Who had by letter dated by letter to the Commissioner and Secretary to the Government of Assam had communicated that an amount of rupees 4,42,639 is required for release of arrears salary in respect of the petitioner, who was working as assistant teacher of Zoom Moza, ZUM, Zoom Moza, MOUZA, High School, District Shribhumi. The said communication was made in compliance with the High Court's order dated 5/8/2019 as mentioned above. By the said letter, the principal amount due to the petitioner was calculated as 2,73,417 for the unpaid period, that is 18/2/2014 to 28/2/2015. This amount is the same as has been calculated by the petitioner and paid for in the petition. However, in respect of the interest amount, the respondent authorities had calculated the required interest rate at 7% per annum from 1/7/2017 to 4/5/2026. Whereas the counsel for the petitioner submits that the interest should have been counted from the date of from the date when the arrear salary was due to be paid to the petitioner, that is from 28/2/2015 till date. In view of the same, Mr. P.P. Datta, learned standing counsel, is directed to obtain instruction as to why the said period of 2 years, more than 2 years, said period of more than 2 years were not included while calculating the interest payable to the petitioner. List this matter. Okay, you bring the instructions. List this matter when? Short date? 2nd of June. List this matter on 2nd of June, by which date the learned counsel would place the instructions.
Yes, that verbal instruction is I have.
Yes, verbal. Why this 2 years?
That is the reason that the order that it is 36/2017. If we could not pay, thereafter that interest would be accrued.
That is, of course, he said.
Yes, this is the instruction. But the
Statement doesn't say that.
Okay, we will record it on that day. Okay?
That's it.
Yes, 35 and Sharma. Pleadings are complete.
Yes, complete.
Yes.
Malak petition number 1 is.
You have filed your affidavit?
Yes.
Yes. Your smile shows. Yes.
Petition number 1 is mother and petition number 2 is her son.
Huh.
And you.
Mother and son.
Mother and
What
son.
problem they have?
My lord, The petition number 2 has been studying in JV, Kendriya Vidyalaya NIT Silchar for last 10 years, 12 years. And because of some medical emergency, he could not attend the school and there are some shortage of attendance. And therefore, he was not allowed to sit in the class 12 examination conducted by CBSE. And as per this honorable court order, interim order on 17 to 2026.
17 to 26.
Yes, ma'am.
Huh.
After
Yes.
perusal of records and the submission made by the CBSE authority, the petitioner number 2 was allowed to sit in the examination. But for
Where is the interim order?
there
Page
is no
5.
order. There is no
Internal page 5.
There is no impugn order as such. And after appearing in the theory examination, but I was not allowed to sit in a practical examination. That this honorable court again directed to appear in the practical examination.
Even theory examination, it was done due to the court's order.
Yes, even practical also. And there is an observation in court number on 24/4/2026. Order
17 to 26.
Yes,
After that,
yes, madam. First order 17 to 2026 as per honorable court's order, interim order. I was.
he sat in the written examination.
Yes, madam. And on as per order 24/4/2026, I was allowed to sit in the remaining practical examination. Out of 6 practical examination, I have already sit in 5 because one practical examination I could not sit because of short notice to the practical examination. And
Short notice
because the
given to you.
Yes, madam, because the practical examination was held on 28/3/2026, but I came to know on the morning of 28/3/2026.
Why such late intimation?
Well, because they have sent an email on the previous evening. I did not check the email and therefore I missed. And immediately when I reached to the school, then I came to know. I set immediately remaining 2 papers and on to 30th of March, I have appeared in 3 remaining subjects in practical examination.
You appeared for all.
I have all appeared. And CBSE will also declared the result for all the students. But
Class
I
12 examination.
Yes, on 13, 13. And as per their guideline, today is the last date for, if the result is declared, they can apply for re-evaluation of their answer script. Today is the date for.
So he got the results.
Result has not been declared till today. Therefore, I approach this honorable court without going into the.
What his results were withheld.
Yes, madam. Because
Otherwise, results are declared.
yes, madam.
His result was withheld.
Yes, ma'am. For the
For what?
interest of the student, because of the court's order, page 24/4/2026, the petitioner number 2 shall invariably appear in the said examination on the date so mentioned. It was mentioned on 29th of April. And the result of the son of the petitioner central, including the result of the practical examination, shall not be declared and kept in a seal cover until further order. And therefore, my lord, I approach this honorable court for declaration of result.
Okay. It was ordered to be kept in a seal cover.
Yes, madam.
Okay.
For the interest of the student, but without going into the merit, my lord, there is some medical document. The medical document, the parents could not submit the medical document in proper format. The proper format was not supplied to us.
That is why he was absent.
For some time, my lord, out of 150 days is required. I appeared in the classes for 74 days. The CBSE can offer 25% of attendance relaxation on submission of medical documents. I have submitted all the medical documents annexure 2 that I was undergoing eye treatment in Bangalore, Hyderabad, Kolkata, etc. Otherwise,
Achha, show me that impugn order where you were not allowed to appear in the
there is
exam.
no impugn order.
There is no impugn order.
There is no impugn order. Admit card was not allowed, not issued on 17 to 2026. The examination was scheduled on 20 February. I was allowed to sit by order dated 17 to 2 days ago. I appeared. Now I have cleared all the papers. Only result to be declared. Otherwise, my 1 year will be broken.
For that purpose, interim order was passed, but you have to satisfy me on the merit of the case.
And therefore, my lord, I have annexed all the medical documents. Annexure 2 up to page 46. From 18 to page 46.
His name is Ayushman Dey.
Yes,
He is also a party petitioner here.
yes, madam. On page 17 is mark sheet of class 10 examination.
Mm.
He has secured more than 90%
Mm.
on that subject.
Mm.
And since he has been studying in the school from 2014,
Mm.
and the parent willfully or intentionally cannot stop the school student from going to the school because of his medical emergency. He could
So
not-
what is his medical emergency?
Well, medical emergency.
Eye problem.
Eye problem. Myopia.
So he was admitted when?
But admitted, I have mentioned in the.
So his absence was in the second year, I mean,
Yes,
in
yes, second
12th
year.
class.
Yes, to get 12.
11th class was over,
Yes,
only 12th.
12 class.
So 12th, when did he study? When, which year?
24, 25, 26.
25, 26, 25.
Yes, 57. This is the attendance sheet.
Acha, wait. Page 19 is the myopia.
Yes.
Then, these are the medical certificates.
Medical certificate. Then there are some also medical certificate also, the prescription.
Hmm.
Page 28. Doctor 35.
28,
Then 30 also.
quint.
Queen.
Since last 1 year and is unable to focus on long duration and require frequent rest, eyes relaxation. This was dated January 26.
From 24 onwards, December to 24 onwards, he suffered from the.
December 25, 20?
December 24 first diagnosis before the Kolkata.
Because 10th examination he passed in 24,
Yes,
right? Hmm.
from 24 December.
13/5/2024 was the result date, was the mark sheet date. So from December 24, he was suffering.
Suffering.
But this
And number of.
prescription is of 26.
Yes, the number of application I have submitted.
Acha, March 25. Okay, then?
Page 47 on one.
Hmm.
Application.
Hmm?
Even December 2025, I also submitted
Hmm.
application. Then June also, page
Hmm.
47.
Hmm.
Legal issues of attendance, for condonation of protest of attendance.
Then, okay, these are medical, sir. Then
Yes. And page 57.
46 is also medical.
Yes, ma'am, all are medical certificate up to
Hmm.
46.
Then,
And then application submitted by the mother petitioner number 1. before
Which
the
page?
principal, Page 47
47. Yes. To the principal.
to the principal. Then page 50 also to the principal.
Hmm.
Then last page 50.
Hmm.
Under above circumstances, health issue, I respect your honor to consider his poor attendance for board examination 2026. All medical registration, prescription and reports are attached.
Hmm.
here.
Hmm.
Then page 51 also,
Hmm.
December, in the month of December. Then page 52, their guidelines,
Hmm.
they can offer 25% of relaxation. As per their guideline, 75.
Where is that?
Page 52,
Hmm.
second paragraph. As per their own guidelines, 75% of attendance is required.
In the, what is strict compliance with the attendance? So in above, the same is being reiterated, board answer.
Board can,
A minimum of 75% attendance is mandatory. Prepare, the board offers a 25% relaxation only in cases of emergencies. Okay, then,
then page 57 is my attendance. 74 days,
Hmm.
150, almost 50%. If board offers 25% relaxation on medical ground, definitely I can.
No, your 75% attendance should be there.
Yeah.
Yours is 50%.
50%, 50% less than 50%, 0.60% was less.
So if
49 point
25% relaxation is granted,
If relaxation is granted, almost 75. Less than 1.
then only something less than 75.
Yes. Then
This is
again,
75% is mandatory.
yes, ma'am. Then page 58,
Hmm.
again, when the examination was scheduled
Hmm.
from 20th of February, then my father also requested.
58 is what? To the principal again.
The principal again. As per their own guideline, the principal has to recommend for relaxation of
Hmm,
poor attendance.
hmm,
There are number of communication has been made.
hmm.
Ultimately, I was allowed in terms of the honorable court's order.
Mhm.
In terms of the honorable court's order, I was allowed.
No reply from the respective authorities.
Well, at that time, only they have sent a mail stating that my poor attendance cannot be condoned. Thereafter, I approached this honorable court.
Where is that? It cannot be condoned.
And so, my lord, and in the order, my lord, in the interim order 17 to 2026,
Hmm,
the story has been written, my lord, whole story has been written.
hmm. Hmm. Okay, that was your.
Practical
If-
examination, I was allowed.
No, 25% was not relaxed on your part
Not relaxed.
because it doesn't come to 75% or what?
They have stated that I did not submit the medical document in proper format, and therefore they cannot recommend for relaxation of my poor attendance.
It is their affidavit.
Yes, my lord. And since due to the honorable court's intervention, I have appeared after perusing of the records, after perusing the medical document. My lord, for last 14 years, 12 years, I have been studying in the same institute, securing more than 90% marks. So because of medical emergencies in 1 year only, plus 12 examination, I could not fulfill the minimum percentage of
Yes, I will hear the other party. Let's see what she says.
my.
Young boy, 12 examination. There are medical certificates, maybe may not be in format, but then.
Not format lordship, what happened as per the,
My senior
our-
agrees, my lord, today can be resolved.
Yes.
but
But I
lordship,
enjoy
what
the
happened?
student.
The shortage can be considered in prolonged illness. We have notification.
The
lordship.
kind of eye problem.
No,
He had been.
no, kind of eye problem he is suffering from 2024.
Hmm.
But he never informed the school also. He never informed. He is suffering
No, he was
24.
under treatment. Sometimes it happens that.
Eye divergence, it is a problem was eye divergence, I think is not so much serious.
No,
Only
only
I have
when
got
the
the information from doctor also, eye
Mm.
doctor.
myopia.
Myopia is eye divergence. It is eyesight divergence problem.
No, see, he was continuing in class 11 that time.
From 1.
And then he was promoted to 12.
That is true, lordship, but
That time he did not feel it necessary that he will inform his
that's
medical
why, lordship,
condition.
but earlier he has not informed anybody, CBSE or school authority. Just just the examination was started before 2 days. The examination
Page 47, June ma hote jama.
don't know, his approach is never informed the CBSE also. Just before 2 days, the examination started, he approached this honorable court. Just to allow him to appear in the examination. What to do?
No, he has written many applications to principal as well. His parents,
Huh?
mother, father.
57.
Lordship, I appear for the principal, respond number 3 in this matter. So Lordship, may kindly peruse page number 77 with regards to the case of the petitioner.
Mm.
Why he could not actually, his name could not be recommended for relaxation under that 25% quota. Now, as per page number 77, para number 2
Mm.
of the letter to the CBSE regional director, dated 13 to 2020.
Who writes it? Principal writes it.
Yes,
Hmm.
the principal, respond number 3.
Mm.
So as per directions of CBSE letter dated so and so 4/8/2025, wherein the SOP was actually issued by the CBSE, and we have to abide by the SOP.
SOP means 75-25.
Yes,
Ah.
and therein relaxation norms are also, in fact, he has attached in the writ petition also the SOP itself. As to on what grounds that attendance can be relaxed.
Hmm.
Now, the question which arises was whether this particular disease can come within the category of prolonged illness. And for that purpose, as per the SOP, that a prolonged illness certificate had to be given by the parents from a government hospital or government doctor. That was not given. And we have also annexed the notices. It is not that one fine day he fell short of attendance. We had annexed all the notices that were issued to the parent of the petitioner, the child, wherein we had actually mentioned that his attendance is falling short. by so and so percentage. So kindly please take care of it.
Hmm.
And we have been issuing this from 30 June to 2025
Hmm.
and till December 2025. But then also there was no improvement. And in the letter itself, we had actually stated
They have replied to your notices?
no,
Yes, ma'am. There's
No.
47.
that for only that 47 notice. But
Hmm.
the thing is, we have been asking, please provide us as per the SOP provided by EBSC, please provide the certificate from the government doctor. The moment because these are private institutions, as per the SOP, this will not hold ground.
Ah.
Because private institutions, a private doctor's certificate will not suffice.
Hmm.
So we had been asking, provide us the certificate as per the government of the.
But
any
see,
government hospital.
nowadays, getting treatment from the government hospitals is risky. So everyone takes to, we all take our children to the private hospitals.
I understand. In
Huh.
fact, what has actually happened here?
Hmm.
Okay, there are 4 other students who are falling short of this. So our most important predicament here is the rest of the 3 other students. They are actually contemplating that they are saying that if you relax his attendance, then why not ours? So this will actually set a very bad precedent for all the other students because everybody will then cite his
No,
case.
all cases will not be the same.
Lordship, all of them has attached medical certificates, and some he is like 49.33%. Then one there is Pritam Das with 60%. Then there is Saurabh Chandra which is 57.57%
57% what? Attendance?
attendance, and one is Rupanjan Chaudhary who is 70.30%. So all of them are waiting for the outcome of this particular judgment of this case, so that they will also approach saying that we also deserve to be relaxed.
No, whether they have medical issues.
Yes, they have annexed the medical. We have forwarded all these cases to the CBSE. And if I may just place it before you, Lordship.
It's okay, but
They have not approached the honorable.
The only
they are waiting for you. Then covered order.
the fence, of course. That's
Examination is
sitting on
over,
the
my lord.
fence. They are.
Oh, here, all medical issues will not be the same. The degree will also not be the same.
Yes, that is true.
Here, where is that requirement under the rules that prolong illness and
That is
where
there.
is there?
It is there.
Is it annexed?
Yes, yes,
I have
it is
got
annexed
it.
in the repetition.
Page 52.
Page 54.
52.
Page 54, it starts with page 52.
Hmm.
The relevant portion is at page number 54.
Hmm.
Serial number 2. In case of shortage of attendance, schools shall be required to procure the following documents from the students or parents and submit them to the concerned regional office of the board while forwarding the cases for considering condonation of shortage of attendance.
Hmm.
Now, valid reason for condonation of shortage of attendance, prolonged illness.
Hmm.
Mandatory documents, requests from the parent, medical certificates for the period of absence from a government doctor, all medical reports or x-rays, etc. Recommendation of school in the pro forma attached. So this was not given by the parent because all he can do.
Only
was
one is not complied with.
medical documents.
Medical certificates for the period of absence from a government doctor.
Government doctor.
Otherwise, medical reports are given.
There, but in none of the medical reports, it says that he requires bed rest. He cannot attend classes. That is the we are asked.
For eye issues, one need not go for bed rest,
That's right.
but rest for the eyes.
That's right. So that, of course, that is not mentioned in any of the because all of these are prescriptions, Your Lordship. All of these are prescriptions. As I have been instructed by the principal, all of these are all prescriptions, but none of them said that he cannot attend classes for continuous period. He could attend classes. It is not that he could not attend classes for 6 months straight, wherein his attendance falls short to 49.33%. It is not that. So our case is basically our stand is basically if he was actually directed to take bed rest or say suppose he could have actually submitted some documents just by in a peaceful manner. If he submits some medical document saying that this is a prescription, I cannot attend classes. This will actually set a bad precedent, Your Lordship. Because tomorrow everybody will give a prescription and not come to school. And this actually destroys the whole culture of a particular school.
What were suggested for him to take eye drops?
Eye drop.
On page 28, this is the certificate my lord, private doctor.
28.
28.
Yes, this one I have seen.
Yes, 28 also, 30 also.
31 also, 30 same type of it. It says.
It is
he
an
gave
admitted fact
constant
that
follow
I was
regular
stated in
treatment.
Hyderabad, I was stated in Kolkata, Bangalore,
So
September.
he, and this certificate is of 31/1/2026. After attendance fell short, everything fell short.
No, I have seen a few documents relating to the year 25, 24.
But
Case
none of
47.
those documents, your lordship, if your lordship peruses through those documents, none of those documents say that he requires bed rest. These all certificates are after his attendance fell short in 2026. Because page 31 is of 2026.
No, this is
Case
2026.
47 of.
But go to the other 7 to 26. Okay, that also can.
47, my lord.
The
case 47.
page 32, you see, this is 22nd of June 24. This is the beginning of his, this is by Chaudhary Eye Hospital Research Center.
But mentioned, your lordship, that he requires rest or he cannot attend classes.
Spectacle prescription and eye drops.
Spectacles, your lordship, everybody nowadays produce this kind of.
Allergic conjunctivitis. Refractive error. What is refractive error?
The number of medical documents, my lord, for last 2 years.
Refractive error is what? Allergic conjunctivitis. Hmm. Cerebral gigantism. What is all these terms? I don't know. Just see in the mobile. Cerebral gigantism. This is in page number 35, you see? Page 35.
Yes, I've seen that.
Ayushman. Diagnosis is cerebral gigantism. Autorefraction. Have you got it? Cerebral gigantism.
A rare genetic disorder characterized by excessive physical growth during early childhood. Children typically.
Genetic disorder, not
Genetic disorder.
not related to
Not related
eyes.
to eyes. Children typically experience a rapid.
But
growth
in
for-
case this is eye only.
It might affect the eyes also.
Hmm.
So it's called a Sotos syndrome also, which actually has effect on the physical, neurological development traits.
Not a very simple disease, Mr. Bora, no?
This is a genetic disease.
My lord, refractive errors are common as per vision problem that occurs when the shape of the eye.
Even if
light-
the 25% relaxation is given, it will not come to 75%.
Less than 1%, 0.33%.
And that is, if it is less than 1 or 20%, same things it comes, it less than
Special
75.
case, my lord, as a special, that may not be a precedent, my lord, as I request them to order whole year he will losing his year.
A young boy having eye problem,
why
parents will definitely be scared, he might get
Because
blind at times.
The
So,
parents, his father is a doctor, lordship, in the professor in the
The same
Silchar,
campus.
same campus, lordship. They have never informed the principal also regarding his eye problem. Later on, when he has got the shortage of
Okay.
attendance,
the school days, while applying for leave, you have to give an application, right?
leave,
Those
lordship-
applications were not given.
no,
Before taking
No,
leave,
No, that is why.
he simply did not attend.
Later on, all the certificates came out.
when he came to know about the shortage of attendance, he was not allowed to sit in the
And he
examination.
But you are not questioning these certificates, right?
We are
Authenticity?
questioning, your lordship. That is why
Because
we are
the
asking for
principal will
document.
ask.
That's why I could not recommend his case. The principal.
See, even
recommended
mental
that
health,
SOP.
even the mental health was checked of the boy. Page number 42.
That happened in Nimhan side, perhaps.
Huh.
Bangalore.
Name Hans. So it's not a case where he simply did not attend. He had these problems. Okay, he did not inform in time.
Everything is
And
there,
when it was known that he won't be able to appear for the examinations, he had given it.
Just
It
now,
happens.
2
We
days.
will make it peculiar to this case. The other children will have to again establish their own cases.
Yes, that is true.
Yes.
But
Why? He has given his examinations, his results isn't kept in seal cover. Okay. Heard Mr. Sharma. You Sharma
And Sharma.
and Sharma.
But this
Learn-
will not be a precedent for.
Ah, it will not be a person. Yes. Yes, yes, yes. The other children will have to come.
Yes, yes.
Kika, you,
And Sharma.
and Sharma, learned counsel for the petitioner, and Miss R. Bora, learned R. Bora, right? Learned
Standing council for CBSE,
or learned standing counsel for CBSE
1 and 2.
and Mr. Bora only. D. Bora. There are so many Boras in the government advocates for respond number 3. By this application, wait. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent authorities to consider the case of the petitioner. Here, petitioner number 2 is the son, right? The candidate. Sonali Dey is the mother.
Mother. They
By this application filed under so and so, no? The petitioners have prayed for a direction to the respondent authorities to consider petitioner number 2. Petitioner number 2 for his appearing in the 12th examination,
Class 12 science.
class 12 science examination, 2026, by condoning the shortage of attendance which was due to the medical ground. It is the case of the petitioner that petitioner number 2, after passing his 10th examination from the said CBSE school, which school? CBSE what? From CBSE?
Kendriya Vidyalaya, NIT.
From Kendriya Vidyalaya Sangathan, what?
NIT Silchar.
NIT Silchar. After passing out his 10th examination from Kendriya Vidyalaya Sangathan NIT Silchar,
Kendriya Vidyalaya, NIT Silchar.
suffered from eye issues. Full stop. The petitioner had annexed with this writ petition the prescriptions given by the various doctors from different hospitals. It is stated by the petitioner that petitioner number 2 is suffering from myopia with squint, SQUINT, with squint. That is an acute eyesight divergence problem. An acute eyesight divergence problem for more than a year. Full stop. He states that his eye issue was first diagnosed in December 2024 in Narayana Netralaya, Rajaji Nagar, Bangalore. And thereafter, the petitioner, number 2, has been treated in different hospitals, including Sankara Netralaya, New Town, Kolkata, as well as in other hospitals. But it is stated by the petitioner that his eye problem had not improved and is still continuing. Petitioners also states that petitioner number 2 was not only suffering from eye problems but also had other problems with ear, nose, throat and lungs, which required treatment, and for that, the petitioner number 2 was taken to various hospitals within the country. The learned counsel for the petitioner submits that submits that that the parents of the petitioner number 2, that is both petitioner number 1 and his father, had intimated the principal of the said school on various dates, one being 25th of June 2025, intimating the problems faced by the petitioner number 2 with regard to his eyes and other issues. Petitioner number 1 wrote in the said letter that petitioner has been suffering from increasing eyesight issue since COVID-19 period, and that his vision rapidly deteriorated and he developed a squint. It was also stated that petitioner number 2 had developed symptoms of derealization, which implies that the petitioner at times fails to process whatever he sees in his brain, which had affected his memory and comprehension during class sessions. It was also stated that petitioner could not see the blackboard properly for intervening periods, and that he had eye pain and other problems. As such, petitioner number 1 had requested the principal of the said school that petitioner number 2 had missed several school days, and that however he was studying at home and is competent and is committed to keep up with his syllabus. Petitioner number 1 had further requested the authorities to consider his attendance sympathetically and grant him leaves as per the medical records. Where is the other? Yes. The father had also written. Where is that? Similar, full stop. Similar letters to the principal was also written on 22nd of December 25 by petitioner number 1. I've seen father also writing something.
Page 58.
58, right? Yes. As well as letter dated 2nd of February 2026 by the father of the petitioner to the principal of the said school.
Page 62 also by the father.
Further, point, full stop, further by letter dated 10/2/2026, the father of the petition had also requested the regional director, joint secretary, CBSE, to condone the absence of attendance, to condone the shortage of attendance of petitioner number 2 due to the eyesight problem. In the said letter, the father of petitioner number 2 had specifically mentioned that petitioner number 2 is suffering from a prolonged illness since December 2024 and is being treated in various hospitals. The learned counsel for the petitioner submits that as per this is what? This is regulation by the CBSE or what?
Yes, CBS, yes,
Page 52. This is a
SOP.
SOP to the principals has placed the instruction given by the controller of examinations. Kikolo, he states, submits that the instructions given by the controller of examinations to the principals or head of the schools affiliated to the CBC provides that a minimum of 75% of attendance is mandatory for the students for appearing in the board examinations. And it is further provided therein that board can offer 25% relaxation in cases of exigencies such as medical emergency, participation in national and international sports events and other regions. As such, he submits that since the petitioner has been suffering from a prolonged illness with regard to his eyes, petitioner number 2, eyes, 25% relaxation in his attendance may be should have been granted by the authorities concerned. And the petitioner number 2 should have been allowed to appear in his 12th examination. Since it came to the knowledge of the petitioners that he will not be allowed to sit in the examination, the petitioners filed this writ petition before this court. And this court, by order dated 17/2/2026, by ordering in, no, where is that? To make him sit in the examination?
In the interim order.
Be not deprived of an opportunity, right?
Yes, ma'am.
In view of the fact the examination order is already underway and
Paragraph
first paper
10.
is scheduled on Iman 22/2026. This is when? Order is 17/2.
17/2026,
Consideration of
paragraph 10.
appeals and noticing the variance are regularly updating for absence of additional. Yes, কি কলো by an interim measure বুলি কোৱা. This court by order dated so and so as an interim measure, not as an interim measure, right? This court by order dated so and so had directed, and this court had observed that on the materials brought on the record by the petitioner number 2, and by noticing that parents of the petitioner were regularly updating the respondent authorities about the reason of petitioner number 2's absence in the school, the petitioner, this court by the order dated so and so observed, no, so and so, comma, the petitioner should not be deprived of the opportunity to appear in the class 12 examination. And in view of the said order, petitioner number 2 was allowed to sit for the examination, for the said examination. Thereafter, full stop. Thereafter, by a subsequent order dated 24/4/2026, this court directed the authorities to allow the petitioner to sit to appear in the what? Allow the petitioner number 2 to sit for his practical examination
For chemistry.
in the chemistry paper with the further direction that result of petitioner number 2 should not be declared. Results including the result of practical examination. Results including the results of the practical examination shall not be declared and be kept in seal cover. The said orders were made for the benefit of the petitioner number 2, so that he doesn't lose years. The learned counsel therefore submits that the petitioner number 2 had appeared in his examinations and his results are kept and his results are not declared and are kept in a seal cover. The learned counsel, Ms. Bora, learned standing counsel for CBSE, submits that as per the instructions given by the controller of examinations, the student as per the instructions given by the controller of examinations, it is provided that the illness stated by the student should be of prolonged nature, and the medical certificates has to be given by a government doctor, and a request should also come from the parents. The medical reports should also be given to the authority concerned for relaxation of 25% of attendance in case the student falls short of 75% of the attendance. In the instant case, she submits that neither the petitioner to himself nor his parents had intimated the authorities in time along with the medical documents, showing that petitioner number 2 has been suffering from a prolonged illness. Mr. What Bora? D. Bora, learned counsel for respondent number 3, also supports the submissions made by Mrs. R. Bora for the standing counsel for CBSE, and further submits that in the medical certificates annexed by the petitioner, it does not show that the petitioner was either suffering from prolonged illness or that he is advised for bed rest. The learned counsel as such submits that there was no valid reason for his absence from his school for such a long period. His attendance being how many, what percentage?
49.33%.
His attendance being 49.33%. Full stop. He submits that even if 25% relaxation is given Still, it does not come to 75% of attendance in respect of the petitioner number 2. Para. Although it is, I have heard the counsel, sir. I have gone through the reports. It is seen that the petitioner had his eyesight problem from December 2024. And he was first taken to the hospital at Bangalore and thereafter to different hospitals in the country.
Including government hospital, and paragraph 118, I have given the list 118.
Paragraph?
Page 118,
Page 118.
the affidavit in reply. During the season 25-26, the petition number was treated in the following hospital.
In the country, boli kolu na?
Including government.
Wait, 118, I'm not getting only. Acha, acha. Your reply affidavit.
Yes.
Okay. Yes. Yes, in different hospitals, such as Nemhans, an hospital run by the central government, comma, Indira Gandhi Institute of Child Health, again a government hospital, comma, SMCH Silchar, comma, government hospital, again, Narayana Netralaya, Bangalore, Sankara Netralaya, Kolkata, Chaudhary Eye Hospital, Silchar. Any documents from government doctor here that you have annexed? So please see. So it's
On the prescription they have annexed.
Prescription is there, my lord. Page,
the
but
prescription
no
will do.
certificate, no certificate.
page 39, the National Institute of Medical Health, Neuroscience.
So it's amongst full stop. Amongst the said hospitals, many hospitals were government hospitals, and prescriptions from the government doctors were also available on records. It is also seen that the parents of the petitioner had given applications to the principal of the school where the petitioner was studying, where petitioner number 2 was studying, on various dates during the year 2024 as well as 2025. The father of the petitioner was also seen to have written a letter to the regional director of CBSE for condoning the attendance of his son, that is petitioner number 2. Oh, point error. গরম দিবেন হ্যাঁ বেসিকে and full stop, the instruction issued by the Controller of Examination on 4/8/2025 shows that although mandatory requirement of attendance for a student is 75% for appearing in the board examination, however, the board can relax 25% in case of medical emergency or other reasons. And in the SOP, it is further provided that in case of shortage of attendance, schools are required to procure documents from students or parents and submit the same to the concerned of regional office of the board for condoning the shortage of attendance. Full stop. It is further provided that the said condonation would be done only in case of prolonged illness. And for that, 4 conditions were provided for. One, and they are request from the parent, comma, medical certificate by a government doctor, medical reports, and the recommendation of the school. In the instant case, the first requirement, request from the parent, is present since petitioner number 1 as well as the father of petitioner number 2 had written to the principal of the school as well as to other authorities, both other authorities, both for the year 2024 and 25. The second criteria, that is medical certificate from a government doctor, is, however, could not be placed by the petitioner or his parents, but the prescription by the government doctor is placed before this court. And the information that the petitioner number 2 was under the treatment of government hospitals was informed to the principal of the said school. As far as the third requirement, the medical reports, the same are in place before this court, as well as before the concerned authorities. Recommendation of school is not there, right? School has never recommended. However, the fourth requirement that school has to recommend is, however, not present in the instant case. It is full stop. It is the case of the petitioner that petitioner number 1 and the mother of the petitioner number 2 had written many letters to the principal of the said school, and it is not known to them as to whether principal has written to the regional office of the board for condoning the shortage of attendance. It is further seen that the father of petitioner number 2, while intimating the Director General, intimating the regional director of CBSE, had stated that petitioner number 2 was suffering from a prolonged illness, as could be seen from his letter dated 10/2/2026. In view of the same, it is seen that in the instant case, 25% relaxation can be granted by the board by taking into account the medical emergency of the petitioner number 2. Full stop. It is, however, seen that even after granting 25% relaxation, the 75% attendance will not be reached. Full stop. It will full stop. It will be s- it will be 15 days short of 15
0.67%, 0.67%.
15.67.
Only 0.67.
Oh, 0.67. 0.67, 0.67.
Yes.
It's only 0.67 lesser than, it will be only 0.67% lesser than than the required 75% of attendance.
No, 50%.
50%.
After relaxation of 25%, then it should be 50%, but less than 49.33%.
No, it is his, total attendance is 49 point something percent.
49,
So if we give 25% relaxation,
then it will be 40.
It will be 74.33%.
huh, 74, so 0.67 less than 75%.
Yes.
That I've dictated it, okay. 0.67 less than 75% of attendance. Seeing the medical emergency of petitioner number 2, and also taking into account the fact that he has been studying in the said school since class 1 and had passed his class 10th examination with flying colors, the board is directed to condone the attendance of the petitioner, condone the absence of the petitioner,
Shortage of attendance.
or condone the shortage of attendance of the petitioner as an exclusive, as a peculiar case, and declare the result of the petitioner, both his physical, no, not physical, both his practical and
Practical and theory.
theory. Both his theory, I've crossed my school long time back now, so I forgot this theory, practical. So, okay, both his theory and practical examination, which is kept in a seal cover at present, at this junction. The said order is, however, peculiar to the facts and circumstances of the instant case and will not be considered as a precedent for any other cases. Petition is disposed of. Any other direction?
That may be declared by tomorrow. Or
Declared.
Declare.
To be declared forthwith. Forthwith.
Because after their notification obtaining for answer script. after
Forthwith,
declare-
forthwith.
Then I may be allowed to, if I am not satisfied with the result, there is a provision for application of answer script for re-evaluation. That may be kept open.
You
because-
are an intelligent student. You will not be
My-
appearing for.
because Today is the last date for application. for
Considering his
submitting the
result in
answer script.
alia examination.
Today is the last date.
Today is the last date for obtaining answer sheet, 19 to 22 May.
As the
And
matter was subject
submission
is before your
application,
lordship, then
submission of
definitely.
application for.
Okay, to
re-evaluation
DD at a
is
line at a DD. Declaration of result forthwith.
Yes.
However, if some further exercise is required after seeing the result by petitioner number 2, he will be allowed by again condoning what?
No,
By
my lord, if he is not satisfied with that, there is a provision.
Ah,
for
he will have to
rechecking the
re-
sheet.
appear for,
Rechecking the
oh,
answer sheet.
re-evaluating his marks,
Rechecking,
Rechecking.
rechecking.
rechecking. So if, oh, acha, acha, chitala likha that if after declaration of the result, if the petitioner decides
That how it-
for any re-evaluation of his marks, the same should be allowed. The same shall hear what I dictate, otherwise again, there will be
Yes.
some mistake. What I have said is after declaration of result, if the petitioner feels that some paper has to be re-evaluated, then the same should be allowed.
Within one.
Although, in spite of the fact that the period will
Last
get
date.
over, or what?
Maybe
Last
one-
date.
Last date is for obtaining answer script. Today is the last date as per prevailing
Um,
condition.
it will be allowed for
No, no, I have
re-evaluation.
no instruction regarding this, but he's saying.
Okay, will be allowed for re-evaluation within a reasonable period of time.
10 days.
He will be allowed. Okay.
Of-
Ah,
and pass-
okay. In view of the order passed in a writ petition, I stands disposed of.
Obliged.
All right, take this. What is this?
Your Lordship, the attendant father similarly situated is.
Oh, yes, so, oh, this is what. Yeah, Judidia. It will not be considered, precedent. They will not. be. Look, gone, this is Mukaddume. Mr. Ayat Sakia, you had given me some decisions. You can take this back, huh? Hey, did you on Ayat Sakia? Yes, yes. This is upgraded again.
Student madam.
Mm-hmm.
Petitioner Malad is a student of sixth semester, the Royal Global University, Biology Department,
Zoology.
Geology.
Hmm.
He's a very meritorious student for
Yes.
very meritorious student since matriculation. What happened on
He's studying at what college? Which year? With what stream? What?
sixth semester, final semester of BSc course?
BSc.
BSc man. Royal Global University.
Graduation.
Graduation.
Hmm.
On 24th of March, my lord, a clash took place between two group of students, my lord. Wherein the petitioner also received injury.
Petitioner also participated. What?
Obviously, the petitioner was also there. He received injury. He was hospitalized.
Yes, Mr. Bhuya.
Lordship, Global University not represented now.
Who is there? Rakhi Chauratia? No. Who appears for Global University?
3 and 4, they have filed affidavit, Lordship. Their presence is required, Lordship. Because of upgradation, maybe they could
No,
not.
affidavits are not filed.
Affidavit has been filed by the university.
Affidavits filed by
University.
university.
Global University.
But then-
my lord, here the basic issue is here, my lord.
But then that's not on record. Record. What is this? Ibrahim Hussain, this is affidavit in opposition by 3 and 4.
3 and 4.
But then let the council come, call the council.
My lord, here the issue is, my lord.
Call the council. Who appears for 3 and 4? Wakala Nama is fine.
My lord, I may continue my submission. So here the issue is, my lord, the petition has been rusticated from the university, my lord, without issuing any show cause notice, my lord.
But what about councils for 3 and 4? Can I hear you in their absence? It will be waste of time. Who? Who is the council, you know? Notice is served, Wakalar Nama is filed. Huh? It will be in the other file again.
He will come within a minute, my lord.
But provided you give, you send them the information because it is taken out of turn.
Yes, ma'am. Already information has been sent, madam.
Information is sent. Who? Who's the council?
Yeah, that's.
J. Das.
The cause list also, my lord, his name is there. Already he is coming, my lord. Already. So here the issue is, my lord, only two issues, my lord. The one issue is that, my lord, my case is that, my lord, I have been terminated from the university, rusticated from the university without issuing any show cause notice. On 24th of March, a clash took place between two group of.
You were injured.
Petitioner also injured and the other student also injured. Malade, what happened, my petitioner is a senior student, my lord, of sixth semester, final semester. While he was coming out from the practical exam, my lord, a group of junior students, they were standing outside. After noticing the petitioner, they insulted the petitioner, my lord. Then obviously, my lord, they are very young boys, my lord. Then when the petitioner approached them, my lord, ultimately some argument took place. Then petitioner was assaulted by them. Then again, the fellow of the petitioner came, and ultimately some injuries was there on both sides. Petitioner was also hospitalized. FIR was lost from both the sides in the police station. What happened? Both the sides amicably settled the matter and withdraw their respective FIR. Nothing more. Both the group of students, they resolved their issues amicably. On 25th,
24th, that incident
24th
occurred.
incident.
You are appearing for global.
Yes, sir.
Oh.
On
Ready?
24th, on 24th, incident took place. On 25th, petitioner was suspended by the university. On 27th, after 2 days, he was rusticated from the university without issuing any show cause notice.
Now the issue is, my lord, before lordship, that the action taken by the university without hearing the petitioner, without issuing any show cause notice is arbitrary and illegal. That is my submission, my lord. First thing. Second thing, my lord, the petitioner is a
Under the global university has their own rules.
Yes, lord.
There is a rule, so that firstly, they have to answer whether it is.
So let me finish
My lord.
here.
Now I'll also answer here. And secondly, my lord, their exam is scheduled from 29th of March, my lord. Only three working days are there, my lord. He's a very meritorious student.
29th of March.
29th of March.
So it is over by now.
No, May.
Oh, May.
May.
Acha.
Only 3 working days are left. And in the item number, in the next term, he is also the same student, my lord. He's also but he's a junior student of 3rd semester. The issue here is, my lord, they are contending that the Royal Global University is a private university. A rate court cannot issue the rate against a private university. That is their condition. And I'll satisfy the court. So here the first,
And also 311 will not come.
Yes.
Giving you notice, hearing you.
My lord.
Those things will also not come. Then you proceed. Then
My first submission is a rustication order passed by the university without following the due process of law, without issuing any show cause notice or without hearing the student, but it is arbitrary and illegal. And secondly, a private university also imparting education deemed to be a public authority because the imparting education is a public function, my lord. Any person or authority imparting education will come within the purview of Article 226 of the Constitution for the purpose of issuing a writ, my lord. And in this respect, my lord, I have also one judgment of the Honorable Supreme Court, and the Honorable Supreme Court said, my lord, clearly that even a private educational institutions imparting education will come within the ambit of Article 226, my lord. Because Article 12 defines the state only for the purpose of enforcement of the fundamental right. The definition of state under Article 12 and the definition of authority, public authority or any person or authority under Article 226 is different, my lord. Because apart from the fundamental right, Article within the under Part 3 of the Constitution, a writ court under Article 226 can also issue, a High Court can also issue any other direction or order also, my lord, apart from the fundamental right, my lord. So that is why, my lord, the contention of the respondent, the university, my lord, that the university will not come under the ambit of 226, my lord. It is not, my lord, sustainable, but I'll place one judgment of the Honorable Supreme Court, my lord, here. My issue is very simple issue, my lord. They are a student, my lord, for the interest of the student, my lord.
I have heard you.
They have to be considered, my lord.
Your, I don't know, first ground is that without hearing you, putting you on notice, they have terminated.
Yes, madam.
The word termination is the right word or restricted, restricted?
Rusticated, madam.
Rusticate is a
Rusticated
word.
means completely rusticated, and he has not been allowed to, my lord, he will not be allowed to appear in the examination or neither to appear in the classes.
His previous 5-year course will also go.
Will all go, my lord.
And the second ground is your?
And second ground, my lord, this is the first ground, and my answer to their query, my lord, that the Royal Global University is a private educational institution.
They are amenable to other rights, if not fundamental.
Yes, madam.
Then, these are the two.
These two grounds.
Let me hear them.
My lord.
Yes.
My lord, I'm placing one judgment now. Here, Honorable Supreme Court say, madam.
First of all, Lordship, this is.
Just let me see the judgment.
Judgment is clear.
226.
Writ is maintainable if there is a violation of natural justice. Since the private educational institutions also provide education, so therefore it is amenable, subject to condition that there must be violation of natural justice. My second ground is that the regulation provide that in against the order passed by the disciplinary authority, appeal lies to the Vice Chancellor. By bypassing this, they have filed a straightway district petition.
Why do you come to?
But I have annex.
In fact, we have got a communication from all these appellate authorities that why the High Court entertains.
Yes.
They should send it back to Assam Administrative Tribunal. Tribunal.
My lord,
So if we keep on entertaining all these applications, what will happen to the appellate authority?
My lord, very sorry to say university, my lord, imparting higher education in the state, my lord. The parents of the student also came to me. It is very sorry to say, this is a very, my lord, I cannot say, use some word here. That even the parents were also not allowed to enter the campuses, my lord, by the security guard, my lord. Very sorry to say, my lord.
For security reasons, because
This is the discipline of the university.
That is not correct, Lordship.
This
That
is
is
the
a
standard of the
correct-
university, my lord. Even the parents were not allowed to enter the campuses, my lord, by the security guard, my lord.
it's okay for security reasons.
If-
Royal Global
What-
School
what
is a,
reason, my lord?
Royal Global School has made a mark.
Educational institution.
There is no pleading, Lordship, out of pleading.
It's like,
how he-
those are not required to be.
Secondly, my lord,
Only what paragraph is your
the
judgment?
representation has been submitted by the, to the register, my lord. That representation has not been considered, my lord. And that representation, my lord, may be treated as appeal, my lord. Representation made to the register because there is no format of appeal, my lord. So representation made by the student before the authority, before the register of the university.
No, you should have gone to the Vice Chancellor.
Vice Chancellor, Lordship. And no
Giving a
represent-
representation to the registrar is not provided for. That you can do, but
Yes.
file an appeal before the Vice Chancellor
My lord,
as per the regulation. Why to
Even-
High Court?
even bypassing the appeal also, that the regulatory appeal, my lord. Even the read court also, my lord, can attend the read and pass the.
Of course,
Because
read court,
the-
alternative remedy will not bar. Alternative remedy will not bar the High Court to take up matters. But why not? In exceptional matters, it will take up. But why not appeal before the appellate authority? You go before the appellate authority. If they rejects, come here.
Only, my lord, 3 days are there, my lord.
No, Lordship. Exam will have
My lord, already, my lord.
June, Lordship.
No, my lord,
Not in March. He says that in
already,
28.
my lord.
May.
Already, my lord, a cert has been published by the university, my lord. This cert will show, my lord, the practical exam will start from 29th of this May. Only 3 working days are there in between, my lord. Today is 22nd, my lord. Tomorrow and day after tomorrow are holidays. 25th, 26th, and 28th, my lord. Only 3 working days, my lord. And already representation has been submitted to the register, my lord, and he has not.
When did you file this petition?
My lord, I filed this petition, my lord.
You had not paid Royal Global a party initially.
Yes,
Then you
Initially not met
impleaded it.
party.
Huh?
Initially not met
Initially-
party.
Not paid a party. Then
Yes.
you impleaded.
Yes, Lord.
Initially, my lord, the register Royal Global University was made a party number 3, my lord, restaurant number 3, my lord. But
Huh?
at the advice of the honorable court, my lord, at the direction of the honorable court, my lord, I made the restaurant number 4 as a party subsequently. And secondly, my lord, this application was filed on 20th of April. And my lord, initially, my lord, since there was available time because the exam was scheduled to be, my lord, commenced from the month of May. So honorable court was, my lord, was of the opinion that the other side be heard at the initial stage. So accordingly, my lord, notice was issued, trustee notice was issued, my lord, steps was taken duly. And consecutively on the last 2 dates, my lord, matter was listed, but could not be, my lord, but on both the days, my lord, matter was late.
Okay, one thing can be done. I will direct you to sit in the examination, but then you appeal before the.
Yes, my lord.
You appeal before the
That may be done.
Yes, yes.
Vice Chancellor.
Because there are 4 students restricted, but due to their behavior or long standing, they
Hmm.
frequently started quarrel with their junior colleagues in the outside the university campus. Lots of complaint has been received against these students. And on 24th, and a student has lodged a complaint before the authority stating that he was grievously injured. Even seizure attack has come. This petitioner has attacked him outside the university campus. He was hospitalized. Then
Outside the campus.
Yes, then and the FIR was also lost. So thereafter, the university constitute a disciplinary committee. Disciplinary committee call all the stakeholders, including this petitioner. He personally appeared, where they have stated that they will not do anything in future such type of activities. Thereafter, they were asked to submit an undertaking to that effect. On the very day, evening, he again assaulted some students.
So
No, my lord, this part.
I have given this medical report also, FIR
he will
also.
not state incorrect statements.
No, my lord.
Huh.
So for the petitioner attacked those.
No, let me hear him finally then. He
Yeah.
again attacked.
He again attacked evening. In such circumstances, again the university urgently called him and his parent, but they did not appear. Thereafter, for preserve the peace and tranquility in the hospital and the hostel, so he has to rusticate it. And
Mm.
he along with three others. Antisocial activities he involved outside the university. So there are lots
He
of.
is of what age?
He's a sixth semester of zoology department.
But admittedly, he has been indulging in these
Yes,
fights
Lordship, that
off and on.
the inquiry committee.
This time it was done. It was okay. It was
Minute of the
considered by
meeting
the
I have annexed,
authorities.
Lordship.
Hmm?
Minute of the meeting, first meeting, he is present, where minute was signed. On that day evening, he again started with
He
the,
cannot control himself.
yes, Lordship.
Now, my lord, so for my.
So you proceed, you appear before the appellate authority.
Yes.
In the meantime, whatever examination, I'll tell you to allow
Yes.
them to allow you to sit in the examination.
Yes, ma'am.
Hmm.
And then you appeal, but then your results will not be declared and all.
Until and unless.
It will kept in a seal cover.
Yes.
And if it is required, it will be it will be declared. And if he is found doing
Otherwise
wrong
also
things.
he cannot appear because his attendance is very low.
Hmm.
As per the regulation, 75% is required.
Hmm.
He has 60%, another petition has 26%.
Then in that case, I cannot allow you to appear also.
No, that is a different issue.
Even after condoning, I don't think so. He'll attendance will reach 75%.
Yes, Lordship. I have annexed. He has 60% only.
25% relaxation or what?
No relaxation, as per the regulation.
No relaxation.
No relaxation, Lordship.
It can be given by the chancellor if required. No, chancellor will hear his case
Yes,
and will decide
yes,
either in his favor or not.
yes,
He can also uphold the
yes,
termination part.
yes, yes.
But if the exams are in 3 days time,
Yes.
then let him appear
As
in.
per my instruction, exam will be start in the month of June.
No, my lord, this is the schedule, my lord, schedule of the exam.
Sixth semester will go.
Okay, heard, Mr. You are Mr.
MA Islam, my lord.
M.A.
Islam.
Islam. It
Yes.
is what number, no? It is what number? It is what?
PG and PTC.
57.
29.
Okay, heard Mr. M.A. Islam. M.A. Islam.
MA Islam.
Learned counsel for the petitioner and Mr.
Yes, sir.
S. Deca.
Yes.
As Deca, learned standing counsel for Global University. Global?
Royal Global University.
Royal Global University. By this application, filed under 226 of the Constitution of India, the petitioner has prayed for quashing of the impugned order dated 27/3/2026. I have not seen any papers. I've just
Yeah.
heard you, and 27/3/2026 issued by respondent number 3. Rusticating. That's a proper word, right? Rusticating. We used to hear this. He has been rusticated.
Yes.
I used to, what kind of, I've never checked. Rusticating the petitioner from the Assam Global University.
Yes.
Royal Global. Assam Royal Global University. With the further prayer for allowing the petitioner to appear in his final 6th semester examination of the BSc course in the said university. It is the case of the petitioner that he is a highly meritorious student and had passed his secondary education examination in 2020 with 88% marks and senior school certificate examination in 2022 with 85.6% marks from the CBSE. It is stated thereafter that petitioner took admission in BSc Science, in Bachelor of Science, Zoology Department in Assam Royal Global University. And that presently he is studying in 6th semester in the said course. Full stop, para. It is stated by the petitioner that on 24/3/2026, in the evening hours, in the evening hours, there was a group clash No, no, group class now. Huh? In the evening hours, while the petitioner came out of his practical classes, a group of 10-12 junior students were seen gathering in the university campus and started abusing the petitioner. And when the petitioner approached the said students, the said students attacked him. And as a result, attacked him. And it is stated that some students also went to rescue the petitioner from the clutches of the said attackers. And that in the process, the petitioner and others got injured. The learned counsel for the petitioner submits that the petitioner was thereafter terminated and was rusticated without giving an opportunity of hearing.
What termination we cannot use, you are suspended and rusticated.
Termination alai there. Suspended and rusticated.
Initially suspended.
By not giving an opportunity of hearing, and neither any show cause notice was issued. Full stop. The learned counsel as such submits that natural justice was not complied with, and the petitioner was rusticated. Full stop. He further submits that the examination for the 6th semester is proposed to be held in the end of this month.
No, we'll start from 29th of May. Please.
The final examination of the 6th semester is supposed to be held on 29th of May,
We'll start from 29th of
2026. And that if he is not allowed to sit in the examination, then his entire career will be frustrated. For full stop, para. Mr. Das, right? Decca.
Yes.
Mr. Decca, learned counsel for the university, submits that petitioner was found indulging in violent activities not only once but twice, and that after the first instance where the petitioner was found fighting outside the university campus, he and his parents were called by the university authorities, and after due deliberation, the petitioner was supposed to give an undertaking that he will not commit such activities in future. But on the date when he was supposed to sign the said undertaking, the petitioner was again found to have indulged in another fight, no, in another
Incidents of fighting.
another incident of assault outside the said campus. And that the authorities had called him and his parents, but neither he nor his parents went and met the authorities. Full stop. As such, the university authorities were constrained to rusticate the petitioner from the college.
University.
Para. It is not in dispute that the petitioner had appeared fairly in his examinations during his career, and that he obtained good marks in other semesters of Bachelor of Science in his zoology department. But due to his behavior, he was rusticated from the college Full stop. It is also seen that petitioner was given an opportunity during his involvement in the first instance of assault between groups, and he was called to sign an undertaking, to give an undertaking, to give an undertaking not to indulge in similar activities in future. But then he is again found indulging in the same. Full stop. Even then, he was called by the authorities to explain his conduct, but he did not appear. Neither his parents. Parents out of shame did not come, no?
Yeah.
But he did not appear. Don't write about parents, huh? The learned counsel for the university made a further argument that under the rules, under the regulation,
Under the manual, Lordship, proctorial board manual,
under the manual, namely
proctorial board manual,
Proctorial Board Manual of Global University,
Assam Royal Global.
Assam Royal Global University, it is provided that the aggrieved party can approach the appellate authority for ventilating their grievance.
Yes.
And in the instant case, the petitioner had not approached the appellate authority. As such, this court directs that for betterment of this petitioner, since he is the final year student of BSc course,
Yes.
the petitioner be allowed to appear in his examination, which is scheduled to start from 29th of May,
No, 20, just now I have instruction on 4th of June.
which is scheduled to start
On 4th of.
from 4th of June 2026. And the results or the outcome may not be declared and be kept in a sealed cover. And in the meantime, the petitioner is directed to put his case before the appellate authority. That is what authority?
Vice Chancellor.
That is Vice Chancellor of the Assam Royal Global University, who would decide the case as per law.
And a rider may be given, he will not.
4th June, the theory paper examination will start from 4th June. But practical exam is 29th of May. This is the
Okay, you're right. Which is scheduled to be held
comments from
in the month of May and June.
May.
May and June will go to examination. In the meantime, he will have petition is disposed of.
Lots of a rider may be given during this examination. If he allowed, then again he will not involve such type of incident.
Further, it is directed
Yes.
that if the petitioner is found indulging in similar incident during the examination, the authorities will be at liberty to take any action against the petitioner. Petition is disposed of, huh?
The other item is of the same matter.
But semester is different.
Item 58, madam, the next item. The same issue, but he is a student of third semester.
Oh, yata jo 6th semester is, huh? That is third semester.
He is the third semester.
semester.
His examination schedule is, my lord, it will be 1-2 days different.
Wait, I've also given some facts, no?
Yes, ma'am. Lordship.
Third na fourth?
আচ্ছা প্রথম প্যারাগ্রাফ প্ৰথম প্যাৰাগ্ৰাফত যে দিছো যে হি ইজ মেৰিটৰিয়াছ হি ৰিচিভড এজ দিছ ডেট সেইটো তুমি পিছৰটোত লিখিবা পিছৰ কেছটোত হা ডেট হি ইজ হাইলি মেৰিটৰিয়াছ থাকিব প্ৰথম প্যাৰাগ্ৰাফটো লিখি লোৱাচোন এণ্ড পাছড secondary school in 2021 and higher secondary in 2023 সেইবোৰ মাৰ্কছবোৰ নালাগে হা
Allowed to lordship in this case, the second case, he may be allowed to appear subject to by regulation allowed him because his percentage is 27.7%.
that condonation of Harry is also required
Yes,
right?
yes, lordship. That has to,
It's okay, that will be decided by Vice Chancellor.
yes, yes,
Right,
yes.
that will be decided only for, but this is, the second case is different now.
Different
Because
27.7.
it's sixth semester, last examination, so I have told him to appear.
He's a fourth semester student.
He is a
But then
fourth sem-
again, he will come, I'm similarly situated just because 2 years are yet to go. It's okay, he let him also appear and Vice Chancellor will take. Okay, the first, need to lower hale. Higher secondary in 2023, took admission, or baki to thike hobo. He took admission in Royal Global University.
fourth semester BA Economics.
Or A2 asil third semester, fourth semester.
Fourth semester
BA Economics.
because
BA Economics, zoology type economics. Or A2 fourth semester. Huh. Rest will remain the same.
rest alone.
How about the side? Ekelage dibo. Okay. This is also disposed of. 22. Yes, Mr. Bhia. Last time it didn't reach or what?
My lord, matter is regarding, my lord, provincialization of service in a junior.
You must be an expert in provincialization of service, right?
No, my lord. What has happened? My lord.
He's expert. Uh-huh. I've learned from him.
No, my lord.
I've learned from him. It's long that I've left provincialization and all with Mr. D.K. Mishra.
My lord.
We are only the two tier to get like one Borbuya, Soikia, and Purkasto.
Good, good. We are learning.
No, my lord.
Yes, Mr. In fact, I've learned it from you, DIAS data and all that. It was not there that time
My lord.
when I had started practicing.
My lord.
Yes.
My lord, my case is what has happened, my lord. I am my lord, lecturer in the Department of Mathematics in, my lord, in a junior college in Morigaon district. Now, my lord, my entire exercise for provincialization had been completed, but for certain.
Junior college, government college.
No, my lord, it was when it was in a venture stage. Then this exercise under the 2017 Act had been carried out. Now, my lord, what has happened, my lord, when the exercise was about to complete it, my name and along with the some other teacher's name for some litigations or the other purposes had not been considered, my lord.
Acha.
Now, some of the similarly situated persons along with me, my lord, approached before this honorable court with the prayer that we come within the zone of consideration. So therefore, our services should be provincialized, my lord. Now, this honorable court, my lord, has issued a direction to the authorities to look into the matters and go for the provincialization. But while doing so, in that order, my lord, my name was also there as a lecturer in the Department of Mathematics. But, my lord, unfortunately, I had been dropped. But the other person's services has already been provincialized and they are enjoying the benefits. Now, my lord, when I approached before this honorable court, my lord, with a fresh this writ petition, my lord, then the issue of enrollment had been come up. That the number of enrollment required for the last three, my lordship knows, my lord, for the last 3 years has not meet up the minimum requirement, my lord. That's why, my lord, my services cannot be provincialized. This is a stand on the affidavit filed by the director, my lord. Now, we have come up with a rejoinder affidavit, my lord, wherein we have annexed all the particulars, including the records from the Assam Higher Secondary Education Council, that we meet the requirement of minimum 20 numbers of enrollment in my subject. So therefore, my lord, the stand taken by them is non-esteemed.
The enrollment is bigger than 80.
Regarding the enrollment. The only issue, my lord, that they are saying that there are three numbers of students are there, shortage is there. But the records of the council as well as the records from the college itself shows, my lord, that I meet the minimum requirement of enrollment, my lord.
So enrollment is okay with you?
Enrollment is okay, my lord.
What is the minimum requirement?
20.
20. You
My-
have more than 20.
Yes.
Much more.
I have, my lord, in my rejoinder affidavit, my lord, I have bring all these, my lord. No. Now, my lord, that's
The
why.
case is ready for hearing, right?
Lordship, I have one
My lord.
instruction, Lordship.
My lord, on the last occasion also some instruction was sought for. Then when we produced this, my lord, so they wanted to verify the record, my lord. Now, what is in the verification, I don't know, my lord.
কি আনছে
আচ্ছা আচ্ছা
মানে 19 আছে হচ্ছে
হুম।
আগতে 8 দিলে 8 কে
হুম। আচ্ছা, মানে বাড়ি গৈছে এতিয়া। এজন source দেখাইছে এতিয়া। আচ্ছা। কিন্তু মোৰ যিখিনি ৰেকৰ্ড, ৰেকৰ্ড খিনি আকৌ 20 কৈ আছে।
Oh, it was found 8 in the year 2006.
Originally-
8 number of students.
Yep, originally. Thereafter, after re-verification, it was found to be 19.
19 Milord.
Where is that?
Last but one.
Prefer the repeated whole. Watch it, there are.
Ah,
As per the observation by the High Court in undersigned again requested the Assam State so and so to verify. Accordingly, Assam submitted clarification report. 8. Recent communication shows as 16. And again, if I ask for recommend what instruction, you will come up with more numbers. What is this?
But
It will not become 19. What year? Which year?
that
8 was in which year? 2024?
Yes.
26? Or 2016?
16,
And the report was 23?
23 Lordship.
Yes.
And Lordship, we rely that figure
Ah.
from the either it's SEBA or from the Assam Higher Secondary Education Council report. Lordship.
No, perhaps 8 in 2016.
Lordship.
Thereafter, it increased to 19.
19 Lordship.
Right.
Lordship, next the annex page.
Actually, 8 in 2016 was not the.
Milord, in 2016 also, Milord, I have the, Milord, required enrollment. Milord, if my lord may be pleased to take up my rejoinder.
So
affidavit,
one
Milord.
second. So the instruction is that your enrollment is 19. It should be 20. One is short.
No, Milord, I made the requirement.
Huh.
10, it should be 10.
It should be 10.
But government is requested to re-examine the matter afresh and to
Minimum
issue.
enrollment number should be 10 in each subject, Milord. My lord.
No, his instruction shows
My lord.
that further to re-examine the matter. What happened? You will have further instructions.
No, that is the last instruction.
This is the last
Ah.
instruction.
But the last line of your instruction shows, in view of the facts stated above, the government is requested to re-examine the matter afresh.
Because it is at the disposal of the secretariat level.
Mm.
So director has forwarded this instruction received from Assam Higher Secondary Education Council after re-verification.
Mm.
So government will take a call on the entitlement of the petitioner Lordship, on the basis of this report Lordship.
Achha,
If he is found entitled, his
Huh.
service would be Lordship. to
District
provincialize.
Scrutiny Committee, they don't see this enrollment part.
Normal Lordship, that is the thing Lordship. We have seen relied the enrollment from the report from the Assam Higher Secondary Education Council
Mm.
or the SEBA, as the case may be.
Mm.
Here Lordship, we have relied the report of the Assam Higher Secondary Education Council.
Mm.
So if that report has some,
My
not,
My lord, may I draw my
Mm.
lordship's attention to page 115 of this 2017 Act, my lord? This
Mm.
manual, my lord.
115.
No, my lord, from this manual.
Oh.
The Act statutory prescription.
Oh, Hemenda. দিয়ক না।
দাদা,
ঢুকি নাপাওঁ। এইখনত এই চাইডে নাযায় দেখোন। এইখন চকীত চকা আছে নে? নহয়, নহয়, এইখন ৰঙাখনত।
Lordship, this.
আছে, আছে। আছে। ৰাতিপুৱা চাবচোন এইখন পাৰি নেকি? Yes, what?
My lord, I want to draw my lordship's attention, my lord, to the provision of section 4, starts at page 114 in my book, my lord.
Huh.
And the provisions, section 4, subsection 2, clause 4, my lord.
Hmm.
In case of teachers and or tutors of the schools for the special subjects like Sanskrit, Arabic, Hindi, craft teacher, music teachers and other classical teachers, the number of students appeared in the concerned final examination like HSLC and higher secondary conducted by the SEBA or the, as the case may be, shall not be less than 10 students in each class as per the during last 3 years. So, my lord, these are the
Acha.
conditions which require that the minimum 10 numbers of students should be there in this, my lord, 10 plus 2 category of institutions, my lord.
This is in case of venture educational institutions.
Yes, my lord. Under this act, these institutions had been provincialized, my lord. So therefore, my lord.
But
now-
whether your mathematics will come other classical teachers.
No, mathematics is also there, my lord.
The subject to side of me.
Uh-huh.
Subject to side follow list.
For special subject like
Special
Sanskrit,
subject,
Arabic,
yeah.
Hindi, these are all special subjects,
No,
see,
no,
not the normal.
The present subject mathematics also covers, my lord. It
Where?
is-
With applying the principle of adjusting generous, mathematics will not come.
My lord, my lord.
See, this is music teacher, craft teacher, Arabic, Hindi, language
No, no, my
teachers.
lord, I have missed out this mathematics is also there, my lord. Lord, if we go by their affidavit also,
Hmm.
then it also clarifies, my lord.
Will you look into and come back again or what?
My lord can verify from their affidavit, my lord, the affidavit in opposition filed by them, my lord.
Hmm.
If my lord may be pleased to take up the affidavit in opposition filed by the respondent number 2 director, my lord. wherein,
Page,
They have said, my lord,
page,
my lord,
Ka.
running page starts at page 106, my lord.
huh.
And I am relying at page 107, my lord, paragraph 4.
Hmm. Yes.
That after going through the contention and averments made in the respective paragraph of the writ petition, it is transpired that the petitioner initiated the instant writ petition seeking for provincialization of his service as a postgraduate teacher mathematics in so-and-so secondary school under Morigao district.
Hmm.
In this respect, your deponent begs to state that in the instant writ petition, claim of the petitioner is that he had been working as a postgraduate teacher mathematics in Hum Girls Senior Secondary School under Morigao district, and his name was included in the list along with other employees when the proposal for provincialization of services of so-and-so school under Morigao district was submitted to the Special Commissioner, Secondary Education Department, Government of Assam for creation of post. In this connection, it is to be stated here that during the process of provincialization, the District Scrutiny Committee Morigao had submitted the scrutiny report wherein the name of the petitioner was reflected. Further, as per the recommendation of the state level scrutiny committee, the Director of Secondary Education Assam by letter number forwarded the proposal for the provincialization of services in respect of 13 numbers of teaching staff of so-and-so school. That the deponent further begs to state that subsequently the matter was placed before the government for further.
This has been reflected in the instruction also,
My
right?
lord. And this, my lord may please to find that provision, they have said in page 109.
Hmm.
However, on receipt of enrollment report from the Secretary Assam Higher Secondary Education Council so and so, it was found that the enrollment in the subject of mathematics is 8
Hmm.
in the year 2016, which is below the eligibility criteria as laid down under section 317 of the Assam Education Provincialization of Services of Teachers.
So let us see 317.
Yes, my lord, 317, my lord.
317, yes. For provincialization of one teacher, yes, mathematics, no, Madrasa Venture School, 10, yes, 10 students.
My lord, at least 10 students must have appeared in the last final examination in that particular subject of the institution. So now, my lord, from the very records of the department, my lord, which has come before my lordship's, my lord, it clarifies that 19 numbers is there, so I am entitled, my lord.
So it was 10 and they said it was 8 in 2016. Why 2016? Why is this cutoff here?
My lord, it has been the prescription of the act of last 3 years. That
Oh, last 3 years,
my
yes.
lord.
Wait, let me read 317 once more. Oh, they have quoted also.
Yes.
For provincialization service of one teacher or tutor, as the case may be, in each subject, including the core subject, in case of venture school or venture senior madrasa, at least 10 students must have appeared in the last final exam in that particular subject from that institution. Further, for a maximum limit of 3 teachers or tutors, 3 teachers or tutors in a particular, as the case may be, in case of a venture degree school, 15 students in that particular subject must have appeared. Final examination. So, in a particular subject, even 3 teachers can be provincialized, right?
My lord. No, my
But
lord,
then
this is-
students has to be 15.
No, my lord.
But your case, only 1.
No, my lord, this is a junior college, my lord. So therefore, subject-wise provincialization provision is there. Now, I am the only teacher in mathematics, my lord. So therefore, there are no other, my lord, income.
So the requirement is 10, Mr. PP Datta. Now that it is
Yes,
19.
19.
19 for 3 years, right?
Yes.
Whether it is for 3 consecutive years.
My lord, we have also annexed the records, my lord. From the council as well as. the
Shows
college.
as 19. 2026. So
That
chart will show.
no, chart will not show.
No,
Look,
no,
that next letter dated 14/5/2026.
Where? This instruction,
Yes, the last page I think got
last
missing.
page.
Does he got it? Yes.
Letter dated 14/5, yes.
Got it.
With reference, I am directed to inform you that 19 students appeared in HS final examination 2016 from so and so. But what about 3 years?
That instruction, Lordship.
No, my lord, that instruction I have, and we have, in our, my lord, rejoinder affidavit has, my lord, annexed all the records pertaining.
No,
to-
but 317
Yes.
shows that at least 10 students must have appeared in the last final examination.
Yes,
Last
ma'am.
So last final examination,
Yes.
3 years not required.
Not
Not
required.
required, my lord.
So only
16, 19 appeared,
My lord.
so 19,
Lordship.
26, 14, 5, 26 enrollment of student it shows as 19.
Lordship.
My lord.
So it is above the criteria
As per that instruction,
as per the instructions. So his services can be provincialized.
My lord.
Lordship. So let the Commissioner Secretary may take a call on that and provincialize the service of the
My
petition.
lord.
Whether I'll give him to consider, I'll pass an order to
Yes, Lordship, that
provincialize.
would be required, Lordship.
To provincialize. Again, on one ground or the other, they will reject it.
No, they will not, if they would reject, they would not furnish this instruction, Lordship. They will consider.
No, my lord, we cannot, my lord, I can rely my learned friend, my lord,
No.
but the officers are, my lord.
No,
very-
let have some faith in the court.
We have to rely on each other.
Yes,
Otherwise,
We have respect to the court, Lordship. We will not do that.
My lord.
okay, heard Mr. A.K. Bhuiya,
No, no, AR.
A.R. Bhuiya, learned senior counsel for the petitioner assisted by S. Loskar, learned learned senior counsel assisted by S. Loskar, learned counsel for the petitioner, and Mr. P.P. Datta, learned standing counsel for
Secondary education.
secondary education. By this application filed under Article 226 of the Constitution in India, the petitioner has prayed for provincializing his services, prayed for prayed for provincialization of his services, of his service dash slash post as a postgraduate teacher
Right.
slash tutor in the subject of mathematics in HAM Girls Senior Secondary School.
My lord.
Full stop. The petitioner has also prayed for quashing of the order dated 6/1/2024, by which the name of the petitioner was dropped from the purview of provincialization of his service. With the further prayer for disposing of his representation dated 8/2/2024. The case of the petitioner is that he was appointed, he was selected and appointed as a postgraduate teacher mathematics in HAM Junior Girls College by the appointment order dated 16/6/2008. And that he has joined in the said post on 17/6/2008. Full stop. The petitioner states he did not receive his salary or order, is it? Those facts are not required.
Not required.
So when is the issue of provincialization started?
My lord can,
He had applied or what?
no, no, my lord, it is the, under the 2017 and 18 Act, the principal of the, my lord, school or college is required to furnish all the particulars before the district scrutiny committee.
Now show
Under-
me that, annexure, anything?
My lord. My lord can find it annexed to status of the scrutiny of particulars of senior secondary schools, my lord, wherein
Annexure 2,
annexed to
Page?
43, my lord.
43, yes.
My lord. And wherein.
And, okay.
Yes, my lord. this is
Scrutiny of
status.
particulars. Here the principal gives.
Yes, my lord, this is the signed by the principal of the college before the district scrutiny committee, my lord. Rukunuddin, my lord.
The case, okay, then after that, the case of the petitioner was considered by the district level scrutiny committee, right?
My
For provincialization of service, of his service. He being the only teacher teaching mathematics in the said junior school, junior college.
My lord. At that time, it was a junior college. Later on, it has been renamed as a senior secondary school.
Junior college, huh? The full stop, the principal of the said school, of the said college, junior college, had forwarded the name of the petitioner along with others for provincialization of their services.
Services.
Then you came for some writ petition or what?
Yes, my lord, then the process could not be finalized due to some challenge made. And my lord, at page 52, order dated 8/4/2021 may kindly be recorded, my lord, by which this honorable court, my lord, directed to take a call and, my lord, to go for the provincialization, my lord, wherein the name of the.
Where paragraph 4?
Paragraph 4, yes, my lord.
The fact that Srimati, but this is a different petitioner.
No, she was the, my lord, principal of the college at that
Acha,
relevant
acha,
period of time, my lord. And my name, my lord, at page 51, my lordship may be pleased to find in the earlier writ petition, Rukunuddin, serial number 13, my lord. Page 51,
51?
my lord.
Yes.
So, my
Where?
lord, this
Oh,
direction,
Rukunuddin, yes.
my lord. Now,
Okay.
my lord, may record from page 4, the operative part of the order, my lord, starts at, my lord.
Acha,
My lord.
However, the said process could not be completed because of some complaint against,
Complaint and some litigation was there, my lord.
some litigation against the petitioner and others,
Others.
due to which the petitioner and others filed a writ petition being WPC number 2522 of 2021.
My lord.
And this court, by order dated 8/4/2021,
Yes, ma'am.
observed and directed, observed that the case of the petitioner and others were considered by both this district level scrutiny committee and state level committee, and the names of the petitioners and others were recommended for provincialization after having the requisite qualifications. And due to the same, the court observed that there is no reason for the education department to hold the process without bringing the same to its logical end. And it was further, full stop. The court further directed that the process for provincialization of the petitioners, which included the present petitioner, be brought to a logical end within a period of 2 months from the date of receipt of the order. Then what happened?
Then, my lord, the process starts at page 54. There is a process undertaken for creation of 21 numbers of posts, my lord. And wherein, my lord, the name of the petitioner's institution at page number 56, serial number 3, my lord. My lord, here it was 19 total for 19 numbers of posts proposal has been sent, my lord.
Full stop. Thereafter, the process for provincializing the services of the petitioner started along with others. And when was it rejected?
My lord, by minutes
Oh.
dated,
And it is stated that other candidates were,
my lord.
other teachers / professors were considered for provincialization of their service, but the petitioner was left out.
My lord.
It is stated by the petitioner that the reason for leaving out the petitioner was due to lack of enrollment.
My lord.
However, the learned counsel appearing for the petitioner submits that there was no lack of enrollment. Why do you say there was no lack of enrollment?
Because, my lord, the minimum requirement was, my lord, 10.
Lack
No.
of requirement as the minimum requirement under the rules,
My lord, 317.
under the Act of 2017, under the Act of Rekha, under the Act, namely Assam Education, within bracket provincialization of services of teachers. and Reorganization of Educational Institution, bracket close, Act of 2017, the minimum required enrollment is 10 students in the last final examination in the particular subject, and the petitioner, to his knowledge,
My lord.
had more enrollment than the required 10 students. This court, to see the enrollment, this court during the proceeding of the instant petition had instructed the learned counsel appearing for secondary education to bring the instruction as to the enrollment part is concerned. And Mr. P.P. Datta, learned counsel for secondary education, places an instruction by which it is seen that initially the enrollment was stated to be 8 in the year 2016 in respect of the subject of mathematics which the petitioner was teaching. However, on a re-verification, the enrollment was found to be 19. For the year 2026.
For the report of 2026.
Full stop, huh?
As per the report of 2026.
Placed an instruction dated 16/5/2026. Instruction from the Director of Secondary Education. From the Director of Secondary Education, Assam. Para. Full stop, para. It is provided under Rule 3, Sub-Rule 7.
Section, my lord.
Oh, section, yes.
My lord.
Section 3, subsection 7. 3(1), subsection 7, no? 3, within subsection 1, clause 7. Provides of the Act, 2017 Act. Of 2017 Act provides that for provincialization of services of one teacher or tutor
Fine.
in each subject, in case of venture high school or venture high madrasa or venture higher secondary school or venture senior secondary school, at least 10 students must have appeared in the last final examination in that particular subject from that institution. In the instant case, it is seen from the instruction placed by the Learned Counsel for Secondary Education that 19 number of students appeared. I cannot say it is in the last examination. For 2026,
Fine. Last means, my lord.
were enrolled. 19 number of students were enrolled for the year 2026.
No, 2016.
Huh?
16.
2016, my lord, it is. The record which is.
Why 2016 required?
That was the crucial date of Act came,
Because
Act
17.
came into 17.
17. that-
16 is
Yes,
the
116.
date. But this is communication of 2026.
26, but Lordship kindly go through that sentence.
Submitted the clarification report. In the earlier report, later
And I can
number
inform you
remark.
that 19 students appeared in AHS final examination 2016.
Where?
That last communication 14/5/2026.
Huh. Enrollment of student in the particular subject shows as 19.
No.
What are
Lordship,
you reading?
last page, Lordship.
The last page. I'm reading 19 students appeared in HS final examination
2016.
2016. Okay. You right, Kikula? Shows that
For the report of higher secondary.
that
education.
19 students appeared in HS final examination of 2016 from HAM Junior Girls College in mathematics subject.
Lordship.
As such, the requirement of having sufficient enrollment is complied with in the instant case. And your representation is also pending.
Yes, my lord, that.
In view of the same, let your representation be disposed of.
Lordship, by the state
My lord,
level.
then they will again some issues there. With a direction, my lord, that with an observation that I made the requirement, my lord. So that those, as my lordship has already judicially come to a conclusion, my lord, with the satisfaction that I made the condition. So my lord can issue a mandamus directing them to, my lord, provincialize, my lord. Because representation is now, it will be another exercise they will carry out, another verification they will carry out. As my lordship has already verified, my lord, from the records. So, my lord,
No, if there are some other grounds,
Yes.
other grounds is not.
if not found ineligible
Yes, yes.
on some other grounds, that I'll say.
That I don't.
Okay, right,
Yeah, Lordship.
okay, so
Lordship, may I?
it is
speak?
as, since the petitioner has met with the requirements
One.
provided for provincialization of his services, it is as such directed that the director of secondary
No,
education,
Lordship, that government will exercise this power.
government,
Let's say it
It
would
should
be.
be by the secretary to the education secretary department. my lord.
it is directed that the secretary,
To
Department of School Education, Government of Assam.
They'll examine. Because, no, Lordship, may I read Lordship that instruction? The proposal was examined by the government, and during the examination, the government took a decision to obtain enrollment data of the subject wise. So, the government
Government
rejected,
data was received and it has said 19.
has already received, so government of secondary decision, secondary education department will take a call on the chief.
And provincialize my service.
Will
Re-examine the issue and the.
will verify the
Yes.
will verify the records as mentioned above, and if found suitable,
Yep.
shall provincialize the services of the petitioner, if however not found ineligible due to some other reason. Right?
It is very risky because they will find out some other reasons. my
No,
lord.
no, they will.
They shall verify the
Right.
documents and shall
So-
provincialize, and on verification of the same, if found eligible, shall provincialize the services of the petitioner. Petition is disposed of.
Because, my lord, from their affidavit, my lord,
Mm.
no other ground they have ever, my lord. Only-
There are no other grounds, like I have not gone into.
And Lordship may mark that
Yes, yes.
instruction.
The instruction, is it required in the order?
Lordship, it will be.
The instruction dated 16/5/2026 mentioned above is kept as a part of the records. Okay. Petition is disposed of. Ikhon ki hoy jam?
Deep level.
Item 23. Director of Higher Education, Elementary Education shall file an affidavit. It is filed? No.
Receive the instruction.
Right. The matter is waiting for go back. Only simple issue Ashik, regarding the pension of unmarried daughter. My lord,
Acha, unmarried daughter.
unmarried daughter, yes,
Hmm.
my lord scheme. That from the date of application or from the date of notification, whichever is later. From that day, the pension is to be released.
So pension to the unmarried daughter, what does the instruction say?
My lord, on the last occasion, we are directed to take, my lord, when my lord application was made, my lord, application was made on 8/10/2019, my lord.
Huh. So whichever is later.
Yes, so from the date of this application, the pension is to be released.
Family pension?
This document is also available in the record on the last occasion. My friend has placed that application lawsuit.
Same document, but this is May 26, 20th May.
My lord, that 19 application, my lord, for family pensions. And thereafter, my lord, in 2021, there is another application for the scheme of the unmarried daughter. As per that application, my lord, we have considered, we have released the pension, my lord, with effect from, my lord.
No, that was, I mean,
26.
mother of the unmarried daughter also died. Or what? Family pension, once a person dies, family pension.
Both parent died, my lord.
So mother also died. Now only the unmarried daughter is claiming.
My lord, that is the dispute, my lord. The pension department released the pension. There is an application, my lord, on 26/5/2025, my lord.
Mm.
On the basis of that application, we released the pension, my lord.
Mm.
Petitioner, my lord, contended that no, we applied in 2019.
Mm.
But 2019, there is an application that applied
For
for the family
family
pension,
benefit.
not for
Mm.
the unmarried daughter,
Mm.
my lord.
That will include mother, wife, everyone.
Whatever is there.
Wife, daughter.
Whatever is there, my lord. That's accordingly, my lord, pension has released, my lord.
Pension has.
The family pension is released subsequent to
she-
2019 or later.
She is not entitled for the family pension. She is entitled for the pension under the scheme of unmarried daughter, my lord.
Mm.
Initially in 2019, where matter was processed, my lord, 19 days submitted application by claiming the family pension.
Mm.
In the meantime, she became major and that family pension part gone.
Mm.
Subsequently, in June 2025, my lord, another application sent to the office of this director for pension for the releasing the under the scheme of unmarried daughter. My lord.
Mm.
Accordingly, my lord, we have released the pension with effect from this June 2025. Now petitioner contended that they know we are applying for 2019 and pension required to is released from the 2019. But the scheme said, my lord,
Mm.
a scheme said, my lord, unmarried daughter scheme said, my lord, from the date of applying of the application, when the petitioner applied first before the authority, on the date that pension will be released. Accordingly, we have done our
So
part.
it cannot be released from 19. 19, it was a case of family pension.
No. My lord, petitioner is no way entitled for family pension. Because she is major. She is entitled only the unmarried, being an unmarried. So the scheme introduced.
Unless one is married.
Yes.
Who was employed? Who for
The-
whose service?
Father was the.
Father. So father was family pension was released after the father retired.
No, because mother expired in long back, that is in 1990.
Before father.
Yes.
Acha.
So there was no question of pension, family pension, lordship in respect of the present petitioner.
Why?
She
She
is
was minor
entitled-
that she was major that time.
At that time, she
Major.
was major.
Doesn't matter. She was not married.
No, that's why,
No.
that is the
My lord,
claim.
Earlier, my lord,
That is the claim of the petitioner that she is entitled for family pension or being a unmarried daughter.
Mm.
And my application is saying so. My friend is trying to say that I file an application seeking family pension.
Oh, in that case, 19 letter will matter.
Yes.
She was not married that time.
No.
my lord,
That no,
my lord,
it's not married.
Till that she is not married.
No.
So when did the father die?
Father died in lordship 1910-2016.
So what happened from 16 to 19?
No, 16 to 19 lordship, the scheme introduced in the year 2018. That is lordship page 50, page 16.
What was in
Nine-
place? What
nine-
was in place before 2018?
No, that is immediately after this notification lordship.
No, before somebody applies under the scheme.
Yes.
Fact remains in 2016 the father died. From 16 to 18 that daughter did not get any pension.
no,
No.
my lord. Because my lord, that time, my lord,
This
unmarried
issue has come lordship only on 9 August 2018.
This is state government, right?
state government,
I think under central government it was allowed.
central government at that time.
But state
Correct.
government, this is the first notification.
Because my father was in the central government.
My lord.
So we were entitled to pension.
Still, my lord, that is. the-
So here, before 2018, the unmarried daughter did not get.
No.
Did not get.
Wife predeceased. Wife
Yes, yes.
predeceased. So no family pension.
No
No
family pension.
No family pension.
No family pension because nobody was there.
She was the only daughter.
She is the only daughter.
No minor son and all.
No, nothing.
So 2018, the scheme came into force.
Yes.
My lord.
And after that, she applied.
And scheme says that from the date of application or from the date of notification, whichever is earlier.
No.
If someone applied earlier to that, then he will be entitled from the date of notification.
Mm.
And if someone applied later on, then he will be eligible for getting unmarried family pension from the date of our application.
Mm.
My application is on lordship 8/10/2019. So my claim is lordship from that date that unmarried daughter family pension should be released from that day.
So it's okay. I don't see any infirmity in it. What?
My lord, as your friend said, that notification said where one, my lord, unmarried daughter, if she is getting the pension under the age of, below the age of 21, my lord, if they are continuing, they will be continuing.
No, no. What under the age of?
At age of 25, they will covered by 2018 notification. Here, my
2000
lord, what happened, my lord?
18 notification does not cover minor. What? I didn't get you.
No, my lord, initially, the daughters are entitled until the age of 21, my lord.
Hmm.
Next, my lord, in 2018 notification said that, no, that has extended up to the marriage of the daughter.
Hmm.
Then, my lord, this petitioner, my lord, initially,
So before 18, there was something in place. You said till the daughter reaches the age of 21,
my lord,
she will get pension.
she will get pension.
After that was extended to 25 years, age,
25, right,
or
25,
till the marriage.
till the marriage.
So
No,
2008.
not till the marriage, on 2025.
So anybody below the age of 25 will get the
Below
pension.
25, otherwise above 20, no, not getting it.
So before 2018, that scheme, something was in place.
Then scheme said, my lord, after 2018, that they will be even above the 25, my lord, they will get the pension if unmarried.
Hmm.
Then scheme come in 2018.
Hmm.
And scheme said, my
You're
lord,
mixing up the years, I think. When was the first scheme? In which year?
2008, no, that is as per the pension rule, my lord.
As per the pension rule,
1969 rule.
a 1969 pension rule, if a daughter
My lord,
is below 21 years and below,
my lord,
she will get the pension.
she will get the pension. And
That's what I
above
was,
20,
you said
she
that
will
they were,
But here in this case, Lordship, on the date of death of my father, I was, Lordship, about 21 years.
Acha, you were above 21 years.
Presently,
So that pension rule you did not get.
Yes.
my lord.
2018, it was increased to
Increased.
25 years.
They have included, my lord. Their entitlement included, my lord.
Hmm.
And this petitioner presently probably she is 49 years old, my lord.
Hmm.
She applied, my lord, initially she had applied, my lord, in 2019, application made before the authority for the pension, my lord.
Hmm.
And authority said that pension she is not entitled. Then, my lord, in 2000,
Why she will be not entitled?
no, that
When was 21
she is
years?
applied for the family pension, my lord.
Huh.
There are two set of pension.
Hmm.
Even unmarried daughter, my lord, that simply that apply that will not, there will be some requirement, my lord.
Hmm.
One, my lord, the unmarried certificate is required, the report from the, that circle officer required, my lord, that some requirement was there, my lord.
Huh.
Then she initially applied for the pension, my lord, in 19. Then 19, that pension, the department said that you will not get pension. Then she said, the direction was made that you are eligible for the unmarried daughter scheme. Accordingly, she have submitted application in 26 May 2025, my lord.
Hmm.
On the basis of the 26 May 2025, my lord, we proceed the pension. And accordingly, that pension PPO has issued, my lord. Now she has get pension. Now petitioner claimed that no, we have made application from 2019, we are entitled for the 2019. But we are not getting that proposal.
Why her request in 2019 was rejected?
No, not rejected, my lord. That is not as per the unmarried daughter scheme, my lord.
But then you said that 2018 scheme came into force.
My lord,
18.
my lord.
18.
So 18 scheme came into force and it says till she gets married,
My lord,
one will get pension.
my lord.
Then why not in 2019 you had applied?
2019, my lord, she applied the 1969 rule, my lord.
Acha, she applied for pension.
Pension, my lord.
Not under the
Not
scheme.
under. My lord, may please go to the one letter, my lord. This letter, my lord, 26/5/2025. On this application, my lord, we have proceed for the pension, my lord.
Acha, in 2019 you had applied for pension.
Pension.
Which of
Can you
course,
see, I have specifically mentioned that I am an unmarried daughter only.
but this is a misnomer.
Maybe Lordship, even
Yes.
I applied for pension, they will not grant me pension. They will be, grant me as per this notification because I have mentioned it. I am the unmarried daughter.
As per scheme.
Scheme. I have
But
mentioned
this
it.
is our latest, this is our
On
25
the basis
application.
of that letter, my lord, we have finalized the pension, my lord.
This is by Director of Pension.
No, this is director of pension, my lord. We have finalized, my lord, director of pension. As per the death letter, my
With
lord.
reference, I am requested to submit unmarried daughter pension proposal in respect of Iman, daughter of Iman. Further action. Okay. So where is her application?
That 25, my lord, June 25, my lord.
This is May 25.
Sorry, May 25, my lord.
So her application had
May
preceded.
25, my lord, the department forwarded, my lord.
So you have applied for pension under the scheme
Under the scheme.
in 2025.
No. My application, Lordship, that application is available in the record. On the last occasion of the education department has placed it.
The application.
Acha, where is your application?
Petition funds.
In the writ petition that I could not allege, subsequently this honorable court directed them to produce that, accordingly they produce it. That
Your
is-
application they have produced.
Yes.
What happened? You don't have.
My lord, that application was not available with the petitioner. That's
Acha,
why-
where is the her application of 2019?
My lord, I have,
Do you have
It is there, madam.
in the records?
it's yes in the report.
Wait, Diokson, tell. Oh, with your bunch. Acha, there's some-
My lord, before that, your lordship may kindly come to page 28.
From 2025, you have been paid pension.
Getting from 26, 20
Only from 19 to 25, you did not get.
yes.
So you want that area
Yes,
pension.
yes, yes. From 27/6/2025,
I did.
27/6/25.
25.
Okay.
And that one reference is there, page 28.
Simply they have not asked for, will not, This is your letter.
Right.
With due respect, I am to inform you that father who was working as a grade 4 employee expired in Iran. My mother expired in Iran. I am only unmarried daughter of my father. I have come as per government rule, get family pension. Acha, so you asked for only family pension
Not,
and that was not allowed, right, Mr. Sakia?
Right, ma'am.
In 2019. But during that time, your scheme was in place.
yes.
Scheme was placed. my
He
lord.
was entitled otherwise.
No, otherwise entitled, therefore, my lord, the scheme said, my lord, that they are entitled from the date of submitting application, my lord. Not prior to
Submitting
that,
application,
my lord,
but
Because, my
then
lord,
this is an
that-
application for family pension,
my lord.
not in so many words that she needs to be under the scheme.
No, my lord, this is not a unique case, my lord. So many cases is there, my lord.
Mm.
Where, my lord, the petitioner applied subsequently to, then they are saying that, no, we have submitted application. Even some cases, my lord, they have taken the receipt from the DO also, my lord, by putting the one rounds in, my lord.
How can they?
Even if,
claim
my
their-
lord, many matter, my lord,
That's
called
not-
the
yeah,
record, my lord.
according to the scheme, from the date of application or whichever is earlier, whatever, your application was not exactly under the scheme. It was for family pension, which was again not allowed.
My lord, no.
Because family pension will be allowed only when you are less than 21 years.
My-
Where is the letter that my application was rejected?
No, no, that application even not a part of the writ petition, my lord. Whatever petitioner is relying, my lord, my lord,
My
that is not a
application
part of the
also
writ petition, my
subject
lord.
in-
Application you did not even annex.
Even not an
My
expert.
lord, that I have made a specific statement in that regard. That's why this honorable court has directed, lordship, specific direction is there to place this application. Accordingly, lordship, this application was.
You are getting pension. You have not, now that you are getting your pension, na? And then you have made a application very late.
My lord, no late, lordship, if you, one reference is there, your lordship will find page 28.
Of
in
your
my writ
petition.
In my writ petition.
Yes, page 28, yes.
That and was process for unmarried daughter, subject to your lordship will see.
This is 22. I have the honor
Yes, this is the
to
22
submit
that-
here with the
after
death
that.
certificate of parents. This is for your favor. This is to
Several
director
times
of
perhaps
pension.
lordship, they have made communication.
Hmm?
Perhaps they have made communication several times, lordship. So this is the reference of 2022.
Show me that scheme where whichever is earlier and all.
Yes, lordship, page 16.
Scheme.
17 is the lordship,
This is Assam.
route 3.
This is the scheme for unmarried daughter.
Unmarried.
Yes,
Assam amendment rules. Which rule?
Assam Services Pension Amendment Rules 2018.
Which?
Original 69 rule, my lord.
Page 17, lordship, note 3.
If at the time of submission of family pension claim, there are no minor children in the family pension shall be paid from the date of filing application by the claimant or from the date of coming into force of this notification, whichever is later. No claim for arrear benefit under this clause shall be entertained. Huh? No claim for arrear benefit.
No.
Huh?
Your lordship,
Otherwise, the family pension shall be paid from the date following the date of death of widow, widower, as the case may be.
The scheme.
This is the relevant provision.
my lord, last page 18.
Hmm.
The provision of notification shall cover all cases of family pension irrespective of the date of death of the government servant pension.
The eligibility of the dependent father, mother, unmarried.
that is a different.
But where is the provision for unmarried daughters?
Yes, Lordship, page 16 provided part,
Huh?
page 16 provided part.
Provided part.
Well,
Provided that family pension shall be allowed
scheme, my lord.
to continue beyond 21 years of age of an unmarried dependent daughter of a government servant,
subject to the.
pensioner, subject to fulfilling of the following conditions. Disabled child, eligible for lifetime. No, there is no disabled child.
My lord, may please to go to Roman 2 also, my lord.
Uh-huh.
In the same point, my lord, Roman 1.
She has to give those non-married certificates.
Yes.
Whatever, my lord, I am saying that even she 19, she said that she applied, my lord. He have to fulfill this criteria also. He have to furnish the undisability child certificate,
That
my
is
lord.
not the issue in this case, Lordship.
No, you have to submit as per the rule.
Without that, Lordship, they
If-
cannot.
My lord, if this petition is not contained with this document, my lord, by merely submitting an application, my lord, he cannot prove, my lord. If
What
it is
petition
there,
is saying,
that should
Lordship?
be a part of this
That-
petition, my lord.
I have submitted, Lordship, I have annexed that document also, Lordship, page 30, your Lordship will see.
No, of course he has to submit the documents, otherwise why will they process? What is the reply to her letter in 2019?
No, 19, my lord, that has not processed, my lord.
That was not processed
That
at
has not
all,
processed, my lord.
because she is not entitled to
Not
family
entitled.
pension, she being more than 21 years.
21 years.
And then where is her 25 letter?
25.
Have you annexed that?
No,
You being the petitioner will not annex petitioner's
so that-
status.
That is during the pendency of this case, Lordship.
During the pendency of this case.
Yes, that released
So you became wiser and then you,
at 8/8/2025. Letter, Lordship. 8/8, that is also in the record, Lordship. I can.
her application is there in the bunch.
No, Lordship, regarding releasing of the amount. Lordship. And application part, that is.
This is by Director of Pension.
Yes. They released the pension from 27/6/25.
As per our instruction, perhaps he has made application on 16/6/2025.
16?
6/2025.
16?
6.
6? Which month?
25.
Which month?
June.
June. 6th of June 25, you made the application.
16.
16th of June, you made the application. And what is this? To the Treasury Officer? Allowing her pension or what?
সেইখনেই পাইছে কাৰণ এই বস্তুখিনি লাগিব নহয় এইখন স্কিমত দিলে নহ'ব নহয় সেইটো দিলেতো গোটেই মানুহবিলাকে তেনেকুৱা সেইখনৰ পৰাই দি দিব
So after she made an application, the pension was allowed.
এলাউডমেণ্ট
She has also deposited the documents and all required under this act.
that as per the format my lord.
Only his grievance is that period,
Yes, only that.
19 to 25.
My lord.
But you had not submitted the application, right?
Oh, that application.
Where is the requirement that he has to submit whichever? That I have not,
That is also not there.
not very clear in this amendment rules.
My lord, that rule, my lord, this is the notification, my lord. This has given the entitlement only the particular scheme. The department has some procedure is there. To procedure itself in the notification, my lord. Therefore, my lord, I am saying, if my lord, my senior phase contention is correct that I am applying under the scheme in 2019, this document should be in the file, my lord. The petitioner have to be bring along with the writ petition. Yes, I filed, this is the application I filed, and this is the certificate, unmade certificate, and this is the other disability affidavit, my lord. All document is there, I submit it. But this is another case of the petitioner, my lord. Petitioner has even not submitting, enclosing this is application also.
Application that was not available.
No, whatever available it is.
The department has placed it.
Where is the pleadings that 2019 you had submitted?
My lord,
That is also not there. No, you have said 1/3/2019 of the Accountant General.
my lord, that document was not available with the petitioner. That's why, Lordship, this honorable court given a specific direction to the department. Accordingly, department placed it. Lordship, kindly use the order of this honorable court dated 27/10/25. 27/10/25.
7/10/25.
Lordship.
Yes.
That is the date of the application.
From the date of our application, that is 8/10/2019.
That is the.
That is, of course, your family pension under the pension rules, unamended.
No, Lordship, I have not mentioned under family pension rules. Lordship, kindly see my application. What does my application says? Now I am the only unmarried daughter of my father left, so I have come to know that as per government rule, I am eligible for to get family pension.
And
As per
this,
government.
you said it's a
Only the
scheme,
what
but it's
unmarried-
not a scheme. It is amended rules of 1969 only.
Yes.
You said under the scheme she is entitled.
No, this is my lord notification. Initially 1969 rule, my lord, does not say above 21, my lord. Subsequently, they are included by this notification by inserting this particular two conditions.
So not scheme, it is under the rules only.
Another rule.
My lord.
Another rule.
So she had applied in 2019 to pay pension under the rules.
Yes.
And by that time, 2018 amendment rules had come into force.
Before that.
Before that,
The rule has come into force.
right?
After that, the petitioner, after knowing that, he has applied.
Why did you then reapply in 2025? Because you were not getting.
So far application is concerned, I have not seen. I don't know whether subsequently any application was submitted because
Then how come it was allowed to you post 25?
No, that is my friend can answer on that. Under what because they.
It
received
is
the-
your pension.
They received the proposal from the director. After that, Lordship, they have released the.
So you had given only one application in 2019.
My Lordship, I have.
He had given only one application. That was processed and 25 it is allowed. What?
My lord, certainly not, my lord. In our instruction, my lord, this is very clear, my lord.
They have-
And I have shown the letter, forwarding letter also very clear, my lord.
Let me see your pleadings. Okay, you do one thing. You apply before the pension authorities and you get this amount. Did you file representation
No.
that I was not paid for the previous years? Did you apply?
Proposal, Lordship, is to come from Lordship department, the education department. Otherwise, Lordship, they will not process. Because.
No, did you file your representation that I did not get the pension for so many years?
No.
Why? You file it instead of coming directly to High Court. You should have filed it.
Oh, their file was this, the other benefit release Lordship.
Were given. GPF and all were given to you.
Yes, other benefit.
Huh.
We have no clue.
So only pension. You should have filed. You file a representation before the secondary education. Right.
Lordship.
And you say that for those 2 years I have not been given pension. My application was there in 2019. Well, it will do, Mr. Saikia. Let him file a representation.
My lord, that can be done.
You are paying pension after 25.
My lord.
Right. So from 19 to 25, let him make an application before the authorities. Right. Heard Mr. M. Khan, learned counsel for the petitioner, and Mr. P. Saikia, learned government advocate appearing for the pension department. Miss S. Chutia, learned standing counsel for secondary education, elementary, and Miss for LCHE. Accountant General. Miss so for Accountant General. By this application, the petitioner has prayed for releasing her pension, releasing her area family pension with effect from. You are asking here from 2016 when your father died.
That was the claim, but she will not entitled for that process.
From 2000 from with effect from 2010-2016. With the further prayer to release the GPF amount as admissible in law. The case of the petitioner is that her father who was a grade 4 employee in Kalangpur ME school, died on 19/10/2016. And that her mother had predeceased her father, that is on 5/6/1990. The petitioner states that she, being the only daughter, applied for the next of kin certificate, and the same was issued in her favor on 20/12/2016. And that thereafter she applied for family pension and other retirement benefits with supporting documents before the DEEO, Sonitpur. Full stop. She further states that on coming into force, the notification dated 17/8/2022.
No, Lordship, you have to get.
No, na?
9/8/2018 notification.
Oh, coming into force, the government notification dated 9th of August 2018, right? 2018. The petitioner has made an application on 8/10/2019 for family pension.
Being unmarried daughter.
Huh? Being an unmarried daughter. Full stop. She had also made application for release of the GPF amount, right?
Lordship.
But the same could not be adhered to for lack of necessary authorization. But this is released later, which was, however, subsequently released, as stated by the petitioner. The petitioner only claims her pension in the instant petition. Further, the petitioner states that she has been getting pension after 27/6/2025.
From 27.
From 27/6/2025. But from the period of 8/10/2019 to 27/6/2025, 8/10/2019, the date when she made the application, to 27/6/2025, she did not get any pension. And as such, she has prayed for the amount as her arrear pension. Mr. Saikia, learned counsel for the respondents, states that that at the time when her father died, when the father of the petitioner died, the petitioner was not eligible for family pension since she was more than 21 years of age. And that later, by amendment in 2018, the said age was increased till one gets married. As such, he submits that after 2018, the petitioner is entitled for, but the petitioner had made an application for family pension in 8/10/2019, which could not be considered due to the fact what, but that should have been considered if at all she has made an application, which shows that she had made.
No, there are other GPF, so many references there, my lord. I just verified in the petition, my lord. Some she applied for the GPF also, my lord, some for other purpose also. Therefore, my lord, petitioner can only say that, yes, I have applied the, as per the provision by complying the clause 1 and 2 of the, that's notification, my lord. That will
Wherein,
be considered,
wherein?
my lord. We
The-
have received as per the, my lord, format, my lord, on 26/5/2025, my lord,
26/5/25.
2025, my lord. That proposal we have
আচ্ছা,
finalized.
কি করলো এটা? Family pension on 8/10/2019, but without the necessary details that she would be entitled under the 2018 amendment
19, I'm
rules.
not acknowledging on 19. I'm acknowledging on only 26/5.
No, but 2019 letter you could not process because she had not.
I'm not, that is department, man. That, my lord, 19 application we are not processing. We get application on 25, 20.
Why was that 19 application not processed?
19 application, my lord, that is, my lord, because.
So
report
what
have
is
to
the
come
answer?
from the department, man.
Secondary education, what is your answer?
This is the answer of the secretary department. They have placed, that is in the report.
Where?
19 months before
Mm.
the director of pension.
আৰু শুনা হেৰি কৈ দিয়া এছ চুতীয়া ন আচ্ছা
That is the instruction.
this is the report.
Yes, that was placed before this honorable court.
Natasha, কি ক'লে এইটো? এইটো back কৰি দিছে?
Here
Back
they,
কৰি দিছে?
they placed.
Wait,
the-
wait. And according the DO has forwarded the family member to the director of pension. They have the right of finalize the family pension. So 19 letter took so long. Here, Mr. Saikia,
My lord.
it is said that I'll read the entire part. With reference to the subject cited in connection with so-and-so, I'd like to inform you that as per report received from DEEO Sunitpur, via its letter under reference, petitioner had applied for family pension on 8/20/2019, which was received by DEEO. And accordingly, DEEO has forwarded the family pension proposal to the Director of Pension via this letter dated 29/11/2019. Thereafter, the Director of Pension finalized the family pension in 2025.
No,
But the consideration of granting a family pension is under this. So it took 6 years.
no, my lord, that is the pension, my lord.
In this.
No.
That, my lord,
DEEO had sent the letter to the Director of Pension in 29/11/2019.
no, my lord, that is their instruction, my lord. My instruction is that, my lord, that letter we
This
have,
is by Director of Elementary Education to Standing Council.
my lord. That I cannot say on that instruction, my lord, but we have received this letter only, my lord, as per my instruction, my lord.
Which letter it is in the bunch?
My lord. Starts from 10/12/2025, my lord, submitted by the Director of Pension, my lord.
Which letter dated? This is in the bunch, Mr. Chutia?
26/5/2025.
What letter? Give me.
এইখন চাওকচোন, ডাইৰেক্টৰ পেঞ্চনৰ ওপৰত এখন লেটাৰ আছে ডাঙৰ।
No, now it's 5 years. So, কি কৈ আছে? কি ক'লো?
এইখন দিয়কচোন, এখন ওপৰখন আছে। সেইখন
No, but without nalag. 8/10/2019. 8/10/2019, which was stated to have been received by the, what is OODEO? Officer in charge, no, Office of the DEEO Sunitpur. Full stop. What do you want to show it from here? This is 25.
My lord, we have
The honor to submit
received that
herewith
proposal only, my lord.
the unmarried daughter pension proposal in respect of Miss Susila Gore. In writ petition so and so. This is the writ petition or what?
My lord, that we
Yes,
received that-
this is the writ petition they are talking. But this is also a letter. This is by email. This is not a manufactured one.
No, I have no idea on that, my lord. My
Okay.
particular instruction is there, my-
So things are not very clear. Then, okay, so and so. Full stop. মই ইয়াৰহে কথা কৈ আছিলো ন However, Mr. Saikia submits that the case of the petitioner was processed in the year 2025 and finally her pension was paid from 27/6/2025. For full stop. For Capera. Where you have shown the rules that now it is being made till marriage. Where is that?
Yes, page 16.
Yes, why is 16?
Page 16 provided.
Family pension shall be allowed to continue. Okay. It is noticed that by amendment to the Assam Services Pension Rules in 2018, Rule 143 was amended and by adding a proviso in subrule 2 in clause C, it was provided that family pension shall be allowed to continue beyond 21 years of age to an unmarried daughter of a government servant, subject to fulfillment of certain conditions. 1, there should be no disabled child eligible for lifetime family pension. Why is this condition provided?
My lord, because my lord, if disabled person is there, my lord, he will get the benefit, my lord.
He will get
First,
the-
he will
Okay.
consider. My
Second, and the second,
lord.
a
Second,
certificate of non-marriage and non-employment should be submitted by the unmarried daughter for every year. For every year. In the instant case, it is seen that the petitioner is the unmarried daughter of the employee who had died in the year 2016 and he was able to establish the same and had submitted the required certificates and the pension was allowed to her after from 27/6/2025. But it is seen that the petitioner was not allowed her pension from 2019. That is the day when she had made the application to 27/6/2025. As such, the petitioner is directed to make a representation before the DEEO.
No, Director of Elementary Education.
DEEO, Director of Elementary Education,
correct, my lord. From
District Elementary Education Officer. What? Director of Elementary Education. Director of Elementary Education to verify the said concept, to verify. Huh?
From the DEO, what did the director?
Acha, before the District Elementary Education Officer, Director Nidiva. Before the District Elementary Education Officer, officer ventilating her grievance. No, District Elementary Education Officer for verification of her application submitted on 8/10/2019 for family pension, more so due to the fact that the amendment had come into force by then. And her entitlement for pension from 8/10/2019 to 27/6/2025.
You may forward it to the Director of Elementary.
That DEO will do.
No, that person of the director will require, otherwise the matter will get.
He will first verify, then he will send.
Subsequently,
Who, after verification of the documents, would submit the proposal before the Director of Secondary Education. Director elementary,
Elementary,
elementary education.
who shall take
The said exercise to be done within a period of 2 months from the date of receipt of this order. The petitioner is directed to submit submit a representation along with the copy of this order at the earliest. Petition is disposed of.
Once sentence, the director of elementary education will take necessary action after that may be addressed.
First of all,
That is the natural corollary. It will do. Yes, it's now past 5. It's okay, Mr. Chaudhary will do it.
Part third matter, I'm praying for taking about next week, Lordship.
Part matter,
Part third.
you should have pointed out which one.
Item 37, Lordship.
37.
Yes, Lordship. This is best 3 matter. Because earlier heard, Lordship.
37.
37.
Part is in here.
Is a part third, Lordship.
Part matter, it should have been shown.
Last occasion, it was solved, Lordship. It was left over.
No, lage batte.
On Tuesday, Lordship.
Huh?
On Tuesday.
Okay.
26th.
As prayed for by learned counsel for petitioner, list this matter on 26th of May.
Lordship.
My lord, I am praying for item number 31, my lord. It may be come up
31.
31, my lord.
Acha, his is 31.
31, my lord. It is for instatement of the service, my lord. And his
As prayed for by the learned counsel for petitioner, list this matter on
26, my lord.
26. There will be so many matters. Okay, 29th. Yes, Mr. Bora.
39 will contain matter fixed today, madam. Item page of fix of 27, madam.
As prayed for by the learned counsel, release this matter on 27th.
Madam.
27th? 27th is a working day, right? 27th.
Now working.
27th.
My lord, may I pray, my lord? I am very sorry, my lord, at this moment I am praying, my lord, item 24 and 25. It has come up by order, my lord, some urgency is there. Can it be on Thursday, my lord, coming Thursday, my lord?
Coming Thursday will be a big holiday.
25th,
Eid holiday.
25th, my lord. Oh, sorry, my lord,
Thursday, Wednesday,
it's 28th.
27th.
Then it is on 27, my lord.
27th.
My lord.
Which matter you said?
24 and 25, my lord.
24, 25, as prayed for by the learned counsel for parties.
My lord.
Release this 24 and 25 are two separate matters.
Separate matters, my lord.
24 may be taken up after 2 weeks losses, otherwise from
No, ma.
massive losses.
Oh, sir. Okay. As prayed for by the learned counsels for all the parties, list this matter on 8th of June.
My lord,
Okay.
and my lord.
25, you right? As prayed
20.
for by learned counsel, list this matter on.
20.
Your name is not shown, Mr. Bhuya.
My lord, I don't know why it has not come.
Okay, list this matter on 27th.
My lord.
Similar pairing item was.
44.
Yeah, review please.
Okay. As prayed for by the learned counsel, list this matter on
Wednesday, madam, 27.
27th. Okay. Yes, Mr. Sharma?
27 on 8th of June, Lord.
27.
27, 8th of June, Lord.
27 to 8th of June koi diya.
Right.
Huh? Yes. You can tell Mr. Chaudhary. Okay?
May I please, Lordship?
Yes,
Lordship,
yes.
in item number 14 and Lordship, interim order is dear Lordship. It may
Oh,
continue.
impugn order may be extended. Shall be till the next returnable date. Item
49.
49 or koi diba, huh?
This person I want to take that.
Huh? Yes. Yeah, this one.
Two documents, Lordship, I have.
So it will be in the file. Did you pass? Huh?
Item 30, my lord, by order, my lord, next week, any day.
Okay. Item 30 on 27th.
Lordship,
Okay.
I keep. That's